Good morning and welcome to the Law News Network. Today we are going to be hearing what I believe is the final testimony in the case of Aaron Hernandez, charged with first-degree murder, 2 counts of first-degree murder, as well as 6 other counts in Boston, Massachusetts, from a shooting in July of 2012. I'll be your host for the next few hours. My name is Beth Karras. We're going to be talking about Aaron Hernandez, which should be starting soon, live in the courtroom. The court was dark yesterday for the jurors because the defense, which began their case late Monday afternoon, or Monday. They began their case Monday after the prosecution rested. They didn't have any more witnesses available on Tuesday, and so they're resuming today on Wednesday. And they expect to call up to 3 witnesses. One is a forensic witness, so probably the testimony will take about half a day. But in addition to Aaron Hernandez, which is wrapping up closing arguments, could be tomorrow, Thursday, we're going to start following another trial at the LawNewz Network out of Arizona. Now that case is 3 hours earlier, so it will be starting late morning, 11:30, even noon Eastern time, and go into the evening for the next few weeks. Opening statements in the murder trial of Stephen Jones are expected later today. They are wrapping up jury selection this morning, jury selection to resume in a couple of hours and to be wrapped up. Now, Stephen Jones is charged with murder, but he says he shot in self-defense. He was in northern Arizona, in Flagstaff, Arizona. The case involves Northern Arizona University students, one of whom was killed and others who were shot at. So this ought to be an interesting case. You know, whenever self-defense is an issue, that is, the manner of death is an issue, it always is interesting, at least for me, because you have to decide whether or not the conduct is indeed criminal. The prosecutors made a judgment call that a crime was committed, that the self-defense claim isn't meritorious, at least in the eyes of law enforcement, and so they hope to convince 12 jurors that this was murder and not self-defense. Other cases where manner of death is an issue are cases where a person kill himself and you don't know if it's a suicide or an accident. That's not criminal unless somebody assisted in the suicide, and then it could be criminal. But manner of death can be, you know, the center of a case, and that's what is happening in the Arizona case to begin later today. Now back to Aaron Hernandez. Yesterday, the lawyers were busy, even though the jury wasn't there, with a charge conference. And the defense moved to have one of the 8 counts Hernandez is facing dropped, the witness intimidation count, which occurred months after the murder, where the state's star witness, Alexander Bradley, says he was shot in the head and left for dead by his good friend, Aaron Hernandez, in order to silence him. The judge is taking that under advisement. Before court begins, I want to have a chat with my friend, defense attorney in Boston, Peter Ellikin, who is joining us via Skype. Good morning, Peter.
Good morning. How are you?
Great. And what do you think about this motion the defense has filed? I guess I'm not surprised that they want to have the witness intimidation charge thrown out. That's the February 2013 shooting of Bradley in Florida. Do you think they have a chance?
I suspect there's something of a decent argument here, but I suspect they're not going to win this. Obviously, he said the victim on that, his friend Bradley, says he was shot in order to silence him. That would definitely be a case of witness intimidation. I think the defense is saying, look, we don't really know. Bradley could have been shot for a variety of reasons by other people, etc. So we really can't nail that down. I think that a judge would probably say, well, let's leave that to the jury then. If it's really a question of fact, we're really debating. Hernandez's lawyers are saying, look, this was not true. He was not shot by Hernandez, and it had nothing to do with this case in Boston. You really have to leave that to I think you'd have to leave that to the jury. It's really a question of fact.
You know, the defense started to present their witnesses on Monday. They'll wrap up today. Defense attorneys, never have to put on a case. So when they do, it's interesting, but they should never be held to sort of the same standard as a prosecutor where, I can't tell you how many times I have heard lay people who are watching trials say, that's it? That's all the defense has? And it's like, wait a second, they don't have to put anything on. They're presenting their case through cross-examination, right?
Absolutely, and that's why the judge is good at giving those instructions. Like, we don't have to prove. We're defense. We can just sit back, relax, and the other person, the burden is on the prosecution to prove the case. Defense really has to do nothing. But you're right. Lay people who aren't lawyers in the legal world, they sometimes take that the wrong way. Again and again, they'll say, well, why isn't the defendant testifying? If he's innocent, why? I would talk. I would. And it's most times, it's almost rare that you put the defendant on the stand. You really usually have nothing to gain and everything to lose by that. But the jury has to be reminded again and again. And I think this judge did do some reminders, letting them know that the defendant really is under no obligation to testify, and it really should not be held against them and not be prejudiced against the defendant for not testifying. Although the average person on the street still has a little trouble wrapping their head around that concept.
You know, there was a witness recall. The street sweeper was recalled by the defense on Monday, Warren McMasters, and there was a Boston police officer before him who testified to what he saw on the street, and the street sweeper there. Also, a couple other witnesses were called, but I thought that the first witness called by the defense, Antoine Salvador, was really quite interesting, what he had to say, the content of his testimony, because it goes right to the motive in this case. Because really, I mean, the issue in this case is who fired the shots. They pretty much agree on a lot of stuff leading up to the shooting. It was the motive for the shooting, though, right? The defense says it was the driver, Alexander Bradley, the one who says he was shot by Hernandez months later, or was it Hernandez shooting over the driver's seat from the passenger seat into the BMW where 5 men were at a stop light next to them? Antoine Salvador, are you familiar with his testimony, Peter?
Yes, I am.
Okay. I thought what he had to say was pretty compelling. Can you describe it?
Well, yeah, from what I understand, they say that Hernandez was really in that club a matter of minutes, really, something like 9 minutes. I forget exactly. They haven't quite, I don't know if it's definitely nailed down, but for just a short period of time. And this witness comes forward and says, you know, I ran into him. I wanted to get his autograph. He wouldn't give me his autograph. I then told him it was my birthday, so he gave me the autograph. He was nice. He was pleasant. We talked for like virtually the whole time. They said, did you see any drink splashed on him? He said, no. Did you see any wetness on his clothing? No. And he pretty much accounts for all the time that Hernandez was in the club. So he becomes a very, very important witness, because if the whole motive was that somebody splashed, accidentally, splashed a drink on Hernandez and was kind of rude about it too, and Hernandez is in a, surly mood or whatever about that, so he goes and kills him. Here's somebody who can say, basically, I was with him almost the whole time, and he was pleasant, he was happy, no drink was splashed on him. And this becomes even more important because we don't really have any evidence other than the one chief witness of the prosecution, Bradley, telling the story about having the drink knocked onto him. Other than that, it's not on any videos. There's no other witnesses came forward and said they saw it. So I agree that this particular witness that the defense presented as their first witness, if he's to be believed, is an extremely strong witness for the defense and really could help, tip things in the defense's favor.
Right. He takes on Bradley's testimony directly, and the jury is left to wonder really what motivated Hernandez if indeed Salvador is telling the truth. I mean, why would he do it? Well, we'll see. Now, we're still waiting for court to begin. The defense has, they say, 3 more witnesses in the Hernandez case. They usually begin sometime, between 9, and it's 9:09 now on the East Coast, 9:30. So I assume that they will be starting soon. But let's listen to a little bit of the testimony from Monday. Yesterday was just the jury instruction. So let's go to Monday to AH4, Anthony. This is Gargas. He was the manager of the VIP area at Tootsie's, which is where Hernandez and Bradley had been in February 2013. This is when Bradley says he was shot by Hernandez. This has to do with the witness intimidation charge that the defense is asking the judge to throw out, and the judge has taken under advisement. So let's listen to Gargas.
So you have 2 levels on it. Downstairs, pretty much the main floor, main stage, everything like that. And then upstairs is a little more quiet, not so many people. It's not as crazy. You know, there's big, giant party rooms in the back, you know, if you want to have, you know, more privacy and everything like that for you and your group. And that's pretty much what the next level is about.
Okay. And was Aaron Hernandez a frequent customer there?
Frequent. Whenever they came in town, he'd come in, yes.
Okay. And you see Aaron here today?
Yes, I do.
Okay. Is he the gentleman wearing the purple shirt?
Yes, sir.
Okay. Now, how many times would you say you've seen, prior to February, how many times had you seen Aaron in Tootsie's?
3 times.
Okay. And each time did he come in with players or other friends? How?
Sometimes players, sometimes other friends, sometimes a mixture of both.
Was it part of your job as the manager to interact with celebrities and athletes when they come in?
Yes.
Okay. And you recognize some of the other players that would come in with him?
Yes.
Okay. I won't name names, so. But, so how was Aaron like with the general public there that was in the club?
With the general public, doing what I did for so long, I seen the worst of the worst, and you know, I'm not going to elaborate on that. But Aaron was always good. He came in, he was polite, well-spoken. One of the toughest things in the club, especially working in the club, are dealing with drunk people. They, you know, get in your face close. You know, they're spitting and talking and everything like that. And being how Mr. Hernandez was, very recognizable, and he always handled it well.
Do you recall any instances?
Yeah, I recall one instance, a gentleman in a Patriots jersey coming up, talking to him, loud, obnoxious, everything like that, you know, like he's his best friend, knows him forever, everything, and was on him for probably a good 20 minutes, half hour, and I walked over to Mr. Hernandez and asked him if he'd want me to separate him from him, and Mr. Hernandez was like, no, he's fine, took a picture of him, signed an autograph, and that was it. So, always handled himself well compared to a lot of athletes out there.
Would you describe Aaron's behavior with fans as standoffish?
No, not in the least.
No, overruled. Did Aaron, when he walked in the bar, ever have like an angry face that you ever observed?
No.
Okay. Was he always had a tough guy attitude from what you could see?
No, not in the least.
And so, Peter, we just heard that this witness from Florida say that Aaron Hernandez was, you know, really a polite and pleasant guy, in contrast to a lot of young people who would hang out at clubs. So this is a very different demeanor from what has been portrayed of Aaron Hernandez, not just at this trial by the prosecution, but in, you know, the former trial, and from what we, the public, know about him with all of these murder charges. Now he's convicted of one, he's facing these 2. I mean, he's been portrayed as kind of a thug, but these folks are saying that he's kind of a nice guy.
Yeah, that is. Members of the public have been given a vision of Hernandez as well. He sounds like he sounds like he's the NFL's first serial killer. He kills this friend here, he shoots these guys here merely for spilling the drink on him, and then he shoots his other friend Bradley down in Florida. The guy, he just shoots and shoots and shoots people. That it really is, as I said, like the NFL's first serial killer. So he's got such. You would have the impression that this is a sullen, surly guy, quick to anger, ill-tempered, and I guess some more people who come forward and say that he's a very nice, pleasant guy. Even the witness, even the defense witness here, who mentioned that he gave him his autograph here and at the Boston club on the. He just keeps coming off as this friendly guy that the defense is trying to portray. I guess it kind of counters that reputation that certainly the public has, and certainly what the prosecution's trying to bring. I mean, but who knows? People can also be kind of two-faced, schizophrenic. They can be kind of smiley and friendly, and then they can have a dark side too. It's probably helpful that they're showing this nice, friendly side to him. It's to present your client in the defendant in the best possible light. I don't know if it absolutely carries the day, but it's smart what the defense is doing here.
Well, his demeanor is most relevant in this case on the days in question. Certainly in those minutes before the shooting in Boston and also the night of the shooting of Bradley. And if he's just sort of amiable, pleasant, getting along with everyone, it doesn't seem to be, the mind of a killer. But looking at the big picture, I mean, serial killers and mobsters who are, hitmen can be extremely charismatic, which is how they, get their work done. In any event, so that he's a nice guy in general. Yeah, he can still be a serial killer, but his demeanor on those days in question, close in time to the shootings he's charged with, yeah, that is something the jury I can take into consideration. So let's keep looking at some other testimony. One of the earlier witnesses also called on Monday by the defense was a Boston police investigator who looked at the video from the Cure Lounge, the club. Do you know that club, by the way?
Yeah, not that I've ever been in it, but it's actually in a very sort of nice, the theater district in Boston, right off near where Back Bay and the Public Garden is and all the tourist areas. It's not some remote neighborhood. It's in a very, pleasant, well-traveled, peopled neighborhood. And I do know the location there. I've never been inside. I'm not that cool, but it's in a rather decent neighborhood.
Well, what about the intersection where the shooting happened? Are you familiar with that?
Yes, I am. And again, it's starting to get a little bit more residential, kind of at the south end. It's only seems like several streets away. It seems very near there. It's already starting to push. I always tell people think of Boston as a city, but it's kind of a big town, really. You can almost walk from one end to the other in about 25 minutes, and so you're almost starting to get into a kind of a residential area. A little bit, particularly that time of night, I could see it being not a lot of traffic at that time of morning and a little bit more remote, and yet you're only several streets away.
So what were the streets? It was Tremont and what?
I forget the cross street of
Okay.
it. I do remember I even drove by it, and I just the name slips by, but it's as I said, several streets away.
Okay, so let's go to the testimony of Robert Satana. This is from Monday. He was a Boston police investigator. This is AH1 from Monday, Anthony.
Mr. Stano, good morning.
Good morning.
Even accounting for the 56-second difference in the Cure videos, even accounting for that, did your hundreds of hours of review of videos show anybody spilling a drink on Aaron Hernandez?
No, sir.
Did your hundreds of hours of review of the video show anybody bumping into Aaron Hernandez?
No, sir.
And given your hundreds and hundreds of hours of review of these videos and some time difference between Tufts and Cure, did any of your review show Mr. Hernandez in the passenger seat of a Toyota 4Runner at the corner of Harold and Shawmut at about 2:30 a.m.?
I did not see that, no, sir.
2:33 a.m.?
No, sir.
2:27 a.m.?
I don't believe so, sir. No.
So I'm trying to account for
Yep.
3 minutes on either side.
There's
The
no
court
video
on
camera, so I couldn't see it.
And Mr. Hagan showed you a. Did Mr. Hagan move the mouse?
I have the mouse here, sorry.
No. Okay. Now that is one way to slow down my cross, right? Mr. Hagan. Mr. Hagan showed you a video.
The court is now live in Boston in Aaron Hernandez, which could be the final day of testimony in this trial that began on March 1st. So let's go live into the courtroom.
Areas which the courts have consistently struck down and overturned cases in which perjured testimony has been utilized. The grounds for the perjured testimony is the knowing use by the Commonwealth of allowing Mr. Bradley to testify that he knew who the shooter was with respect to the Florida incident on February 13th of 2013. Specifically, as found in Exhibit 311, there is a text message from Mr. Bradley, number 268. Exhibit 311 has been introduced as evidence, and that text message was sent by Mr. Bradley to his attorney, Mr. Pickering. And that text message said, "Now you sure once I withdraw this lawsuit, that won't be held on perjury after I tell the court the truth about me not recalling anything about who shot me." Now, if you remember, I believe it was on redirect, the Commonwealth attempted to explain away through Mr. Bradley that this involved a prior court grand jury hearing. Well, the fact of the matter is that whether or not this testimony was referencing a prior grand jury, it was an admission.
Prior grand jury because he hadn't testified in the grand jury yet.
No, but he was saying that he was about to testify in the grand jury.
Wasn't that October?
No, it was within a matter of weeks, the Bristol County grand jury.
I see.
Okay, and I think if you look at the text message, this was at 8:33:38. The next text message at 8:40 to his lawyer talks specifically about, and is an additional matter with respect to my grand jury testimony. And it was in this context of grand jury testimony that Mr. Bradley was asking the question of his lawyer if he told the truth to the grand jury about not recalling anything about who shot me. Now, that text message was known to the Commonwealth. It was, in fact, provided as discovery to the defense. And as this court has reminded the defense counsel numerous times, that to the extent that disclosure Bradley, contrary to his admission to his own counsel that Mr. Hernandez shot him. Now, you know, there's an old expression, if it walks like a duck, and it looks like a duck, and it quacks like a duck, it's a duck. And Mr. Bradley, this is clearly perjured testimony before this court. It is one of the most disfavored activity that can occur in a court. Specifically, the United States Supreme Court has consistently held that knowing use of perjured testimony procedure violates the fundamental right to due process guaranteed by the United States Constitution. And it went on, the court has gone on to say in United States versus Bagley, stating that perjured testimony is considered material unless failure to disclose it would be harmless beyond a reasonable doubt. There is no question that this isn't harmless lack of disclosure. We're not even alleging disclosure. The Commonwealth knew about it.
Well, there was no lack of disclosure. The
I
text,
agree.
I take it, was produced in discovery, known to all, and part of the 479 texts that were introduced from the extraction report. So it's not an issue of concealing perjured testimony. It's an issue, I take it, of whether or not, in fact, there is perjured testimony. Taking the text as evidence, as evidencing that what Mr. Bradley said here was in fact false. The Commonwealth knowingly made use of that testimony in advancing its case. Correct?
Yes.
Okay.
I wasn't suggesting. All I was suggesting is that the courts, in retrospect, after trials, in cases where they have overturned convictions for perjury. In those cases alone, it's even just the, not even just, the failure to disclose. In this case, we have disclosure, yet, and they knew as well, yet they proceeded to use perjured testimony. And I don't see, let me continue. The courts have also said, the United States v.
So
the Massachusetts
I don't think
asserting that convictions obtained by the knowing use of perjury are fundamentally unfair and must be set aside if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury. In Pyle versus Kansas, 1942, declaring that the prosecution's knowing use of perjured testimony would deprive the defendant of due process. There's court after court after court in the U.S. Supreme Court and also the Massachusetts Supreme Court.
I don't think I need a primer on the law. Let's accept the proposition that the knowing use of perjured testimony is improper and can cause reversal or warrant dismissal.
Yes, sir.
Let's accept that as the state of the law.
Yes, sir. That's the state of the law.
Okay, so what more do you want to say?
What more that I want to say is that to suggest that the Commonwealth, with a communication from Mr. Bradley to his lawyer, telling the lawyer he was concerned about perjury when he tells the truth that he does not know who shot him, and then the Commonwealth goes on to present a case and allow Mr. Bradley to testify that Mr. Hernandez shot him, is clearly use of perjured testimony and can't be viewed in any other light.
Okay.
Thank you.
Commonwealth?
Sure, very briefly, the statement is not evidence of perjured testimony. The court is well aware that instead it's an alleged prior inconsistent statement that was used in cross-examination, and I expect will be previously argued in closing argument. The statement has to be taken in the context to which Mr. Bradley explained it on redirect. Right after that text is a text about his impending grand jury testimony. Mr. Bradley indicated that he was concerned about settlement negotiations that were ongoing, whether or not if he withdrew the lawsuit, went into the grand jury, and in essence perjured himself by saying he didn't know who shot him, whether or not that would affect his civil lawsuit, and whether or not he could be charged with perjury for the inconsistent statement. So again, it has to be taken in its context. It is not evidence of perjured testimony, and the motion should be denied.
All right. I recall the back and forth on direct cross-examination and redirect as to this text message and its meaning. Mr. Bradley gave an explanation for what he thought for what he intended to mean in sending that communication, as just referenced by the Commonwealth. The motion assumes that, in fact, Bradley's testimony here as to knowing who shot him was false and perjured. And I don't make that assumption. Ultimately, that is for the jury to determine. So after hearing this motion is denied. Counsel, before we bring our jurors down, the issue was raised on Monday regarding the testimony or anticipated testimony of, is it Dr. Jamie Downs? Dr. Downs, having provided a report of the opinions he had formed in this case, and then over the weekend amending that report and expanding his report. It was also disclosed that Dr. Downs had in fact been present during the testimony of Dr. Lindstrom, notwithstanding the fact that a sequestration order was in place. And as I've seen the supplemental report of Dr. Downs, it also reflects that he's viewed the video testimony of other witnesses.
Only as to the actual shooting, not the whole testimony. Only as to the nature of the shooting.
Well, he doesn't say what it was, other than He viewed the direct testimony of Mr. Bradley. He reviewed the video testimony of Detective McIsaac. He reviewed the video testimony of, is it Michael Haig, the reconstructionist, and was present throughout the testimony of Dr. Lindstrom. The Commonwealth raised a concern about that and asked at a minimum that it be permitted to meet with Dr. Downs. And you folks, I think, were working that out. Mr. Lee, did you have an opportunity to meet with Dr. Downs?
I did. We were originally scheduled to meet yesterday evening, but his flight was delayed until close to 11 p.m., so I did meet with him this morning for roughly 35, 40 minutes.
All right. And do you have any request to the court now?
Well, Your Honor, from having read the report, I think the court probably sees that it's long on observation and relatively short on opinion testimony. I will challenge, as it comes up, certain aspects of the numbered paragraphs that Dr. Downs, if those are elicited. But one of the opinions that he gave in his original report has been, I guess, punched up in a way. It's not the same verbiage that he used in his original opinion, but I can cross-examine him regarding that. But there are a number of numbered paragraphs that I think are inadmissible and inappropriate for the jury's consumption, but I can make those objections when necessary.
So you don't want me to do anything at this stage?
Not at this stage, but to the extent that any new opinion is in that, I'd ask the court to exclude it. But Ms. Kenny Bodden also explained to me that the two major opinions that he's going to be offering to the jury is the number of shots and the relative position of the arm of Mr. Furtado at the time he was shot.
Yeah.
And those are consistent. Those were in his original report. So as far as those opinions are concerned, I can rely on my...
All right. Then I will listen for objections and talk with you folks as they arise.
Your Honor, I also in the Lane Foundation, we have an exemplar shirt to explain the shots, and the Lane Foundation, you have to be able to use that shirt in front of the jury.
Have you seen it?
I've seen a picture of the shirt, but I've seen what there's a paragraph devoted to it in the supplemental report. I would object to the exemplar shirt coming in for a variety of reasons.
Just a demo to explain the shots that were indicated in this first report, how the angulation was. As a matter of fact, the demonstration without the shirt was done today with Detective McIsaac, I think, having yellow stickies on his shirt to show the same angulation.
You didn't shoot McIsaac.
Didn't shoot Dr. Downs either, so that's what I was concerned with.
Judge, my concern with the shirt is that what Dr. Downs evidently did was take the exemplar shirt and either lay it over or superimpose it upon the Mr. Furtado shirt, and then marked two places and put holes in it and tries to make a comparison regarding the trajectory testified to by Dr. Lindstrom and that as it appears to be on the shirt. The problem is, of course, that there's so many variables involved. There's no way to know how the shirt was being worn or where it was laying across the victim's back at the time he was shot. Sometimes shirts bunch up, and sometimes, quite often, the holes don't even match the holes in the
well, and
in other words, I don't
that's an issue whether you use a exemplar shirt or the original shirt that is in evidence. So that's not grounds to exclude it. It seems to me grounds to exclude it. Examination as to how it was worn and whether it was bunched up.
I'd prefer that foundation not be laid in front of the jury, however, because it could be that after the foundational questions, it's not admissible.
Well, you go take a look at the shirt compare it to the original exhibit.
Well, all I have
See if it misrepresents anything to you. That would be the ground to exclude it, and I don't see any other ground to exclude it. I would not permit the shirt to come into evidence. I'd permit it to be marked for identification and serve as an identification exhibit. Shirt to come into evidence. I'd permit it to be marked for identification and serve as an identification exhibit.
No intention to move it. And Your Honor, could we have one of the cops on to make sure it's not going, because we're dealing again with medical examinations?
You can do that now because we're about to get started. Now
They need it, I believe, now for Mr. Lane. They need to have access to it.
For who?
For the first witness. Dr. Down is not the first witness, it's the second one.
And who is the first witness?
Jacob Green. Computer expert.
Oh, yes. Thank you. All right, the last issue before me, before we bring the jurors down, relates to this witness, Lysander Amato. The defense asked me on Monday to recognize process electronically, I guess it was, to a member of the U.S. military now serving in Kuwait. The defendant submitted in support of that request references to the Hague Convention and to U.S. code regulations or laws regarding the fact that an active member of the U.S. military would retain their domicile or residency for purposes of judicial process. Based on what was submitted, I allowed the defendant's request or motion, whatever it may have been. Yesterday, I received in letter form what appears to be a motion to quash by the witness, Mr. Amato. The motion to quash in letter form dated April 4 and addressed to me is on the letterhead of the Department of the Army and Camp Arif John in Kuwait. Arif John Nancy, A-R-I-F-J-A-N. In the letter, this soldier indicates that service of process is not proper in the country of Kuwait because it would rely on a provision of the Hague Convention Kuwait does not recognize, that is, has objected to. Counsel, it's all a way of saying, I don't know why I'm dealing with this issue now on the last day of the defense case. This seems to be an issue that should have been raised far in advance of today. The question is the propriety of process. Based on what has been presented to me by way of the defendant's ex parte memorandum supporting the propriety of process, and in light of the response by Mr. Amato, that I take it was prepared with the assistance of some member of the Judge Advocate General's office. I'm not prepared to issue an order indicating that process is in fact proper to a member of the U.S. military serving in Kuwait. All right. I think that means we're ready for jurors.
But I don't know if we want to address this now, but I did want to be heard briefly on the issue of two recall witnesses who I believe are being called today, one being Mr. McCann and one being Mr. Kwan. I would just ask the court to require counsel to give some offer of proof as to why these witnesses need recall. As the court is aware, the court did give counsel the ability to recall certain witnesses at a certain time if it deemed it appropriate. In the Commonwealth's position, if it's just a question that was forgotten to be asked, then it would not be appropriate to allow defense counsel to recall the witnesses, as opposed to if it were actually another area of questioning that counsel was relying upon the Florida rules and intended to recall this witness. I think that would be a different situation. The Commonwealth would ask for some offer of proof as to what these two recall would be testifying to.
Mr. Baez?
The issue is moot, Judge.
It's moot?
Yes, sir.
You don't intend to call them?
No, sir.
Okay. Very good. Anything else before we bring our jurors down? No? All right, we'll be in brief recess to line up the jurors.
All right, please. Welcome back to the Law News Network. I'm Beth Karras. I'm your host for the next few hours. So we just heard a hearing outside the presence of the jury in Boston, Massachusetts, where Aaron Hernandez's trial is wrapping up. The defense expects to present its final witnesses today, and as we just heard, one of those witnesses who the defense wanted to call via Skype or some sort of electronic medium, the judge has denied it. There was a motion to quash a subpoena. Peter Ellikin is joining me from Boston via Skype. Peter, did you hear the argument just now?
No, it did not come through to me. Sorry.
Okay. The final argument just now was that the defense had requested and tried to subpoena a service member, Lissandro Amato, who is serving in Kuwait right now. But Amato, through on U.S. Army letterhead, through I guess the attorneys, the judge advocate general's office, had filed a motion to quash the subpoena, or a letter motion to quash the subpoena, and the judge was not about to order it. Unusual, and the judge was like, why are you raising this on the last day of the trial? You should have dealt with this beforehand. I have seen people in the service testify at trials, but trials are often arranged around their leave time when they're in the United States. I have never seen someone, not that it hasn't been done, but in a state case, I've never seen the long arm of state jurisdiction reaching into our service members in another country to bring them back or have them testify electronically.
Yeah, I agree. Knowing that the mechanics of bringing somebody from the Middle East over to the United States would take weeks. I wonder why they were not aware of this witness before, because otherwise, almost always, it's very rare that somebody can testify over video. It's that old thing that you have a right to confront your accuser. You want them there live in person. You want to be able to really see up close their demeanor, their face, it's why people have to testify rather than just type out statements and kind of send them in. You really do have a right to in-person confront your accuser, or somebody, not your accuser, but somebody who would be willing to testify. And in this case, it really is unclear why they wouldn't have tried to make those arrangements, knowing that it would be very, very iffy and risky on the last day to try to see if you can get permission to have somebody testify, via Skype.
I mean, I suppose it would be one thing if the witness was going to consent to it and not really care, and then the judge may or may not have allowed it for the reasons you stated, that it's preferable to have, in a criminal case, to have the person present. We do see videos used in civil cases, but criminal cases, the stakes are high and the rules are different. But this was not someone who was consenting to it either. I mean, he was moving to quash it, or maybe his boss, maybe it was out of his hands, but the Army was moving to quash it. So yeah, I guess, the defense thought, it's a shot. They said they had up to 3 witnesses. Assuming Lissandro Amato was one of those 3 witnesses, there goes one. And then I couldn't hear who Baez was referring to when the judge, when he said we're not going to call him, if that was Amato or yet another witness. But it could be a brief morning, or maybe it'll be just one witness, maybe 2. They're lining up the jury right now. We should have the one forensic witness a Dr. Downs. They talked about a Dr. Downs this morning, who, experts can be in the courtroom for testimony of other experts. There was some discussion also in this hearing this morning about that. The state having been a little concerned that one expert was listening to the state's expert and reviewed other witnesses' testimony. But I'm sitting here thinking, well, that's the rule in most states. Isn't that allowed in Massachusetts?
Yes, I would think so. It's not like they're sequestered witnesses trying to, sometimes you on certainly, let's say the defense has a bunch of witnesses, they want them sometimes sequestered out of the courtroom so they don't get their story straight. So so they don't try to imitate.
Let me cut you off, Peter. I'm sorry to cut you off. The jury's in the courtroom and the judge has begun the trial with the jury. So it's been a few days since the jury's been in there. Let's go live into the courtroom.
Superior Court that is sitting with me this morning, Judge William Barrett. Judge Barrett comes out of private practice. He had a practice in the field of law in Boston for many, many years, and was then selected and nominated by our governor, Governor Baker, to serve as a judge of the Superior Court, and recently was inducted into the court. And as part of our welcoming traditions, new judges often sit with other judges, and to the case on trial, at least to this morning. And let me inquire of all our jurors, since you left on Monday, whether any juror has discussed this case, has read, heard, or seen anything about this case, or has any contact with the case outside of court. If you have, would you raise your hand? And I see no hands raised, and I find the juror remains indifferent, and we continue with the evidence this morning, turning to the defense for further witnesses or evidence. Mr. Baez.
Thank you, Your Honor. The defense calls Jacob Green.
Sir, you're going to start right here. You're going to raise your right hand and your face as well.
You solemnly swear the testimony you shall give this court and jury, and the issue now pending between the Commonwealth and the defendant at the bar shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Kindly follow the officer.
Go ahead, sir.
Mr. Baez, please.
Yes, may it please the court, Your Honors. Mr. Hagan. Good morning, ladies and gentlemen. Good morning. Good morning, sir.
Good morning.
Could you please introduce yourself to the ladies and gentlemen of the jury?
My name is William Jacob Green. I work with a company called Guardian Digital Forensics based out of Raleigh, North Carolina.
And what does this company do?
We specialize in digital forensics, anything ranging from cell phone tower location data, cell phones, computer forensics, GPS forensics, anything that we can assist with either civil, criminal, litigation matters to better assist attorneys and jurors like yourselves understand digital forensics.
Mr. Green, don't get offended. We're up to here with phone records and computer searches. So
yes, sir.
I'm going to move quickly if that's okay.
Yes, sir.
Okay.
Yes, sir. I started in law enforcement in 2006 with the city of Rock Hill in South Carolina. It's the fifth largest city in South Carolina, just south of Charlotte. In 2009, I was assigned to a forensic investigation unit. We utilized a system called Cellbrite to examine cell phone data. I was assigned to the United States Secret Service as a task force officer in 2000. I apologize, I believe it was 13 or 14. Where I spent the last few years of my law enforcement career assisting law enforcement agencies, both state, federal, local level, investigate over 1,300 cell phones.
And what about doing work on computers and recovering?
Yes, sir. The same thing. That 1,300 number that I use in my CV includes both cell phones, computers, surveillance videos, all kinds of anything that stored electronic media, we were tasked with examining.
And have you taken multiple courses in this field of digital forensics?
Yes, sir. I have over 1,100 hours of forensic investigation training. Almost over 600 hours of that total is specifically assigned to digital forensics.
And have you testified previously in other courts of law in the area of digital forensics?
Yes, sir. I just recently testified in the county of Jackson, Missouri, and was ruled as an expert in that trial.
I'm going to dive right in, sir, and talk about the work you did in this case. Did you have an opportunity to receive and examine a hard drive known to be from the laptop of a Brooke Wilcox?
Yes, sir.
Okay. Tell us quickly what you did and how you go about getting this information.
Yes, sir. The evidence was released and shipped to our office directly in Raleigh from Boston Police Department. We received a hard drive that contained what's called an EO1 image. It's an in-case forensic image. It contains all the data that was recovered from that drive, more than likely by the original law enforcement examiner.
So it's like a mirror hard drive?
Similar, yes, sir.
Okay. Please continue.
Yep. We ran that data through several different types of software. One would be access data. It's called Forensic Toolkit, FTK. We also ran it through a system from Magnet Forensics called Axiom.
Okay. And did your examination generate any reports?
Yes, sir.
Okay. May I approach the witness?
You may.
I'm handing you a binder that's yet to be identified. Does this appear to be your report?
Yes, sir.
Okay. And is this of the computer that you did purporting to be Brooke Wilcox's computer?
Yes, sir.
Okay. I'd like to have this marked, if I may, Your Honor.
As an exhibit or for identification?
As an exhibit.
Any objection?
I said be marked just for identification so we see exactly what's going to be put into a rather large document.
All right, we'll receive it for identification. E.
I'm showing you now exhibit E. Okay. All right. E stands for easy, okay?
Yes, sir.
So let's do this easily. Let's talk about the searches that were run on July 16th, 2012. Do you have those before you, sir?
Yes, sir, I do.
Okay. Were there any searches run for any type of shootings that evening?
I believe so.
Or that early morning?
Yes, sir.
Okay. Now, I remember we had an issue with this UTC time. Did you have a chance to have it done in Eastern Standard Time?
Yes, sir.
Okay. Can you tell the ladies and gentlemen of the jury the brief overview of the searches that were run on that morning?
Yes, sir. We have, I believe it was a total, let me just verify that. In this record, we have 15 different Google searches. All these searches were completed using google.com. This specific report doesn't outline, or I apologize, it does outline which browser was used. So Google Chrome and Internet Explorer were observed in these records as being the operating system or program that was used to search for google.com. We have a couple different searches. The first one that we can see that somebody actually, it was called an original search query, which means someone actually typed that into the Google search engine. Breaking news in Hartford, that was actually the things that they typed were breaking news in HARTF, and then of course Google auto-populated Hartford into that and guessed that that's what the user was typing.
What time was that done?
That one was done at 6:58 a.m. and that is corrected for Eastern Standard Time.
Okay, 6:58 a.m. Not later on in the evening?
No, sir. That was in the morning.
Okay, please continue.
Yes, sir. The next one that we actually have a search for that someone actually typed in, shooting in HAR, and Google guessed that the person was searching for a shooting in Hartford. That search was completed at 7:07 a.m.
Okay, please continue. Now, before you continue, you can't say who's running these searches, right?
No, sir.
Okay. And even whether it's one browser or another, you can't really make any determinations based on that. You can just say this browser at this time and this computer at this time.
Yes, sir.
Okay, please.
There's another search that did not provide us that the original search query, so we don't know how exactly this information was put into Google, but we have a record for shooting in Hartford last night, and that of course was on the 16th at 7:07 a.m.
Okay, and then continue.
We have another one for the shooting in it's HARTF, again at 7:07 a.m. We have a search for breaking Boston news at 7:09 a.m. On the 16th at 11:54 a.m. we have a search for Aaron Hernandez.
Okay, and is that a Google search?
That is from google.com, yes sir.
Okay, what else?
The next one we have at 11:56 a.m. someone searched for, we actually have a original search query, so someone actually typed this into google.com, Aaron Hernandez address.
Okay, and that is at what time, 11?
That would be 11:56 a.m.
Okay, continue.
We have a Google search at 11:56 a.m. Within Internet Explorer for Aaron Hernandez address. At 4:25 p.m. in the afternoon, we have a search for www.gucci.com within Google.
Okay. What else?
4:25 p.m. we have another search for www.gucci.com.
Let me stop you there.
Yes, sir.
So you got searches being run early in the morning at 6 to 7 a.m., right?
Yes, sir.
And then another sitting around 11 a.m.
Yes, sir.
And then another sitting at 4.
Yes, sir.
Okay. So someone's on the computer at different stages during that day?
Correct.
Okay. Let me just fast forward if you can.
Yes, sir.
These Gucci searches, are they for any specific type of clothing?
Yes, sir. They're searching for men's shoes, specifically sneakers, on Gucci.com.
Okay. And then does there appear to be another relevant sitting later on that afternoon?
Yes, sir.
Or evening?
Yes, sir. At 6:26 p.m., we have this will be from Internet Explorer's history, a search term for Boston, or shooting in Boston.
Another sitting at 7:30 p.m.?
Yes, sir. 7:30 p.m. There was an original search query, so again, someone actually typed this into the Google search engine for Aaron Hernandez, and then it auto-populated to Aaron Hernandez's girlfriend.
Is there another sitting later on that evening?
Yes, sir. At 11:55 p.m., we have a original search query for breaking news in B, and it auto-populated to breaking news in Boston.
Judge, at this time we would move these subject to redaction, this item into evidence as exhibit.
Subject to redaction, I just want to see what's in there.
All right, that'll be received, Nancy, 381. Exhibit 381.
sir. Did you then have an opportunity to examine a cell phone that was purported to be from an Alexander Bradley?
Yes, sir.
Okay. Tell the ladies and gentlemen of the jury how you got that and how that all went down.
Again, the Boston Police Department released that physical piece of evidence that was determined to be an Apple iPhone 5. It was shipped to our office in Raleigh, where we received it and completed an investigation and examination of it using a cell phone forensic software suite called Cellbrite.
Okay, is that the latest version of the software?
Yes, sir. Prior to doing any examination using that software, we verify that Cellbrite has released any updates, and if so, we install those updates to make sure we are using the current version. It's very similar to what law enforcement does.
And did you generate any reports as a result of this
Yes, sir.
forensic examination?
Yes, sir.
Okay. May I approach the witness? You may. I'm showing you a white binder that has a document, numerous pages, that says extraction report. Do you see that, sir?
Yes, sir.
Okay. May I have this marked for identification first? 4F. All right, this is FFFF. All right, I won't tell you what that stands for. Now, on the extraction report, sir, when you have that, did we ask you specifically to pull something for just a certain type of text messages?
Well, the first report that we did when we completed the extraction on January 25th, we pulled all available data.
Okay. And this is a condensed version only of a certain thing, correct?
Yes, sir.
Okay.
This report contains only those items that were recovered that had been deleted by a user.
Okay. So all these pages here are deleted text messages and other items?
Yes, sir. All the fields on these, every one of these pages has a field that is titled deleted, and it is marked as being a true indicator, which would indicate that it was deleted.
Okay. So I could show this to the jury real quick. I'm going to put it up here on this screen. I'm just going to pull a random page, sir, and if you can kind of tell us what certain fields mean.
Can you zoom out just a hair?
Oh, sure.
There we go. So we'll take, that is item 225. It is a type of chat message. Cellbrite recovered it as a deleted MMS message or a multimedia message. The first column.
You can touch the screen. It's
okay.
on the screen.
Sounds good.
It marks it up.
So we see here, it's marked as a deleted SMS message. That is actually what I typed into it to tag that message.
All right, I'm zooming it in a little better. Okay, go ahead.
So this is the tag that I created so that we could keep track of what it was. This is a deleted MMS message or multimedia message. We can see in this field, that is when we actually tagged it. This is our indicator field for it being deleted. And we can see that it is from an iMessage directory using that phone number. And then we see the participants of that field. When items are deleted, we recover only portions of them sometimes. In this case, we only recovered a very slim portion of data. We see that there was the body of the message, and then we see the participant in that message.
Okay, I'm going to show you another text message at this time. I'm going to zoom in.
sent to this party that was stored in the contact directory.
So this party, that's their phone number, and the word pick, would that be what that person is as their contact?
Yes, sir. That would be what the person's name is saved as.
Okay. And then go ahead and go through the rest, please.
Continuing across, we see that the date time of the message was sent July 4th, 2013 at 8:38 p.m. And again, this is not in UTC. This is actually corrected for Eastern Standard Time.
Okay. So that's Eastern Standard Time at 8:38 p.m.
Yes, sir.
Okay. And now as it relates over to the message.
Yes, sir. We see that the status was sent.
Okay.
And we also see that the status indicator for deleted is actually deleted and recovered. And then we also have the body of the message here.
Okay, so this message was sent on this time to this person.
Yes,
right?
sir.
And that's the content of the message. I'm sorry, down here rather.
Yes, sir.
Okay, and the message was deleted, correct?
Yes, sir.
Judge, at this time, we would move item FFF into evidence, subject to any redactions that counsel deems appropriate.
Unlawful any objection.
I have no further questions. Thank you, sir.
Mr. Hagan.
Thank you, Your Honor. Good morning, Mr. Green.
Good morning, sir.
I just have a few questions. Let's start first with the download you did of the laptop computer. Actually, you got a hard drive, correct? An in-case hard drive of some sort?
Yes, sir. We received a forensic image of that machine.
And what date did you do that forensic examination, sir?
I do not have that information with me.
Does February of this year sound about right?
Yes, sir.
And I believe you testified, Mr. Green, as to a number of the searches that you located in your forensic analysis. Is that correct?
Yes, sir.
And is it fair to state that the original report that you gave to counsel, who then provided to the Commonwealth, you did not account for the UTC, the subtraction of 4 hours? Is that
yes, sir? The very first report, yes, sir.
And just calling your attention to some of the things you just testified to, I don't know if you can find it in your report, but I'm going to place on the screen Exhibit 315 and a particular entry. I'll just ask you if you found that in your report as well. The entry is labeled as 22745. Can you see that on your screen?
If you go up, or I apologize, slide the paper down just a little bit. There you go.
22745.
Yes, sir.
Does that indicate a search on July 16, 2012, 11:15 a.m.? If you subtract the UTC, that would bring us to 7:15 a.m.?
Yes, sir.
And is it fair to state that this search was for a shooting in Boston South End that leaves 2 people dead?
Yes, sir.
And is that one of the searches that you found in your download as well?
Yes, sir.
Okay, but you didn't just testify to that with Mr. Baez just now, did you?
Do not believe we brought that specific item up.
And I'm just going to go to the top of this exhibit, exhibit number 315. Was this, to the best of your knowledge, a Chrome search?
Yes, sir. That was completed within the Chrome internet browser.
And just to be clear, I think you've already testified to it, Mr. Green. There's a difference between the browsers that you can search on. You can either use Internet Explorer or you can use Chrome, and I think there's a few others that are beyond me.
Yes, sir. There are many others.
And Mr. Green, is it fair to state that people tend to be creatures of habit. People.
Judge, calls for speculation.
Sustained.
Mr. Green, do you have a favorite browser that you use?
Chrome.
Chrome.
Yes, sir.
Do you use only Chrome when you're doing searches?
Use as many as I can.
And prior to using Chrome, did you have any others that you used frequently back in the old days, maybe the early 2000s? Did you use Internet Explorer?
Yes, sir, we have.
And when you used Internet Explorer, that would be all you used, right? You wouldn't keep clicking between Internet Explorer and Chrome?
It depends.
And it's fair to state, Mr. Green, you did a full forensic download of this computer, and you were focusing on the internet searches, correct?
Well, we did not do the forensic download. Law enforcement completed that download and provided us the in-case forensic image.
Good point. So, but you then looked at the forensic image and did some type of analysis, correct?
Yes, sir.
And would it be fair to state that the majority of searches on this computer in that relevant time period of about a week before and a week after, those are mostly searches with Internet Explorer, correct?
Believe we did find more records for Internet Explorer.
More records for Internet Explorer. And this particular entry I just showed you was a Chrome search at 7:15 in the morning for a Boston shooting, correct?
Correct.
And then the later searches that you testified to on direct from Mr. Baez, those searches, and I'm calling your attention particularly to the evening searches around 6 o'clock at night, those were Internet Explorer searches, correct?
Yes, sir.
And is it fair to state there's really only a few Chrome searches, kind of early morning, maybe into the late morning, correct?
Yes, sir.
Mr. Green, I want to move now to the work you did on the cellular telephone purportedly belonging to Alexander Bradley.
Yes, sir.
When did you do that search or that download of that device?
I believe it was January 25th of this year.
January 25th of 17?
Yes, sir.
And the report that you just identified that Mr. Baez showed you, that was just produced yesterday, correct?
Correct. That was,
Is that correct?
Yes, sir.
And I just want to call your attention to some of the testimony you gave about deleted files that you were able to recover, I think was your word, correct?
Yes, sir.
Is it fair to state, Mr. Green, as part of your analysis on this case, you looked at the Boston Police Celebrate report that was generated purportedly by Detective Kevin Witherspoon, correct?
Yes, sir.
And it's fair to state that Detective, or Sergeant, I should say, Detective Witherspoon's report also contained all of those deleted files.
I believe so, yes, sir.
So it's not as if you were able to recover deleted files that he did recover, is that correct?
Would not be able to tell you exactly how many he recovered. All I can do is provide you what we recovered.
But you did see that his report had numerous deleted files?
Yes, sir.
And just so we're clear, Mr. Green, can you tell when a file's deleted?
No, sir. Not on this operating system.
And just as far as what you did find deleted, and I think we marked as an exhibit, at least subject to redaction, a rather thick packet of deleted files, is that correct?
Yes, sir.
Is it fair to state that the MMS messages on that phone had numerous MMS messages, correct?
Yes, sir.
And is it fair to state, for those in the jury who may have forgotten from prior witnesses that we've had, that MMS messages are basically text messages that have a photo or data attached to it of some sort, correct?
Photo attached can actually be a longer, just text document.
But it's a little different than an SMS. It has something of a little more meat to it, correct?
Correct.
And isn't it fair to state, Mr. Green, that the entirety of MMS messages on that device were all deleted?
I believe so, yes, sir.
And that's oftentimes done, is it not, to free up space in a telephone?
If you know, based on your training and experience, you may answer that.
I mean, there are many methods to free up space on a phone. You could delete your MMS messages to free up space, but there are many other areas.
And MMS messages that have photos and other data attached take up more space, correct?
They can, yes, sir.
And is it fair to state on your review of the various and numerous MMS messages that were deleted from Mr. Bradley's phone, some included photographs of children and things like that?
Yes, sir.
And all of those were deleted?
I believe so, yes, sir.
And just calling your attention now, sir, to the various text messages that were deleted. Did you have a chance to look at some of those?
I did not review every single one, but I did verify that they were in existence.
Well, so I'm just going to call your attention to at least on the report from your original download, number 492, which I'll ask to be marked for identification. So they just have smart right here.
That'll be tree.
Yes, sir.
Just going to show you what's been marked for identification only as GGGG. And I'm just have you focus on number 492, a sent text message, and tell me if I'm reading this correctly. You think that you cool find them 76ers Barkley post these on eBay for me? Did I read that relatively correctly?
Yes, sir, I believe so.
And according to your analysis, Mr. Green, that's a message that was deleted, correct?
I can't specify exactly what this came from. The header for the top of the page has been cut off, so I'm not 100% positive where that came from.
Okay, we can go to the individual pages, but the column on the far right that says yes, that indicates whether or not it's been deleted, right? And that's what we've been looking at the prior messages?
Yes, sir, in the prior messages. However, this one, the header is cut off of the top row, so I'm not sure what it came from.
Okay, well, we can, do you have your report in front of you?
I do not have it, no, sir.
I mean, I'll just pick a random page, Mr. Green. We're at page 144. I mean, there's messages here like, you good, yeah. Something about a tow happening. These are all deleted, correct?
Yes, sir, all those are.
I think I can find this one. Oh, and in fact, while I'm looking for that, Mr. Green, you had a chance to review the various iMessages as well, correct?
Yes, sir.
And those are a little bit different than text messages, SMSs, because that means, not to state the obvious, but one iPhone talking to another phone, or an Apple product talking to another Apple product.
Exactly, yes, sir.
And it's fair to state on this particular phone, every single iMessage was also listed as deleted.
Correct.
And without going through individual messages, sir, just calling your attention to the one I showed you with Barkley, is it fair to state that there's somewhat of a randomness to the text messages that were deleted? In other words, sometimes it's just something like buying sneakers that's deleted.
Judge, also speculation. As to whether there's a randomness.
Why don't you rephrase that, if you would, Mr. Hayden?
Again, I'd rather not spend a lot of time going through a report, but that exhibit I just put up on the screen, talking about the Barclays, again, assuming that the right-hand category is your right-hand category of deleted, does that look like it was a deleted file?
Yes, sir.
And that particular text, again, seems to be talking about sneakers on eBay.
Yes, sir.
And in your examination of that phone and looking at text and providing counsel with various texts or SMSs that were deleted, it's fair to state there were others like that.
Yes, sir.
Okay. Just talking about random stuff, correct?
Yes, sir.
Judge. Who knows what's random stuff? It's not just free.
Sneakers.
Sneakers. There were a lot of discussions about sneakers in these text messages, aren't there?
There were, yes, sir.
And almost every single one of those is deleted, right?
Correct.
Mr. Green, this is a little bit unfair because you may not know any significance, but I'm going to show you a page from your report as well. It's just a number of SMSs that are from your original report, not the one you just created. But there's a phone number here from 203-606-8969. Do you see that?
Yes, sir.
If we're on the same page, there we are. And there's various text messages back and forth from that number to this phone, correct?
Yes, sir.
And all of these are deleted, right?
All of those are deleted, yes, sir.
And did you become aware that that's actually Aaron Hernandez's cell phone number? Did defense counsel
I
advise
believe
you
so.
that?
Yes, sir.
And it's fair to state that, at least from what we see in the category to the right, the yes, all of those text messages were deleted too.
Can you rephrase?
All of the text messages that we're talking about from Aaron Hernandez's phone to what's purportedly Mr. Bradley's phone, those were also deleted.
If you go back up, I believe there were some that were from and to that were not deleted, that were from Mr. Hernandez.
I'm sorry, so some here are not deleted, but the other ones are?
Some of them are, yes, sir.
And Mr. Baez placed on the screen, Mr. Green, and let me see if I can find it on your report. It'll probably be easier. So Mr. Baez placed on the screen this particular page and asked you some questions about this text, correct?
Yes, sir.
I'm just going to call your attention to the page right before that. Calling your attention now to what's labeled as number 1091. This is an SMS message to PIC from the owner of the phone, purportedly Mr. Bradley, correct?
Yes, sir.
Just tell me if I'm reading this right. Hey, PIC, Mass law says that any grand jury testimony can only be used for an indictment, but that is not admissible in court. Did I read that right?
Yes, sir.
Then another text, will his lawyer receive a copy of his indictment if went before a grand jury, and if so, would it say I testified before the grand jury? Did I read that correctly?
Yes, sir.
And then the answer back purportedly from someone identified as PIC is yes, lawyer gets transferred.
Correct.
And that's the day before the other text messages, correct?
I believe so.
Let me call your attention, Mr. Green, to page 140 of your report. Just give you the entry number. Appears to be entry number 1062, SMS message, correct?
Yes, sir.
And I'm not going to say the N-word in this, but so it says, I listen little n and listen real closely, and well, what your best move is to keep my name out of your mouth for a few reasons. One being you don't want me in the type of shit I be on. Secondly, you ain't a street N, and the wrath I bring will have you telling the police and your mommy on my boy. Thirdly, I ain't never say a mither fucking word to the police about who shot me. LOL, dumb. And go read some law books. A civil suit is suing a person. It's not criminal. You can't find an article anywhere that says I told police that he shot me. Don't your dumbass know that if I told on him, he would have been charged with that shooting? Stupid. Watch your mouth and be careful, because I'd be around if that's how you feel. I'll confront you so you can tell me that, and that'll be what I'll be. Do some research on me. I never told and never will, young boy. Did I read that relatively correctly?
Yes, sir.
Thank you, Mr. Grant. No further questions.
Yes, sir. Mr. Green, all you got as far as the information that this was Brooke Wilcox's computer, right?
Yes, sir.
Okay. It doesn't. You don't know or can't testify that Alexander Bradley likes to use Chrome Internet Explorer, right?
That's correct.
And that Brooke Wilcox likes to use Internet Explorer.
That's correct.
Right. In fact, people search sometimes multiple search engines when they can't find it on one, right?
Yes, sustained. I think you objected to that.
You, sir, you utilize multiple search engines, right?
Yes, sir.
For what reason?
It depends on what we're searching for. Forensically speaking, sometimes Internet Explorer is better than Chrome. It just depends on which one we decide to use.
Okay. And Mr. Hagan talked about deleted photos and stuff like that of children. Do you remember that question?
Yes, sir.
Okay. May I push the witness? Do you know that there were lots of other photos deleted, right?
Yes, sir.
Okay. And most of which are some type of amateur porn?
Objection.
Sustained.
Were most of the photos that were deleted on that phone of other types of photos that didn't include children?
Overruled.
Yes, sir, they were.
Okay. Lots of photos, right?
Yes, sir.
Lots of graphic nude photos, right?
Sustained.
Your Honor, I would request a sidebar.
Come to sidebar.
Welcome back to the Law News Network. I am Beth Karras. We have been listening to the first witness of the day called by the defense as they wrap up their case in chief in the double murder trial of Aaron Hernandez. With me is Peter Ellikin, criminal defense attorney out of Boston. This witness, Peter, is just wrapping up his testimony because Jose Baez was just beginning his redirect examination when they called a sidebar. So I think that the witness is almost finished. I'm looking for his name, William Jacob Green. He's a forensic expert out of Raleigh, North Carolina, who examined Brooke Wilcox's hard drive. That's the computer of the former girlfriend of Alexander Bradley. It was to her home that Bradley and Hernandez went shortly after the shooting. Also, he examined Bradley's cell phone, and he talked about he generated some reports on deleted text messages. The prosecution just ended the cross-examination reading a long text from Hernandez, which ended with this statement: "The wrath I bring will have you telling the police and your mommy on me, boy." So anyway, then Jose Baez got up to cross-examine and to redirect, and they went to a sidebar. Were you able to hear much of this testimony, Peter?
Yeah, I didn't hear the earlier part, but towards the end I did hear the testimony.
Make anything of it?
There was sort of something in it for everybody, but I thought the prosecution kind of did well with it. If the argument is that he was out there deleting important things, I know the prosecution, it seemed like they were trying to make the point, but he deleted all kinds of things about, ordering sneakers online and a lot of things about sneakers and about and so it seemed like the prosecution was trying to diffuse the idea that he was just really trying to cherry pick and delete certain things. And in the court, it kind of came out that in the course of people using all this, all these kinds of online communications or social media, etc., or text messaging, that we all tend to delete lots of things because that also frees up space.
Correct.
So
That's something that Green said. He said they delete for freeing up space. I agree with you that the deletions didn't really have a theme. They were random things. But let's go. Well, you didn't hear the earlier part, the hard drive of Brooke Wilcox, where there were searches at 7:15 in the morning for breaking news, shooting in Boston, at least 2 dead. So somebody was on Brooke Wilcox's computer looking for what had happened just hours earlier. Of course, the defense is going to argue that it was Bradley using his ex-girlfriend's computer. Are they back in court now? Oh, let's go, Peter, let's go back into the courtroom live. The sidebar is over. They wrap up this witness and maybe call another one.
This text message here with the one containing all of the violent threats that Mr. Hagan read out loud, do you recall that? Okay. The one referring to have you telling the police and your mommy on me, boy. That one.
Yes, sir.
Okay, that was deleted, right?
Yes, sir.
Okay. Now also, you have experience as a police officer, correct?
Yes, sir.
You're a detective?
Yes, sir.
And in your review of these text messages, sometimes in a case, sir, I want to give you a hypothetical. Do drug dealers usually discuss specifically that when they're referring to drugs, do they call them drugs or do they sometimes call them innocent objects?
Overruled, I'll allow it.
Yes, sir.
Okay, so like sneakers. Like, do you have those sneakers for me?
Objection.
Sustained.
Okay. Do they use certain items to describe drugs, to kind of talk in code, so to speak?
Overruled.
They can use slang terms, yes, sir.
Okay, slang terms, and sometimes they substitute words, right?
Correct.
Okay, so what may appear to be on the surface an innocuous conversation could in fact be actual drug dealing.
Objection.
No, I'll allow it.
Yes, sir.
No further questions.
Mr. Hagan? Thank you, sir. You may step down. Please watch your step.
Mr. Myers. I think we need a 5-minute recess to set up for the next witness.
All right, we'll take 5 minutes, ladies and gentlemen.
Welcome back to the Law News Network. I'm Beth Karish, your host for the next few hours, and I'm joined by Peter Ellikin in Boston, criminal defense attorney, and we're following the case of Aaron Hernandez, which is now in a morning recess. The defense is wrapping up its case in chief. They started presenting witnesses on Monday after the Commonwealth rested. Court was dark yesterday because of the unavailability of defense witnesses, and they're completing their case today. The judge had the charge conference yesterday, which means that once the evidence is in, I don't know if the state's going to have a rebuttal case. There often is not a rebuttal case. Closing arguments could be tomorrow, could be Friday, but in all likelihood, this case is going to go to the jury this week. Don't you agree, Peter?
Yes, I think that they've done everything. It's a very, very efficient judge there, Judge Locke. And the fact they already had the charging conference, so they got a lot of the things out of the way of what they would talk to the jury about when giving them instructions at the end. And so I would say that I don't really hear about another list of witnesses, so I would think definitely tomorrow or Friday at the very, very latest.
How do they do closing arguments in Massachusetts? I've forgotten. It's been a while since I covered a case there, and I'm a New York attorney. In New York, the prosecution doesn't sandwich the closings. It's not like there's a prosecution, closing, defense, and then prosecution, rebuttal, close. Do they do that in Massachusetts?
Yeah, that's true. Generally speaking, what there is just each person takes their turn. I've always, as a defense counsel, always hated the idea that I go last, which defense always goes, defense goes first. So prosecution always gets the last word. Right. It's the nature of our business. But yeah, there really is just the defense counsel gives the closing and then prosecution gives the closing, and that is that.
It's just one from each side. It's like New York. You don't have two from the prosecution.
That's correct.
Okay, good. I don't know what who's on deck, but perhaps this Dr. Downs. Did you hear any argument today about Dr. Downs? That's the expert who was in the courtroom listening to the state's expert, despite the witness sequestration rule, which we already talked about.
Right. No, I did not.
Okay. So let's go back while we're waiting, while they're in a break, and review a little bit of what went on this morning. Let's take a look at the argument so you can hear, Peter, what you missed, and others who may be tuning in later can listen to what they missed first thing this morning. So this is AH1, Anthony, from today. This trial that began on March 1st. So let's go live into the courtroom.
Areas which the courts have consistently struck down and overturned cases in which perjured testimony has been utilized. The grounds for the perjured testimony is the knowing use by the Commonwealth of allowing Mr. Bradley to testify that he knew who the shooter was with respect to the Florida incident on February 13th of 2013. Specifically, as found in Exhibit 311, there is a text message from Mr. Bradley, number 268. Exhibit 311 has been introduced as evidence, and that text message was sent by Mr. Bradley to his attorney, Mr. Pickering. And that text message said, "Now you sure once I withdraw this lawsuit, that won't be held on perjury after I tell the court the truth about me not recalling anything about who shot me." Now, if you remember, I believe it was on redirect, the Commonwealth attempted to explain away through Mr. Bradley that this involved a prior court grand jury hearing. Well, the fact of the matter is that whether or not this testimony was referencing a prior grand jury, it was an admission.
Prior grand jury because he hadn't testified in the grand jury yet.
No, but he was saying that he was about to testify in the grand jury.
Wasn't that October?
No, it was within a matter of weeks, the Bristol County grand jury.
I see.
Okay, and I think if you look at the text message, this was at 8:33:38. The next text message at 8:40 to his lawyer talks specifically about, and is an additional matter with respect to my grand jury testimony. And it was in this context of grand jury testimony that Mr. Bradley was asking the question of his lawyer if he told the truth to the grand jury about not recalling anything about who shot me. That text message was known to the Commonwealth. It was, in fact, provided as discovery to the defense. And as this court has reminded the defense counsel numerous times, that to the extent that disclosure Bradley, contrary to his admission to his own counsel that Mr. Hernandez shot him. Now, you know, there's an old expression, if it walks like a duck and it looks like a duck and it quacks like a duck, it's a duck. and Mr. Bradley, this is clearly perjured testimony before this court. It is one of the most disfavored activity that can occur in a court. Specifically, the United States Supreme Court has consistently held that knowing use of perjured testimony procedure violates the fundamental right to due process guaranteed by the United States Constitution. And it went on, the court has gone on to say in United States versus Bagley, stating that perjured testimony is considered material unless failure to disclose it would be harmless beyond a reasonable doubt. There is no question that this isn't harmless lack of disclosure. We're not even alleging disclosure. The Commonwealth knew about it.
Well, there was no lack of disclosure. The
I
text,
agree.
I take it, was produced in discovery, known to all, and part of the 479 texts that were introduced from the extraction report. So it's not an issue of concealing perjured testimony. It's an issue, I take it, of whether or not, in fact, there is perjured testimony. Taking the text as evidence, as evidencing that what Mr. Bradley said here was in fact false. The Commonwealth knowingly made use of that testimony in advancing its case. Correct?
Yes.
Okay.
I wasn't suggesting. All I was suggesting is that the courts, in retrospect, after trials, in cases where they have overturned convictions for perjury, in those cases alone, it's even just the, not even just, the failure to disclose. In this case, we have disclosure, yet, and they knew as well, yet they proceeded to use perjured testimony. And I don't see, let me continue. The courts have also said, the United States v.
So the Massachusetts
asserting that convictions obtained by the knowing use of perjury are fundamentally unfair and must be set aside if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury. In Pyle versus Kansas, 1942, declaring that the prosecution's knowing use of perjured testimony would deprive the defendant of due process. There's court after court after court in the U.S. Supreme Court and also the Massachusetts Supreme Court.
I don't think I need a primer on the law. Let's accept the proposition that the knowing use of perjured testimony is improper and can cause reversal or warrant dismissal.
Yes, sir.
Let's accept that as the state of the law.
Yes, sir. That's the state of the law.
Okay, so what more do you want to say?
What more that I want to say is that to suggest that the Commonwealth, with a communication from Mr. Bradley to his lawyer, telling the lawyer he was concerned about perjury when he tells the truth that he does not know who shot him, and then the Commonwealth goes on to present a case and allow Mr. Bradley to testify that Mr. Hernandez shot him, is clearly use of perjured testimony and can't be viewed in any other light.
Okay.
Thank you.
Commonwealth?
Very briefly, the statement is not evidence of perjured testimony. The court is well aware that instead it's in a much prior inconsistent statement that was used in cross-examination, and I expect to be vigorously argued in closing argument. The statement has to be taken in the context to which Mr. Bradley explained it on redirect. Right after that text is a text about his impending grand jury testimony. Mr. Bradley indicated that he was concerned about settlement negotiations that were ongoing, whether or not if he withdrew the lawsuit, went into the grand jury, and in essence perjured himself by saying he didn't know who shot him, whether or not that would affect his civil lawsuit and whether or not he could be charged with perjury for the inconsistent statement. So again, it has to be taken in its context. It is not evidence of perjured testimony, and the motion should be denied.
All right. I recall the back and forth on direct cross-examination and redirect as to this text message and its meaning. Mr. Bradley gave an explanation for what he thought for what he intended to mean in sending that communication, as just referenced by the Commonwealth. The motion assumes that, in fact, Bradley's testimony here as to knowing who shot him was false and perjured. And I don't make that assumption. Ultimately, that is for the jury to determine. So after hearing this motion is denied. Counsel, before we bring our jurors down, the issue was raised on Monday regarding the testimony or anticipated testimony of, is it Dr. Jamie Downs? Dr. Downs, having provided a report of the opinions he had formed in this case, and then over the weekend amending that report and expanding his report. It was also disclosed that Dr. Downs had in fact been present during the testimony of Dr. Lindstrom, notwithstanding the fact that a sequestration order was in place. And as I've seen the supplemental report of Dr. Downs, it also reflects that he's viewed the video testimony of other witnesses.
Only as to the actual shooting, not the whole testimony. Only as to the nature of the shooting.
Well, he doesn't say what it was, other than he viewed the direct testimony of Mr. Bradley. He reviewed the video testimony of Detective McIsaac. He reviewed the video testimony of, is it Michael Haig, the reconstructionist, and was present throughout the testimony of Dr. Lindstrom. The Commonwealth raised a concern about that and asked at a minimum that it be permitted to meet with Dr. Downs. And you folks, I think, were working that out. Mr. Lee, did you have an opportunity to meet with Dr. Downs?
I did. We were originally scheduled to meet yesterday evening, but his flight was delayed until close to 11 p.m., so I did meet with him this morning for roughly 35-40 minutes.
All right. And do you have any requests to the court now?
Well, Your Honor, from having read the report, I think the court probably sees that it's long on observation and relatively short on opinion testimony. I will challenge, as it comes up, certain aspects of the numbered paragraphs that Dr. Downs, if those are elicited. But one of the opinions that he gave in his original report has been, I guess, punched up in a way. It's not the same verbiage that he used in his original opinion, but I can cross-examine him regarding that. But there are a number of numbered paragraphs that I think are inadmissible and inappropriate for the jury's consumption, but I can make those objections when necessary.
So you don't want me to do anything at this stage?
Not at this stage, but to the extent that any new opinion is in that, I'd ask the court to exclude it. But Ms. Kenny Bodden also explained to me that the two major opinions that he's going to be offering to the jury is the number of shots and the relative position of the arm of Mr. Furtado at the time he was shot.
Yeah.
And those are consistent. Those were in his original report. So as far as those opinions are concerned, I can rely on my...
All right. Then I will listen for objections and talk with you folks as they arise.
Your Honor, also in the Lane Foundation, we have an exemplar shirt explaining the shots, and in the Lane Foundation, you have to be able to use that shirt in front of the jury.
Have you seen it?
I've seen a picture of the shirt, but I've seen what there's a paragraph devoted to it in the supplemental report. I would object to the exemplar shirt coming in for a variety of reasons.
Just a demo to explain the shots that were indicated in this first report and how the angulation was. As a matter of fact, the demonstration without the shirt was done today with Detective McIsaac, I think, having yellow stickies on his shirt to show the same angulation.
You didn't shoot McIsaac.
Didn't shoot Dr. Downs either, so that's
Judge, my concern with the shirt is that what Dr. Downs evidently did was take the exemplar shirt and either lay it over or superimpose it upon Mr. Furtado's shirt, and then marked 2 places and put holes in it and tries to make a comparison regarding the trajectory testified to by Dr. Lindstrom and that as it appears to be on the shirt. The problem is, of course, that there's so many variables involved. There's no way to know how the shirt was being worn or where it was laying across the victim's back at the time he was shot. Sometimes shirts bunch up, and sometimes, quite often, the holes don't even match the holes.
Well, and
in other words, I don't.
That's an issue whether you use a exemplar shirt or the original shirt that is in evidence. So that's not grounds to exclude it. It seems to me grounds to exclude it. Examination as to how it was worn and whether it was bunched up.
I'd prefer that foundation not be laid in front of the jury, however, because it could be that after the foundational questions it's not admissible.
Well, you go take a look at the shirt. Compare it to the original exhibit.
Well, all I have
See if it misrepresents anything to you. That would be the ground to exclude it. And I don't see any other ground to exclude it. I would not permit the shirt to come into evidence. I'd permit it to be marked for identification and serve as an identification exhibit. Shirt to come into evidence. I'd permit it to be marked for identification and serve as an identification exhibit.
No intention to move it. And Your Honor, could we have one of the cops on to make sure it's not going, because we're dealing with medical examinations?
You can do that now because we're about to get started. Now
They need it, I believe, now for Mr. Lane. They need to have access to it.
For who?
For the first witness. Dr. Downs is not the first witness. It's the second one.
And who is the first witness?
Jacob Green. Computer expert.
Oh, yes. Thank you. All right, the last issue before me, before we bring the jurors down, relates to this witness, Lysander Amato. The defense asked me on Monday to recognize process electronically, I guess it was, to a member of the U.S. military now serving in Kuwait. The defendant submitted in support of that request references to the Hague Convention and to U.S. code regulations or laws regarding the fact that an active member of the U.S. military would retain their domicile or residency for purposes of judicial process. Based on what was submitted, I allowed the defendant's request or motion, whatever it may have been. Yesterday, I received in letter form what appears to be a motion to quash by the witness, Mr. Amato. The motion to quash in letter form dated April 4 and addressed to me is on the letterhead of the Department of the Army and Camp Arif John.
Welcome back to the Law News Network. We've cut off that bit of tape that we were just listening to. The judge denied having this service member in Kuwait testify, but court is back in session. Another witness is on the stand. They had to set up the courtroom for this witness, and that's why the delay just now. So let's go into the courtroom.
Ms. Kennicott.
Thank you.
Dr. Downs, could you spell your full name for the court reporter and introduce yourself to the ladies and gentlemen of the jury, please?
James Claude Upshaw Downs, MD. Do you want the whole thing spelled out?
I think James and Downs would be okay.
Okay, I go by Jamie, Jamie.
And your last name?
Downs, Downs.
Okay. Thank you, Dr. Downs. What do you do?
I am a consultant in forensic medicine. Basically, my full-time job is I review autopsies and crime scenes and try to determine if I'm able cause, manner of death, and how an injury came to be. I also teach on that subject as well. Part-time, I am the medical director for the physician assistant program at Charleston Southern University.
Okay. And before being a full-time consultant, have you recently retired from a specific job?
Yes, ma'am. I retired after about 14 years from the Georgia Bureau of Investigation. I was a medical examiner in Savannah for them for 14 years.
And before that?
Before that, I was the chief medical examiner and the director of the state of Alabama's forensics department. So I ran the 10 labs we had throughout the state, as well as chief medical examiner over about 10 to 13, depending on how our staff was, medical examiners.
I'm sorry, I interrupted you. I apologize.
Prior to that, I was a state medical examiner in Mobile, Alabama. I was there for about 5 years. Prior to that, I was in Charleston, South Carolina, my hometown, where I was medical examiner for 5 years. And during that same period, I was completing my medical postgraduate training, residency and fellowship.
Okay. And where did you graduate medical school?
The Medical University of South Carolina in Charleston.
And then what is the education that you have to go on after that to become what you are now, a forensic pathologist?
So following that, I completed my residency postgraduate medical training in anatomic pathology and clinical pathology. That was also at the Medical University of South Carolina.
Could I stop you and have you explain to ladies and gentlemen what anatomic pathology is and what clinical pathology is?
Sure, let me break it down. Pathology is basically the medicine of using the laboratory to study disease. There are two parts of that. Anatomic has to do with the body and tissues. Clinical is the labs. So, for example, anatomic pathologists would be if you had an appendix problem, you had the appendix taken out at surgery. The anatomic pathologist would look at the tissue under the microscope and tell you what was wrong with it. If you happen to pass away due to the appendix, the anatomic pathologist would be the physician that performs the autopsy to find out what happened medically. Clinical pathology is using the laboratory part. So actually you would be doing the blood work for the person who had an appendix out and running that lab.
Okay. And then did you continue your training to get board certifications in those two areas?
Yes, ma'am.
And what does a board certification mean?
Board certification means you have met the requisite requirements. You've successfully completed medical school and a certified or a qualified residency training program. Then once you complete that, in my case anatomic and clinical pathology, you are allowed to sit for the boards. That's as I recall, a 3-day exam, non-stop questions for 3 days, and hopefully you complete that successfully.
And you did successfully, correct?
Yes, ma'am, I did.
And those are as a result of your medical degree in dealing mainly with live patients for those board certifications, correct? Except for the autopsy that you indicated was for the anatomic pathologist.
Yes, ma'am. Well, anatomic does both. So, like I said, if you have your appendix taken out and you don't pass away from that, then the anatomic pathologist would look at the tissues under the microscope. So, actually, most patients in anatomic pathology are alive. The practicing physician out there would be called a surgical pathologist, which is just an anatomic pathologist specializing in surgical tissues.
Now, you got a third specialization after you graduated medical school and after you completed the boards in anatomic and clinical pathology, did you not, sir?
Yes, ma'am, I did. It's actually a subspecialty called forensic pathology.
And what is forensic pathology?
Basically, that applies the medicine of pathology in a context of sudden, unexpected, unnatural death and or injury. Again, basically something happens to someone and the forensic pathologist tries to determine what that is and collect any evidence associated with that.
And that's what you did, be a forensic pathologist for how much of your career?
Really all my career. Then in '89, July 4th weekend actually, I started doing forensic pathology as a deputy medical examiner in Charleston, and I did that continuously ever since.
And until you retired recently?
7 years working for the man, I decided it was maybe time to work for myself for a while.
Okay. Now, in addition to your experience, by the way, have you testified in the United States of America?
Yes, ma'am, quite a bit.
And could you give us just a short history of, for instance, how many states you've testified as an expert forensic pathologist or pathologist in?
I've given sworn testimony in probably 20 different states, as well as testimony for military, for the Air Force, as well as for the Army. Also testified before subcommittees of the U.S. Senate, U.S. House of Representatives. Also testified before the National Commission on Forensic Sciences.
Okay. And when you testified in those areas, did you also testify about this wound analysis reconstruction in terms of determining what happened when somebody dies?
Yes, ma'am. That's the practice of forensic pathology. So, yes, ma'am. It may be more or less in an individual case, but yes, ma'am.
Okay. Have you taught?
Yes, ma'am, quite a bit.
What about?
Really all aspects of forensic pathology. Areas that I have special interest in are child abuse, use of force, elder abuse and neglect. In fact, I just finished hosting a seminar at Charleston Southern on vulnerable victims that really ran the gamut.
How about in the area of wound analysis, reconstruction, or being a scene pathologist? Have you taught in that?
Yes, ma'am, many times. Most recently, specifically in that would be for the Atlanta Police Department back in September, I believe.
Have you taught at the FBI Academy?
Yes, ma'am, quite a bit.
In the same areas that you mentioned, the wound analysis, scene reconstruction, forensic pathology?
Yes, ma'am, I have. Actually, I wrote the textbook for them that's still used today, the Forensic Investigators Trauma Atlas.
Okay. And what about other areas such as the National Forensic Academy? Have you taught there?
Yes, ma'am. I am on the board of directors for the Law Enforcement Innovation Center at the University of Tennessee. And part of that program, we have the National Forensic Academy, which basically takes law enforcement crime scene folks and brings them up to speed about how to properly process a crime scene, what should be collected and documented. And I, for years, did the forensic pathology of that.
Now, you provided us in discovery and the prosecution with a copy of your most recent CV, which is 8 pages, correct?
I'll take your word for the number, but yes,
Okay.
ma'am.
I'd like to approach, Your Honor. Could you tell us, Dr. Downs, is this a copy of your most current CV that you provided to all of us?
Yes, ma'am, that's actually 9 pages.
9 pages, I apologize. And if I were to go through all of this, this would be the areas that I would ask you about that's in your CV.
Yes, ma'am.
Okay. May I have this marked as an exhibit rather than delay the jury from going early on?
Is there an objection?
As an exhibit, just for identification.
Rather than go through everything, I'd rather just move.
Let me see you at sidebar.
Welcome back to the Law News Network. I'm Beth Karras, and we've been listening to the beginning of the next witness for the defense. He is a medical examiner, a forensic pathologist who has extensive background in the area, not just in Georgia, but in Alabama and South Carolina. He's really just laid the foundation for his expertise, which is required of witnesses who are going to give opinions, who are experts as opposed to sort of fact witnesses, an officer who investigated, or a civilian who was an eyewitness, or somebody like Bradley who cut a deal with the prosecution. He has to be declared and found to be an expert by the judge. Sometimes the other side will object and do a voir dire, meaning their own questioning in front of the jury, challenging the credentials of the person or getting further clarification of the credentials of the expert. Usually, whoever is calling the witness knows what they're doing and they're calling somebody qualified, but there are times when they're trying to maybe call someone with, I don't know, kind of a new area of expertise that's not generally accepted in the field, and the judge doesn't allow the witness to testify. But this is done often in front of the jury. When there's a challenge, though, when it's clear that maybe the witness shouldn't be allowed to testify, they might do the hearing outside the presence of the jury. In any event, jurors should hear the foundation, the background of the witness, because that is part of what they take into account when assessing the credibility. When there are experts called by both sides, we call it the battle of the experts. Jurors are free to accept part, none, all of one expert versus the other, some of each. Sometimes experts just are awash and jurors just reject them all. But there was a sidebar because of what they're about to get into, I guess, with this doctor. I want to thank Peter Elkin, by the way. I was speaking to him off air, saying goodbye to him. He had to leave at 11 o'clock Eastern time, so thank you to Peter Elkin. Go back into the courtroom for continued direct examination of the doctor. Dr. Downs.
Well over 2,000.
Okay. And have you written about gunshot wounds and whether or not you can determine the path of a bullet through gunshot wounds?
Yes, ma'am. And that trauma atlas that I wrote for the FBI, specifically, there's a chapter in there that covers that topic.
Okay. And you were here when Dr. Lindstrom testified on Friday before the jury, the medical examiner?
Yes, ma'am.
Okay. And you were introduced to the prosecutors before she testified, right? You met them all?
Yes, ma'am. Actually, I don't think I met them all, but I shared an elevator up, I know, with Mr. Lee and met with him again this morning.
Okay. Now, I'd like to bring the jury's attention back to some of the exhibits that were utilized last week when we discussed the medical examiner, so we can go from there. Oh, by the way, Dr. Lindstrom testified that she had taken a course from you. Do you remember her?
Honestly, I have to say I don't. I teach a lot of classes in a lot of different places.
Okay.
I've taught all over, actually, U.S., Canada, Ireland. I've been around a little bit. Turkey.
All right. So, do you give your number out for people to call you if they have a question?
Actually, I routinely have my email and my phone number available, and it's in my teaching materials. That's usually the first or last slide if I do a PowerPoint.
Okay. So you're accessible.
Quite. I'm also. You can get my Forensics is my name of my business, and it's online.
Okay. Now,
Overruled.
I'd like to show you what was marked 371A. Now, freeze. Okay. All right. You see that, Doctor?
Yes, ma'am.
You've seen that before, correct? All right, we're gonna put it right back in right now. No. Still not there?
It'll go quicker if it
Okay.
stays black.
Thank you. All right. Yeah, you recall this? You've seen this, correct?
Yes, ma'am.
And this is purportedly a fair and accurate representation of the wounds of Mr. D'Abreu, correct?
I recall that was the way it was presented. Yes, ma'am.
Okay. And then you've seen a number of other exhibits, correct?
Yes, ma'am.
And you saw all the exhibits that Dr. Lindstrom testified to?
Yes, ma'am, I believe so.
Okay, not here, but in a different packet that you received, right?
Yes, ma'am.
Okay. Now, before we get into the specifics of the autopsy reports of Mr. Furtado and Mr. D'Abreu, I'd just like to ask you about some basic concepts, okay, in the forensic pathology world, right?
Sure.
What is bullet wipe?
Bullet wipe is the residue, basically it's grease and dirt that is on the outside of the bullet. As it goes down the barrel of a gun, it will pick up this grease that lubricates the bullet and whatever dirt happens to be there. Then when the projectile goes through the air, it carries that grease, dirt with it. If it hits a target, for instance, a shirt, skin, it'll wipe that grease off, and we call that bullet wipe. It's black dirt grease.
Okay, and you as a forensic pathologist have had with your over 2,000 gunshot wounds, you've seen bullet wipe on skin, correct?
Yes, ma'am.
Does bullet wipe come off skin easy?
Yeah, you just wipe it off. It's grease. It's like working on your car and you get a little black grease on your finger. You just wipe it.
Okay. And that's how it reacts on skin, correct?
Yes, ma'am.
Okay. And you also, as a forensic pathologist, deal with what is called gunshot residue, correct?
Correct.
And do you, as a forensic pathologist, when you have a gunshot wound in front of you, usually know at the time, you know whether or not there's been test shooting on fabric to see if the purported gun that killed somebody is 2 feet, 3 feet, 2 inches, 3 inches away? Do you normally have that at autopsy?
Have the information in advance of the autopsy?
Yes.
The objection is overruled.
I don't recall ever in my career having the test firing results prior to performing an autopsy examination.
And why would that be, sir?
Because usually the autopsy is done hopefully the next day, and if not, then maybe a couple of days later, and they're not far enough into the investigation of a case to have a weapon, let alone get it into the lab and get it in line to be tested.
So what do medical examiners do then to determine possible ranges of gunshots if they don't have the test firings from a GSR spread pattern?
Overruled.
We are trained in the practice of interpreting residue. It's a very good estimate. It's not exact, but within a certain range of fire, for example, 2 feet, you'll get little pieces of partially burned and unburned gunpowder that will stick to whatever the surface is. If it's a shirt, they'll stick to the shirt. If they're the skin, they'll hit the skin and cause little abrasions. An abrasion is like you fall on the sidewalk and skin your knee. That's an abrasion. The powder particles do the same thing, except they're really small. So since they're small, they're pinpoint, we refer to that as stippling. So if you have just that stippling pattern, we get a range of fire out to maybe a couple of feet, 24, 26 inches. It's not exact, but a couple of feet. You get closer into maybe a foot, closer than that, you'll also get the smoke, because what is a bullet but gunpowder, and that catches fire. So it burns, you get smoke. So if you get close enough, you'll get the smoke. That occurs within maybe out to 12 inches down to contact range. And that's our experience. We can also interpret directionality if there happens to be gunshot residue on a body or clothing.
All right, so you can tell then whether something is an intermediate shot or a long-range shot or even a contact shot, correct?
Yes, ma'am.
But you can't tell direct distance. Is that what you just said?
The one point I should make is in what's called a long-range or a distant-range shot, that assumes that there's no intermediate target. For instance, if I had a gun and shot it through this screen, then whatever gunshot residue would be on the screen, not on what I was actually shooting at. So if you ask me if there's no intermediate target, yes, I'm comfortable saying that's a distant range shot.
Okay. All right. And then in terms of scenes, do you go to scenes as a medical examiner?
I did routinely. When I was in training, we went to every suspicious death scene, every homicide scene. I actually had 5 years of training in doing scenes before I took my job outside of the medical university. And when I was in Mobile, we went to every homicide scene, every suspicious death.
Now, you did not have the luxury or the time of seeing the BMW in this case, correct?
No, ma'am. I did specifically ask to see that and was informed that it wasn't available.
Okay. Did you go to the Boston Police Department laboratory?
Yes, ma'am.
And what did you view there?
I looked at several projectiles, bullets. I looked at clothing that was packaged and looked at a small fragment of glass. And then later on went to look at the 4Runner.
Okay. And when we say the 4Runner, you mean the Toyota 4Runner?
Yes, ma'am.
Okay. Did you view video of the scene of the shooting?
Yes, ma'am.
And did you actually visit the scene?
Yes, ma'am. Retrospectively, I went after the fact because obviously 5 years later it's not there anymore for me. The vehicles aren't there.
Okay, so you actually saw the intersection of Chalmette and Tremont?
Yes, ma'am.
Okay. I'm trying to get rid of my New Jersey accent when I say Shawmut. All right. So let's talk then, sir, about, by the way, you also went to the medical examiner's office, correct?
Yes, ma'am.
What was the purpose of that visit?
I wanted to look at the x-rays directly. What I saw, I had some questions about, so I wanted to make sure that what I saw on the x-rays that I received was actually what was there.
And what do you mean by that?
The x-rays were really dirty. There was a lot of material on the plates or on the images that weren't projectiles. So when you're looking for at an x-ray for a bullet, you're looking for something that appears white. And these had a lot of white little dots here and there all across the film. And I'm interpreting that as artifact because I don't believe it was real. And I kept seeing that repeated pattern in a lot of places on the.
Okay. And were you able to tell what was real and what wasn't after you compared the originals with the copies that you had?
Well, they were showing me the same thing, so I know what was a artifact. I could see, okay, this is a repeating artifact versus this is a projectile because the views are a little different.
Okay. Now I'm going to show you, Doctor, getting to the autopsies, what was marked last week as Exhibit 376. And I don't know if you can see that. Did Jerry see that? Okay. You've seen this, correct?
Yes, ma'am.
And you created it, correct?
That's correct. I didn't create the underlying animation image, but from the existing image that was a screen capture, I captured that image and then put it next to the black and white version on the right.
All right. And the screen capture was a screen capture of what the prosecutors had done as a movie exhibit?
That's my understanding.
Okay. And then on the right, what is that?
That's the wound as it existed in reality.
Okay. And I'm going to show you today additional pictures regarding that specific wound. And while I'm finding those, could you tell the jury of what wound that specifically is?
That is the wound to the right upper arm at the shoulder area in Mr. Furtado.
Approach your arm.
You may.
Dr. Downs, I'm going to show you right now what's been what hasn't been marked, but it's 1, 2, 3, 4, 5. I'm going to ask if you recognize this.
Yes, ma'am.
And then I'm going to show you a separate one that I'm going to ask to be marked later for identification. I'm going to ask if you recognize that.
Yes, ma'am.
Okay. May I have the first 5 you want to mark? And then this for exhibits and the second one for identification.
The first 5, are they all relating to the
Yes.
same wound?
Yes, they are, sir.
Then why don't we mark them with letter designations, 384 A through F, E.
Each 4 inches for identification?
Yes, ma'am. What, a diagram? Very good. No objection, Mr. Lee?
Not for identification.
All right, doctor. Let's discuss first this wound that was discussed last week with the jury, and that would be the wound on Mr. Furtado's arm, right arm. Okay?
Yes, ma'am.
All right. So I'd like to draw the jury that attention. All right. I'm going to show you what is been marked 384A. Jury see that? Okay. And doctor, what is that?
This is the wound to the Mr. Furtado's right arm that we were just talking about at the upper arm shoulder area.
Okay. And that's in black and white, correct?
That's correct.
Okay. And I'd like to show you the second exhibit, which is 2 photographs. And can you see that all? And what is this, doctor?
This is the same area, the same wound that we're talking about on the left in black and white, and then a close-up of that same injury in color.
Okay. And you focused on this wound, correct?
Yes, ma'am.
And why did you focus on this wound?
This wound is, to my interpretation of the case, one of the more important injuries in that it gives me the position that Mr. Furtado had to be in, relative position at the scene when this shot was inflicted.
Okay. And there's a close-up photo of that wound that you just identified, right?
Yes, ma'am.
All right. I'm going to show you what's been marked 384C. Do I have that positioned correctly?
Yes, ma'am.
Okay. What is this?
This is a extremely close-up photograph of the same injury we've been talking about.
And why was this close-up photograph important to you, sir?
The area of abrasion that is at the 4 to 5 o'clock border. Can I mark on the screen?
Yes, this is a telestrator, so you can actually draw on it, and we can erase it, or we can print it out.
So the area I've just indicated in yellow is what's called an abrasion border. If you remember, I described abrasions. You fall on the sidewalk, skin your knee, that's an abrasion. Well, as the bullet goes into the body, it does the same thing. It rubs against the skin surface. And I can look at an abrasion border and get an estimate of the directionality as that bullet entered from looking at that. I know based on where that abrasion border is, that bullet had to be traveling, as we're looking at this, up and to the left.
Okay, and on me, could you just show me where?
Your Honor, may I step down?
May I approach? Just show where on me.
It's going to show directionality on you. All right, you may.
Thank you, sir. So, again, as that's directed, it's roughly, make it easier, roughly that general direction.
You want to see that? This one? On the directionality?
I'm fine.
All right, thank you. All right. And is that directionality going to be important in any wound reconstruction to get shooting reconstruction?
Yes, ma'am. That to me allows me as a forensic pathologist to look at the wound and position the body, because bullets travel in straight lines unless something else happens. For instance, if you hit concrete, a bullet might deflect. Okay. So bullets generally travel in a straight line. So if I see this and I see another injury, generally that's going to be a straight line. But that doesn't mean that if I have a part of the body that moves, like an arm, that when I do the autopsy, those 2 points are my straight line, because I have to move in the arm, I have to move that point to get the right straight line.
Okay, so we're going to show you the next exhibit, which is 384E. And I think I have this here. What is that? And we have to clear this. Okay, all right. getting the hang of it for 6 weeks. What is that?
If you could rotate that 90 degrees clockwise, other way. Thank you. So this is the same injury that we were just looking at. This is taken from the body, which is, he's on his belly, and the shot is taken from the back, looking down on the body. This is a close-up cropped image of that right upper arm shoulder area, and there's a trajectory rod that's been placed along the wound track.
All right. And let me just show you the next exhibit, which is a more, the right side is the actual autopsy photo, Dr. Downs?
That's correct.
And the left side is what?
This is from the animation that was done, shown in court Friday.
Okay. And what is wrong with the animation?
Well, you can look at the...
Sustained.
What is different from the animation portion that is shown here from the actual trajectory rod that is trying to show trajectory in the autopsy picture?
Well, the first thing I notice is the path is incorrect. If you look at them, those two rods are not level. They should be parallel if what you're trying to show is the same thing that's on the right. Now, the body's turned a little bit, so I can understand that, but looking at the right arm wound that we've been talking about with the trajectory rod, you can see the skin there. If you look close at the close-up, it's pushed up. There's tension on that skin.
And what does that mean?
That means that the arm, as Dr. Lindstrom testified Friday, she moved the arm to put the rod in, and that's an important consideration in this case. She said correctly that you want to go very carefully with the rod so you don't damage tissue. So it's typical that if you've got something in an arm and you're trying to line it up, you move the arm. Typically, you take a photograph of that to show this is how this arm had to be positioned to get the body, to get that rod into the body. That didn't happen here. So the arm, for some reason, was moved down.
I'll see you at sidebar.
Welcome back to the Law News Network. I'm Beth Karras. We are listening to the testimony of a defense witness, Dr. James Downs. He's a forensic pathologist with extensive experience. He is being examined by Linda Kenny Bodden, who's a defense attorney, but she has expertise in forensics. Her husband is Michael Bodden, the very renowned forensic pathologist who was medical examiner in New York State for years. Now, there's a sidebar right now, so let me just tell you where they are. He's gone through his background, and he's now talking about the gunshot wounds in Furtado and De Abreu, the two deceased victims in this case. And he is talking about the directionality of the bullet as it entered the bodies. And he was looking at one of the wounds in the right upper arm. I think it was a Furtado, but he's been talking about both. And he said that the abrasion border on a wound will help determine the direction the bullet entered and also the angle. He took issue with the prosecution's animation that they used, saying that the paths were incorrect on the animation. They put these rods in the animation to show, bullets travel in a straight line unless they're deflected. They hit something that causes them to go off. And he said that the paths were incorrect on the animation, and it was soon after that they took a sidebar. So we're waiting for that sidebar to finish, and it is actually finished. I was just about to go to a break, but let's go back into the courtroom for a more direct examination of Dr. James Downs.
The skin tension that we talked about right here indicates to me that that rod wants to travel upward.
And what does that mean for positioning of the arm?
That means that I would need to move that arm up away from the body until the rod gets to the alignment. And actually what I would do is I would start that way to not create an artificial pathway. So I would lift the arm and work the rod in from the exit until I got to that point, and then I would move the arm up and down until I got it to the right, and then when I dropped the arm, I would get something that looked like this.
Okay, so you would, was your testimony, you would move the arm up and so the skin is not pulling?
Yes, ma'am.
And when the skin is not pulling, what does that mean?
That means I've approximated the actual trajectory of the shot in that part of the body and how the body was positioned as it went through.
Okay. Now, just make sure I don't walk away with exhibits. Let me show you two more photographs. I'll do three. Have you seen these, sir?
Yes, ma'am, I created, except for the last one.
And the last one is what? Just
that is a photograph of the head wound.
okay.
Mr. Furtado. The back head wound, there's two to the head. This is the back one.
Okay. Your Honor, could I have the first two marked as a set and the second one marked separately?
No, I haven't seen it.
All right, any objection?
To two of them, Your Honor, not to the third.
Let's see you.
Welcome back to the LawNewz Network. I'm Beth Karras. Well, that was a short bit of testimony before yet another sidebar. Here's what I think could be happening. Dr. Downs had prepared a report that the prosecution got a copy of, and that is required whenever either side is calling an expert and the expert prepares a report. The other side gets the report in advance so they can prepare the cross-examination and maybe prepare a witness who would testify in rebuttal. And the prosecution, in a hearing this morning before the jury came in, talked about Dr. Downs, how his initial report was long on observations and short on opinion, and he's obviously being called to give an opinion. We haven't heard his opinions yet, although we did hear him say the prosecution's animation was wrong. I have to believe that he's saying things right now that the prosecution wasn't prepared for, such as challenging the accuracy of their animation. Maybe that's not in his report, and so they're taking issue with this and grappling with it at sidebar. Because there was such a short time period between these two sidebars, I just have to believe that the prosecution is hearing things that they were unprepared for. He did supplement or amend his report over the weekend. We don't have the report, so I can't tell you what the differences are, but the discussion during the hearing before the jury came in this morning dealt with his observations of the shirt that one of the victims was wearing, and the bullet holes in the shirt and some of the forensic evidence, and that there was enough, the state said, Commonwealth said, for them to cross-examine. Like they understood, I guess, where he was coming from so they could properly cross-examine him. So we're going to take a break until this sidebar is over, and hopefully they will iron out whatever it is they need to do with so Dr. Downs finishes direct examination. They usually take the lunch break and within the next hour for sure, but probably within an hour, maybe even less. So perhaps the judge will break after the direct examination and before the cross. We'll see. Anyway, we're going to take a quick break. We'll be back as soon as Dr. Downs resumes his direct examination.
test.
Sustained.
Did you come to some conclusions about how Mr. Furtado had to be positioned, yes or no?
Yes.
Okay. Were they easier demonstrated by using, did you also get an exemplar shirt?
Yes, ma'am.
And by an exemplar shirt, what do we mean?
It is a shirt that is the same brand, same size as what Mr. Furtado was wearing. And what I did was take the measurements from the photographs and then took blue duct tape so it was highly visible and put those where the bullets, the defects, the holes in the shirt are located.
And from somebody wearing that shirt seated down, can it be better be determined and easier for the jury to see what the position of Mr. Furtado was through that shirt and being seated?
I would think so, yes, ma'am.
Would it create no misrepresentation?
I don't see how it could.
Okay. Based on your analysis of how the wounds, right?
Yes, ma'am.
Okay. Have this marked for identification, Your Honor. This is the shirt?
Yes, ma'am. Let me just see the back. Yes, ma'am.
That'll be received triple I, quadruple I.
Now, Dr. Downs, just stay there for the moment. You said that you positioned the duct tape where the holes or tears, as they've been described by others, are in Mr. Furtado's original shirt.
Yes, ma'am.
And you saw the original shirt at the lab, correct?
Saw it, photographed it.
Did you make measurements?
Yes, ma'am.
Okay. Your Honor, may I have Mr. Favors put this on?
No.
May I put it on?
No.
All right. Your Honor, can we have a sidebar on this?
Yes. In fact, why don't we give our jurors a little bit of morning recess?
Welcome back to the Law News Network. I'm Beth Karras. We've been listening to the direct examination of Dr. James. He goes by Jamie Downs. He's a forensic pathologist who's a defense expert in this case, and he's talking about the directionality of the shots fired at the two victims, Furtado and De Abreu. How this is going to help the jury determine that it had to be Bradley who fired as opposed to Hernandez, because that's the defense's position, that Bradley is the shooter, I don't know. Because it's not as though Hernandez and Bradley were in different vehicles, or, you know, one's outside, one's in a car, one's on one side of the car, one's on the other side. They were both inside a car, a Toyota 4Runner, which was to the right of the BMW where the 5 victims were. 3 were killed, 1 was shot, 2 were not actually injured, but there's 3 attempted murder counts for those 3 guys in the back seat. So I really don't know how this directionality is going to help show Bradley was a shooter, unless they're simply poking holes in the prosecution's witness who talked about the same stuff. This witness has already said that the Boston Police Department's animation video about the shots and the paths, the trajectories, was wrong. So maybe they're just going to try to pick apart some of the Commonwealth's witnesses, which is okay to do as well. But their theory, the defense theory, is that Bradley, the driver of the Toyota 4Runner, closest to the BMW, had a beef with the guys in the car next to him, to his left, and that he's the one who shot into the car, not Hernandez, who, according to Bradley, fired over him, over his body from the front passenger seat, and that he, Bradley, leaned back in the seat, and that he did not know, Bradley said, as a star witness for the prosecution, that Hernandez was going to shoot into the car, maybe menace them, threaten them. You know, under New York law, it's called menacing. You know, when you threaten somebody, threaten to hurt them, but nothing more than that. Maybe that's what Bradley thought Hernandez was going to do, pull out the gun and just wave it around and threaten them, menace them. So we'll see in closing arguments, which could take place as early as tomorrow. Since they've already had their charge conference, they've gone through the jury instructions, which usually, well, can often take several hours. There was a dark day yesterday for the jury, so the judge used that time with the attorneys to hammer out the charges. So after the evidence is in, I mean, the lawyers should have been working on their closing arguments all along. I used to keep a file and keep notes so that, you know, you can put it together really fast. Sometimes, you know, in your run-of-the-mill case that isn't being streamed or televised and isn't, you know, high profile and isn't a murder case, as the bulk of trials are, you know, sometimes you got to get up within an hour and do your summation. There's no give me overnight judge to prepare it. Well, they had taken a fairly decent break before Downs took the stand to set up for him, and I thought that was the mid-morning break. But about 4 minutes ago, the judge said the jury hasn't had their morning break, so let's give it to them now. They'll have a break now, and then lunch will still follow soon after. I find that this judge doesn't go another hour after giving them a morning break. Then again, the judge can do whatever he wants, so he doesn't necessarily have to follow the routine he has been following. So we're going to take a quick break while we wait for a court to come back, and also for my next guest to arrive, a former colleague of mine from Court TV. He used to be a correspondent with me, so Michael will be joining us in about 10 minutes. Stay tuned. Welcome back to the Law News Network. I'm your host today. Beth Karras is my name, and I am joined now by my former colleague from Court TV, Michael Bryant, a practicing attorney now.
Yes, and still, yes.
All right, you
Yes.
always stayed licensed, so did
Oh,
I.
yes, why not? Yeah.
So you do your CLE, I don't. I haven't practiced
Yes,
for a
I
while.
do.
But I may. You know, let's talk about a case that's coming up. Court TV. LawNewz Network is going to be streaming a trial that is supposed to start later this afternoon. They're finishing up jury selection now in northern Arizona. It's a trial of a man named Stephen Jones, a young man who's charged with murder, but he says he shot and killed someone and shot at others in self-defense. Always an interesting case when self-defense is the defense. Is it a crime or not?
You know, in this case, it's going to be something that so many parents can relate to, because this was a kid that was trying to get into a fraternity, so he's going through that whole process. I don't know if you did the Greek life when you were in school. I was not a Greek life guy.
No, I was at Mount Holyoke. I was at a women's college.
Okay, so just wasn't my thing. Wasn't interesting to me. So here you have, you know, parents who send their kids off to college, and this guy now, as part of this process to get into a fraternity, is caught up in what was first a big party and then turned into a bit of a brawl, which he says led him to believe he feared for his life, and therefore he just happened to snatch a gun he had in his car, because doesn't every 19-year-old have a Glock in their car, you know, in northern Arizona? I don't know. But he grabbed his and used it because he said he had to defend himself.
And killed?
And killed one gentleman and wounded 3 others. And it's been a very interesting pretrial process. You know, there have been so many hearings, motions in limine to limit some of the evidence, and also an attack on the grand jury indictment itself, which is a little bit bizarre. I don't know what you're going to gain trying to attack that at a pretrial stage, except I think to maybe educate the community and even the judge as to what you think your problems are.
Well, I do know from having presented a lot of cases in the grand jury, because that's what we do in New York. Some states, the norm, like in California, is to do a preliminary hearing, let the judge decide whether or not probable cause exists. And yeah, I think there is a good argument that grand juries are a little archaic, and maybe we should be a little more transparent and have preliminary hearings instead. But you can get a lot of cases through the system if you do. We used to do like hundreds of grand jury presentations in a week. In any event, in a case like this, the defense wants its evidence presented at the grand jury stage, right? I mean,
of course, and
so
they really can't do much. Yeah,
I can see why, and they don't. I mean, I think it's probably discretionary whether or not you're going to put that defense on. I would put it on. Let the grand jury decide if this is a case that should proceed to trial. But maybe they didn't do that here.
It seems like some of the information the defense wanted in that was not presented at the grand jury goes direct to the self-defense claim. It had to do with the position of the body of the gentleman who died, therefore giving some impact as to the trajectory of the bullet. Was a guy lunging toward the defendant? Was he standing upright? Was he fleeing? That was left out of the grand jury testimony. So their point was that the grand jury didn't get enough information, that if they had gotten the full story, maybe there would not have been an indictment. But to me, you tell me, I mean, this is, you know, we know an indictment is relatively easy at the grand jury stage. Do you really think sending it back to the grand jury is going to result in a no bill, that you're not going to get an indictment?
No, but it might satisfy them and, you know, take an issue out of the case for appeal. Probably not. But, you know, I was talking to a gun expert recently about stand your ground, because people make a big deal out of Florida stand your ground, and you're basically saying I was defending myself when I shot and killed, right? So it's a self-defense claim. And a lot of states, about 34 states, have a stand your ground law. And I had said to him, well, why aren't we hearing about these immunity hearings like Florida has for stand your ground? He said, because other states have a preliminary hearing or grand jury where you get to air it out earlier. You air it. So that didn't happen in this case. But you do get like 2 bites at it, presumably, at a preliminary hearing or at a grand jury. But in Florida, you don't. You know, they direct file cases. Wow. You only go to the grand jury if it's a capital case. That's all. Otherwise, they direct file. There's no preliminary hearing, no grand jury. I mean, I double-checked that with some Florida lawyers recently, where I'm headed in a couple of hours for a meeting tomorrow down in Florida. In any event, we will be joined, hopefully soon, by a reporter from Arizona who is in Flagstaff. We'll be covering the trial. He's going to Skype in so we can talk to him about the Stephen Jones case. But in the interim, we are still on a break in the Aaron Hernandez case in Boston. But we're going to take a look at some of the testimony from earlier today. They're about to rest all the evidence in this case. The prosecution rested its case in chief on Monday. The defense started presenting evidence Monday. It was dark yesterday. They're presenting a couple of witnesses today. And let's look at a witness who testified earlier today. His name was William Jacob Green. He was a digital forensic expert. He looked at the hard drive of the computer belonging to Brooke Wilcox, the girlfriend of Alexander Bradley, which is where Hernandez and Bradley went after the double murder in Boston. So listen to the searches he said he found. He also examined Bradley's cell phone. But in this particular clip they're about to play, he's talking about the hard drive of Brooke Wilcox. So this is AH2.
And talk about the work you did in this case. Did you have an opportunity to receive and examine a hard drive known to be from the laptop of a Brooke Wilcox?
Yes, sir.
Okay. Tell us quickly what you did and how you go about getting this information.
Yes, sir. The evidence was released and shipped to our office directly in Raleigh from Boston Police Department. We received a hard drive that contained what's called an EO1 image. It's an in-case forensic image. It contains all the data that was recovered from that drive, more than likely by the original law enforcement examiner.
So it's like a mirror hard drive?
It's similar, yes, sir.
Okay. Please continue.
Yep. We ran that that data through several different types of software. One would be access data. It's called Forensic Toolkit, FTK. We also ran it through a system from Magnet Forensics called Axiom.
Okay. And did your examination generate any report?
Yes, sir.
Okay. May I approach the witness?
You may.
I'm handing you a binder that's yet to be identified. Does this appear to be your report?
Yes, sir.
Okay. And is this of the computer that you did purporting to be Brooke Wilcox's computer?
Yes, sir.
Okay. I'd like to have this marked, if I may, Your Honor.
Welcome back. Well, we got out of that little piece of tape we were playing for you just now of William Jacob Green because Michael Kiefer is joining us now on Skype from northern Arizona to talk about the Stephen Jones case. They're just wrapping up jury selection. Good morning. It is morning for you, right, Michael?
Good morning.
All right, so what's going on? Did they finish jury selection?
Not yet. I haven't been over to the courthouse yet. They're expecting to finish by lunchtime and then start opening statements after lunch.
Why is it that they thought openings would be a week from now? Did they think it was going to take that long to get a jury, and it took a day and a half, if that?
Well, no. I think originally that estimate was probably my estimate, thinking that how are they going to seat a jury in less than a week for a major trial like this, a high-profile trial in which everybody knows everybody in Flagstaff. It was, my mistake thinking that it would take longer than that. I was kind of surprised on Monday when I called and the judge's JA said, well, no, we're going to do it in one day.
Well, swift justice, I guess, in northern Arizona. So what's the issue in this case? What's going on?
The question is whether it's murder or self-defense. Here you have a young man who was with some of his friends walking back from a party when they stopped in front of an apartment complex where a big party was going on. While they were standing there, the people inside the apartment complex apparently thought they were trying to crash the party, and they came out. Stephen Jones was punched in the face. They started running, and they ran onto campus. Stephen Jones ran to his car, which was parked right there, and got his 9mm pistol out of the glove compartment, and then walked over. The fight had moved along, and his friends were still in the middle of it. And he claims that that he went to help his buddies, and that he told everybody to stop, that he had a gun, and instead they charged him and he shot. Now the prosecution describes it as he went to his car and came back to the fight, with the intent of killing somebody or shooting somebody.
Okay, so self-defense is defense of self or a third person. So even if he weren't in imminent danger at the time, if he felt his friends were, maybe, you know, it's a viable defense, even though you're saying they charged at him and he fired. But I guess the prosecution is saying, well, he took the time after he's punched in the face or whatever. He takes the time to go get his gun, so he has time to reflect on what he's doing. He's walking away, he's retreating, you know, but he wants to go. His friends are still being beat up, you're saying?
I'm not sure that they were being beat up. They were being threatened. They were being hassled by this group of other students from. They were all mostly fraternity brothers, and it had been a fraternity party. The prosecution describes it in a way that it sounds like the fight was stationary and he went to his car and he came back. But if you understand what I mean, the whole melee was sort of moving towards, you know, in one direction. And so he went to his car, and he had like his key fob and his keys in different places. You know how sometimes they separate?
Yes.
And so he found the key fob, got in the car, and claims he was afraid for his life. Then he went out of the car and he walked towards where the fight was then. And then two of these other students, he claims, ran at him. And there is evidence to suggest that in fact they did. He said he had a gun. It had a light mounted on it. I doubt that the victims ever saw anything but the light. As they came towards him, he dropped them. One of them was killed, and the other one was wounded. Then he went over, he claims, to render assistance, and he was jumped by a mob. And then he started shooting blindly in the air, and he shot and wounded two other people. Then after that, he surrendered.
Okay, so what time of day was this?
It was after midnight. Now, one thing that's important to mention is that the victims were all highly intoxicated.
That was my next question. Okay.
The young man who died not only had a very high blood alcohol content, he also had traces of Xanax and marijuana in his system, and I believe two of the other victims tested positive for marijuana. This took place at a place. This apartment complex is technically off campus, but it's right across the street, and it is notorious for these wild parties. Just a month earlier, there was a man who had his head put through a window there during another melee there. So, and it was a place that the campus was aware of. That the campus had sent emails to the fraternities saying, yeah, we know that this is not a fraternity party, but everyone who lives there, is from one or another fraternity, and that these parties, they literally said, if it looks like a duck and quacks like a duck, it's a duck. That was just about a month before. So everybody knew that this was sort of a trouble spot. Curiously, none of that will be allowed into trial. The reputation of this apartment complex.
This must have had, just must have reverberated through Flagstaff. That's a small area, right? It's a small town about, 45 minutes north of Sedona?
About that, and 2.5 hours north of Phoenix. But Northern Arizona University is Flagstaff, and so yes, this would be a big deal. When it first happened, everybody wondered if this was another one of those instances of someone going berserk on campus. And then it turned out not to be, but it still left a lot of scars because the Northern Arizona University presence here is so strong that people have strong feelings about this case.
Well, we are going to be streaming it. We'll be following it closely. I hope that I have a chance to talk to you again. We're live again in the Aaron Hernandez case, so I do need to stop talking to you and let you get into the courtroom. But thank you so much, Michael Kiefer, for joining us today at LawNewz Network, and we'll look forward to your reports coming from the courtroom.
Thanks, Beth. For you, anytime.
Thank you. And in the Aaron Hernandez case, a witness has put on that shirt that is similar to what I think it was Furtado or De Abreu, I think it was Furtado, was wearing, and Dr. Downs is demonstrating for Linda Kenny Bodden, the defense attorney, where the bullets were entering and abrading the body. So let's go into the courtroom.
Or should all form a straight line.
And does that show why it's different? It looks like it's a downward trajectory when you're doing it anatomically, but an upward trajectory when you're doing it based on the headrest?
Yes, ma'am.
And is there any other position that Mr. Pavoris has to be? His head is turning this way?
No, ma'am. Again, we discussed earlier the back head wounds. The head would have to be turned roughly in the same direction as the arm wound to get those abrasion borders. Again, the exit would roughly be here. I can't say specifically because I don't have a location out in space, so I don't know if he's tilting down or tilting up. All I know is it has to be, the shot has to come in at a sharp angle of the skin and then exit the back 2 inches lower than the entry.
Thank you, Doctor.
Anything further, Ms. Kenny Bodden?
No, that would be it. That's it.
All right. Do you have any examination on this issue?
Dr. Downs, can you just return to that same position? You have no idea whether all of this was taking place simultaneously, correct? In other words, you don't know that his head and his arm were in that position simultaneously, correct?
No, sir. All I can tell you is that there are 2 head wounds.
Yes or no?
Okay.
This arm position would also be consistent with this part of the arm resting on the door frame with the window open, correct?
Yes, sir. All I can speak to is medically what we call the arm, so the forearm I can't speak to.
Thank you.
Well, hold on now. Let's understand. What does that mean?
May I step down again?
Would the arm have been like this?
The arm had to be up, so the arm would
Did it
be...
have to be extended, or?
No, sir.
I don't have any further questions at this point.
Okay. All right. Thank you. Now, Mr. Lee, as the result of what it is that Ms. Kenny Bodden would seek to present and what we've just heard as to the visual demonstration by wearing the shirt, do you have an objection?
I just have one question to Dr. Downs. Doctor, the shirt as it was being worn, are you suggesting that the shirt, the holes in the shirt line up with the holes in the body?
No, sir. There's actually a difference, I believe, as the measurements are in the autopsy report. It's 6 3/4 inches apart, and the holes in the shirt are about 8 inches apart.
So you don't know how the shirt was being worn on the day that the shooting took place? You just lined up the holes in the shirt based upon your measurements and put them on top, basically superimpose them on the holes as you observed them to be in Mr. Furtado's arm and back, correct?
No, sir. What I did was measure the holes in the actual shirt and looked at where the wounds were on the body. And based on that observation and how the body was placed, I know that the bullet had to go through the shirt sleeve first to enter the body. So the entry wound into the body is going to be more to the midline, and then the reverse on the exit. The exit is going to be closer in the body than it is on the shirt.
Well, I guess my question is, when the shirt is laying flat, do the holes in the shirt line up to the holes in the body?
No, sir, because you're talking about a 3-dimensional object versus a 2-dimensional.
Okay. So did you do anything to line up the holes in the shirt with the holes in the body? And if so, how did you do that?
I didn't do anything to line them up with the holes in the body because I didn't have the holes in the body to line up to. Instead, what I did was take the shirt and represent exactly where the defects are on the shirt to the best of my ability, and then look at the body. Knowing the body's 3-dimensional, I know that there's going to be possible movement of the clothing.
And knowing that the shirt can move on the body, and it can be in any number of infinite positions on the body, isn't the far more relevant evidence relating to your conclusions where the holes are in the body?
No, sir. Actually, we look at both. Typically, what a medical examiner will do is look at the body with clothing on, examine the shirts, see if there's defects. Oh, lift the sleeve up, there's a corresponding defect there. Taking the shirt off, there's a defect in the body, a corresponding defect in the shirt. Photograph the shirt so that you have the continuity of everything.
Would your opinion in this court today change in any way whatsoever if that shirt had been destroyed?
I cannot think that it would, but not having that option to look at, I couldn't tell you. I just know what I see.
Well, my question is, if you didn't have the shirt, would it detract in any way from the opinion that you gave in this court to this jury so far?
No, sir. I think it supports the opinions that I have.
Your Honor, based on that, I would object
Judge, I
to
just have two follow-up
demonstrative.
Two follow-up questions. Doc,
You still object?
Yes.
Be seated. Yes, ma'am.
Dr. Downs, did you see Mr. Furtado in the shirt at the time he was taken out by the medical examiner representatives at the crime day? Did you see pictures of that?
I don't know who took the body out, but yes, ma'am.
Okay, so you know how the shirt was worn in terms of the buttons and all, correct?
Yes, ma'am.
And how many were buttoned, unbuttoned?
There were 2 down from the top unbuttoned.
Okay. And, sir, you actually measured the shirt, right? To be
Yes,
able to
ma'am.
get the holes, right?
Yes,
So if the shirt didn't exist, you couldn't measure the shirt to get the actual location of the holes.
that's correct.
That's all I have.
Let me see you up here.
Welcome back to the Law News Network, everyone. We have just been in the courtroom for a brief period to watch a hearing outside the presence of the jury. The defense had wanted to put this exemplar shirt that Furtado, one of the deceased victims, was wearing on a member of the defense team. I mean, at first the judge said no, but he allowed it. So I'm talking to Michael Bryant, my former colleague from Court TV. So now we saw this, one of the men put it on. It wasn't Hernandez. And then Downs got off the stand, and he was demonstrating, where bullets were connecting, impacting the shirt.
Well, the defense wants this in to help support their expert's testimony that the angle, trajectory of the bullets came from someone other than Aaron Hernandez, obviously Bradley. So they feel that by getting this guy to wear the shirt to try to replicate the position of the vehicle the night of the shooting, they can convince the jury that it could not have been Hernandez reaching over Bradley and shooting from that angle. It was more likely the driver shooting from a different angle. So now the prosecution is saying, well, wait a second, there's so many variables that you can't control here. Right. This is crazy. So they're trying now in this hearing outside the presence of the jury to lay the foundation to allow this expert to rely on this demonstration. One of the key questions asked was, will your testimony change dramatically if you don't have this shirt to deal with? And he, of course, danced around it a little bit, but said, well, it reinforces my testimony.
We were taught years ago in the Manhattan DA's office to do a direct examination, a double direct, a triple direct, and you just get your witness to tell the same story over and over again. So they tell it as in a narrative form on the stand, and then they're back on one, and then you may have them use photographs or a diagram, tell it again, and then get off the stand and demonstrate, tell it again. So this is a way to get the explanation out again. But there was a sidebar, and they're back in court now. So. Let's go into the courtroom.
Ms. Kenny-Bodden,
Yes, sir.
For the demonstration purposes, you had a chair out here. Do you plan to use that again?
Yes, ma'am.
Why don't we get that in place? Sure.
All rise.
Ms. Kennybod.
Thank you, Judge. Dr. Downs, before we go to our break, you were talking about an exemplar shirt that we procured areas of the holes with blue tape, correct?
That's correct.
And that's from your measurements at the lab, correct?
That's correct.
Okay. We've had Mr. Favors put the shirt on. Now, Mr. Favors is about 5'10"-ish. Does that matter in this demonstration to determine the angulation and trajectory of the horse?
No, ma'am, not really.
And he's about 185, we understand. Does that matter in the angulation and trajectory of the horse?
No, ma'am.
Could you sit down, sir? And may I have Dr. Downs come?
You may, and ladies and gentlemen, I'm permitting this, what we would call a demonstration, insofar as it assists you in understanding the expert or the witness's testimony, and to the extent it assists the witness in explaining his testimony and the basis for his testimony. So understand this is simply to be considered much like any other demonstrative aid, to the extent it helps you to understand the evidence as it's being presented. Doctor, you may step down. Watch your step, please.
Dr. Downs, we've had Mr. Favors unbutton the first two buttons. Is there a reason for that?
Yes, ma'am. In the photos that were taken in the crime bay, the top two buttons of Mr. Furtado's shirt were unbuttoned.
Okay. So would you tell the jury again now what these two blue pieces of tape are?
The one on the sleeve represents the site of the entry defect on the right sleeve of Mr. Furtado's shirt, overlying the area where the skin entry wound was.
Okay.
And then the other is the corresponding exit.
Now, because the trajectory goes upward through the headrest of the BMW but appears downward on the autopsy table, could you explain how the trajectory would be for somebody who was alive when they were hit with these shots?
I would need to position him first. Is that?
Please do.
Okay. Starting with the arm wound, there's that abrasion border at the 4 to 5 o'clock margin. So that tells me the bullet has to be traveling in that direction, which would be directed upward as his body. You could put your arm palm forward. This is what we call anatomic position, although it's not exact because he's sitting down. You would be standing toes forward, palms forward, straight ahead. But having him seated, this is the best I can do. It's pretty close. So that shot would then be directed upward.
When you say that shot, what are you pointing to?
That's the entry wound into the right arm. It has to be going upward. Well, I know that the same shot exits lower, so that doesn't make any sense. The only way to get those to line up in the body is to take the arm, lift it until those two shots, the entry and the exit, line up. It makes a straight line. 2 points form a straight line. Okay, so as the trajectory rod demonstrated, that's the path through the body. Now, in the scene, looking at the headrest has a trajectory rod that's going a little above horizontal. In order to account for both of those, I have to get his body into position. To do that, he's got to be leaning right far enough to get that shot, the entry, that shot, the exit, to then correspond with the same angle in the headrest. Another way to look at it is if I have just the headrest, I work backwards from that fixed angle, those two spots in the headrest, and I go back to the body, and I then work, that point has to be with that point. So I have to connect this line in the body with this line in the headrest.
And what about the angulation of his head?
Again, the head, the back...
The jurors can't see over there.
Sorry. Put your hand down. Okay, up. Thanks. And again, that's roughly where I had it before. If you remember, we talked about the back head one. Can you turn your head? There was an abrasion border at about 3 o'clock. That tells me the bullet is traveling out in space towards the right side of his head. It's a prominent abrasion border, which means it's a skinny angle. It's a narrow angle. In order to do that and exit about 2 inches lower in the back, left back of the head, again, I have to line those shots up. So it has to come in basically with him looking to his right hand. If you can just open a hand, like palm out, that's the best, again, I can do for anatomic position. So hand out like that, abrading the skin here and then dropping 2 inches through his head and exiting the back.
Thank you, Doctor. Thank you, Mr. Rivers.
Now, Mr. Favors, does the shots in the back of the skin line up to the clothes?
Yes, ma'am.
All right. Is there any differential?
There's a little bit of difference. If you think about it, I'm wearing a jacket. If a bullet came in my jacket and was headed to my left, I would expect the entry wound to be a little inside. Those shots in the shirt, the defects in the shirt where the bullet went in, went out, those are separated by about 8 inches. The measurements from the autopsy separate those from one from another by 6 3/4 inches. Again, that's in the area what I expect it to be.
All right. And is that normal when you interpret wounds in a forensic pathology basis to have the clothes not exactly where the shots are?
Well, what we do is we start with the clothes. So when I get a body, it's clothed, and I look at the clothing to see if there are holes. And then the first thing I would do is look under the clothes to see if there's an entry wound there. And it would, again, if it enters, it's going to be a little more, in this case, to the midline than the shirt.
Okay. So Mr. Furtado's arm has to be out. What about the lower portion of the arm? Where's that?
I can't tell you specifically. We were demonstrating anatomic position with the arm out. So I can place the upper arm, what we call the brachium. I can place that. I don't know where the forearm was. It could have been all the way out, could have been anywhere into touching his chest.
Okay. But you can't tell that, but you can tell the arm had to be up.
Yes, ma'am. The arm had to be up.
Okay. Now, let's move on to Mr. Debreo, okay?
Yes, ma'am.
All right. Where was the wound pattern on Mr. Debreo?
He had 2 entry wounds to the right side of his chest. Wound A was up at the area of the armpit. Wound B was just at the side of the right areola, the outer part of the nipple.
All right. And after reviewing the autopsy report, did it have a wound track that you observed?
There were 2 wound tracks.
All right. One was what?
One basically went through the one near the armpit, went through the body, got the 4th rib on the right, and the left 3rd rib, both of those on the sides, and then continued from that point through the left arm to exit as wound D.
And what is the second wound?
The second wound track?
Yes, please.
Second wound track starts as wound B, just by the right nipple. And that one has a kind of an interesting course. Anatomically, the nipple is located in males at about the 4th intercostal space, between the 4th and 5th ribs. That shot is described in the autopsy as going up to the 2nd rib in the front, then going through the mid part of the chest, crossing over to the side of the left 2nd rib. So from the 4th rib, 5th rib area, it goes up to 2 and over and out 2 on the opposite side.
Have you ever seen the wound like that before, that goes up and then makes a sharp turn?
I've seen wounds follow unusual paths, but not quite that unusual.
Okay. Were you able to, though, even with that unusual path, position Mr. Debreo's arm as to the shots?
Well, yes, ma'am.
And how was that?
Well, we know because he hits the armpit, the shot has to have access to that area. The simplest way to account for not hitting the arm is to move the arm out of the way. He's in a motor vehicle in the driver's position. I would infer from that his arm is somewhere up or near the steering wheel. It's out of the way, but it has to be up out of the way.
It has to be out of the way so the bullet can enter.
Correct.
All right. And what about the left arm?
The left arm is a little more complicated because of the measurements in the autopsy and the documentation in the autopsy. Do I need to get in that further?
No. Just tell us why. What your conclusion was.
My conclusion, based on everything that I know, is that arm has to be also up.
Could it be resting on the window?
Yes, ma'am.
Okay. But both arms have to be out of the way so the shots could both enter and exit without hitting the other arms.
That's correct.
Okay. Is that the easiest way to explain it to the jury?
Yes, ma'am.
Okay. Now, before I'm going to come back to Mr. DeBreo, but Mr. Freire, were you able to determine the positioning of his arms at the time that he was shot in the right arm and grazed in the left arm?
Yes, ma'am.
And what was that position?
That position was with the hands extended forward between the headrest area, forward from his body.
Okay. And can you determine anything else besides they had to be forward from his body? Can you determine whether one's up like this or one's like this or what?
I can't say specifically. I can tell you that, again, back to Mr. Furtado's shot that goes through his arm, back, headrest, that then has to go into Mr. Freire's right arm and lodge there. That fits everything. So his arm has to be, just continue that line through the headrest toward the middle of the car. That right arm has to be wherever it is in that plane to catch the bullet.
And what about the graze wound on the left arm?
The left arm, because it's a graze wound.
What is a graze wound? Let's tell the jury what a graze wound is.
A graze wound is where a bullet rubs across the skin as it doesn't enter into the body. It goes along the surface and causes an abrasion.
Okay. And because of the location of the wound was inside his arm, his left arm? Where? Could you put it? You can't see because of that screen in front of you. Could you just like move out if it's a judge? Is it okay if he just moves out so they can see where the arm is?
Yes. Thank you, Madam. Basically, it's shown here in the medical records on the front of the the left forearm.
Okay, it's inside, correct?
That's correct. That would be anatomically the front, but when you turn your arm, that would then become the inside.
And is a graze wound different than an incised wound?
Yes, ma'am. They're completely opposite.
Medically, they're used differently?
Yes, ma'am.
What's an incised wound?
An incised wound, think of a doctor making an incision into the body. It's a cut. So it's a sharp and edged thing. For example, glass might cause an incised wound. An abrasion is blunt force. So think of a baseball bat or something like that. Those cause different types of blunt force injuries, bruises, abrasions. A bullet causes an abrasion also if it just goes on the surface.
Okay. But it does not cause an incised wound?
No, ma'am. They're completely distinct from one another.
Okay. And then, sir, based on the fact that you were able to discuss the wound patterns of both Mr. Furtado, Mr. DeBreo, Mr. Freire, were you able to determine whether or not there could be 6 shots here?
Yes, ma'am.
Why?
Because I look at the bullets and accounting for the bullets and the damage to the vehicle, my opinion is there had to be 6 shots.
Why is that?
Well, it's simple math. We can account for 1 bullet in Mr. Furtado's head. We know another bullet went through Mr. Furtado's arm, headrest to Mr. Freire. That's 2. We know that 2 went into Mr. Abreu. That's 4. We know that another one went into Mr. Furtado's head, fragmented. That's 5. And there's a defect in Mr. Abreu's headrest that's not accounted for by any trajectory. We also have the graze wound to Mr. Freire. So either one of those could be that 6th shot.
So hypothetically, sir, let's assume hypothetically that if a piece of lead fragment left Mr. Freire and came across and was responsible for the graze wound on the left, Mr. Furtado was responsible for the graze wound on the left arm of Mr. Freire, would you still need another shot?
Yes, ma'am. Again, there's 6 shots. If one of the pieces of a projectile from Mr. Furtado's head came out, hit Mr. Freire's arm, that's going to be traveling at fairly low velocity, fairly low speed, because in order to pass through bone, and this would be bone at the back of the head, the thicker part of the skull, and then directly at the back part of the head, which is the thick part of the skull, you're going to lose a lot of energy from that bullet. It would probably fragment, and so you might get pieces of bullet passing at fairly low velocity. I would not expect that to do more than cause that abrasion, that graze.
Welcome back to the Law News Network. I'm Beth Karras, and I'm with you for another 15 minutes, and then I'm going to turn over the host chair to a new colleague of mine. But in the next few minutes, while they're at the sidebar, I'd like to continue to talk to my former colleague, Michael Bryant. Dr. Downs just said that there had to be 6 shots that were fired, and that has been an issue in the case, whether it was 5 or 6 shots. The tattoo that the prosecution made a big deal out of wanting the jury to see, because it kind of, the tattoos on his body, some of them obtained after the shootings in this case, and after the shooting in Florida of Alexander Bradley, a witness the Commonwealth says he was trying to silence, and who became a star witness for the prosecution, has the chamber of a revolver with 5 empty rounds and 1 loaded. He just said, as a defense witness, there had to have been 6 shots fired based upon his view of the forensic evidence. And that obviously is not something the Commonwealth agrees with.
Right, and obviously it confuses the issue, if nothing else. And again, it's a defense expert. Confusion is that's their stock and trade, if nothing else. You know, they don't necessarily provide all of the answers, but they certainly make you question what's out there, and that may be his goal, his function in front of this jury. You know, I have to tell you, Judge Locke, he's really very entertaining. Can I do my Judge Locke impression?
Yes, sure.
Well, that is overruled as to the form of the question.
Very good. I like that.
He's very
Note
good.
the time code.
He takes care of his jury, and we saw they went to sidebar to decide whether this expert could even testify to the extent that the defense wanted, with the whole shirt, all of that. Obviously, he decided that the expert could use the demonstrative human being wearing the shirt to try and solve some of these questions.
You know, typically when an expert renders an opinion, we hear the questions fashioned in a certain way, and then, you know, they talk about a lot of what they found, what their own investigation review of the documents, videos, every testimony was, and then based upon all of this, do you have an opinion about the number of shots that were fired? Yes, I do. And what is that opinion? I didn't hear that here. He just said there had to be 6 shots. I don't know if there's an objection to the form, but there is a way that you should elicit these opinions. The objection is probably something more than that. However, that did jump out at me.
And there may be no foundation for that, and that may be a problem.
Yeah, maybe they didn't expect him to say that. Again, we don't have his report, so we don't know the extent, to what he says he's going to opine on, and maybe this was outside what he said he was going to opine on. And he really should be sticking to what's in the report, the parameters of the report. Now, he is on to De Abreu, the other victim. He's talked about Furtado. He's talking about De Abreu now and the chest wound. He said De Abreu's arms had to be up, and then he said there had to be 6 shots, and the next thing you know, we're in a sidebar. Now, it is 12:47 on the East Coast. I would expect the judge to take the lunch break soon. Are they still at sidebar, or are they back in court? Are they still? They're back in court. Okay. Let's go back into the courtroom. Now, it's possible that I won't be sitting here, depending upon how long this next stretch takes. If so, I'll be back next Wednesday. It was great spending the past almost 4 hours with all of you. So let's go back into the courtroom for continued testimony of Dr. Downs.
May I approach him? Thank you. Doctor, I'm going to show you a diagram. Do you recognize that?
Yes, ma'am.
Okay. And what is it?
That is a reconstruction that I did of the interior of the BMW, trying to place the individuals in the vehicle as best I can.
With how many shots?
A total of 6 shots.
All right. May I have this mark as a chalk, please?
It'll be J.
Doctor, I'm showing you and the jury at the same time what's been marked as demonstrative exhibit JJJJ. Does this fairly represent your opinions as to the number of shots and the trajectory of the shots that were
that occurred?
Yes, ma'am.
Okay. And the yellow is what?
Those are the shots to Mr. DeBreo.
And then the blue shots are what?
Those are the shots to Mr. Furtado.
And then what is the orange shot, the orange line?
That is the 6th shot.
And that accounts for what?
That accounts for the total number of shots that I can reconstruct this scene shooting to represent.
And where does that shot go?
The orange?
The 6th shot, yes.
I believe that's the shot that grazed Mr. Friere's left arm and then continued and shattered the window.
Okay. Thank you, sir. Now, Doctor, there's been some other discussion of the autopsy report and concerning the serious nature of Mr. DeBreo's wounds. So I'm going to turn to that next, okay?
Okay.
Okay. Could you tell us, sir, given the nature of his wounds, what was the interval from the time of the shots until the time he lost consciousness?
That'd be a matter of seconds.
And why do you say that?
That shot, if you recall, went through both lungs, the right lung and the left lung. Right lung 3 times, also grazed the middle lobe, so actually 4 times in the right lung. Then went through the midline, getting the feeding tube, the esophagus, the superior vena cava, which is the big vein that brings all the blood back from the top of the body, and the aorta, which is the big tube that sends all the blood out of the body. Then went through the left lung twice to exit. So there's multiple reasons for that to cause issues for Mr. DeBreo. Start with the lungs. Both of those lungs are open chest wounds. So the lungs are both going to collapse because the lungs typically are inflated by negative pressure inside the chest. That's what keeps the lungs expanded. If you put a hole in that space, the lung collapses. You can't get air into your lungs as well. In addition, if you recall, there were 2 liters of blood, one in the right, one in the left. Blood is what causes us to carry oxygen, so that's an issue. In addition,
when you say carry oxygen to your brain?
The brain included, but all of the body. In this case, though, specifically the brain would be what I would be talking about loss of consciousness. So, again, it went through the aorta and the vena cava. So you're losing blood out of the vena cava, you're losing blood out of the lung defects, and you've got this injury to the aortic arch. That's where the vessels that lead to the brain, that's where they start. And so you're bleeding out of, and there's damage at the area where those arteries would go to the brain. So you're basically losing the ability to carry of oxygen because you can't inflate the lungs. You're lost blood that carries oxygen, and you can't pump blood to the brain because that area is damaged.
And that occurs in a matter of seconds, correct?
Well, all those injuries would occur simultaneously with the shot, but the loss of consciousness wouldn't be no more than seconds.
Okay. And when somebody loses consciousness, can they still actually appear to be taking breaths?
Yes, ma'am.
Is that well known in the medical community?
Yes, ma'am.
And what is that called?
Well, you would be unconscious, and then the machine of the body, that is the innervation that's causing you to try to breathe, would continue. Eventually, when you get sufficient loss of oxygen, you would have what we call terminal breathing. That is, your body is it's on the wane, it's on the way out, and so the breath change, and it might be seen as gasping or something like that, but you're long since unconscious.
And to the lay person, it could be seen as gasping and all.
Gasping, hiccups, basically.
But that's not real breathing.
It's an attempt to inflate the lungs that in this case aren't going to inflate for the reasons I said earlier.
And when that happens, somebody is already unconscious.
Oh, long since in this case.
And when you're unconscious, do you feel pain?
No, ma'am.
Now, Doctor, let's move on then from discussing death for the moment and talk about some forensics. Now, you have been involved in many scene reconstructions, correct?
Yes, ma'am.
Okay. And have you been involved where glass is reconstructed from a window of a car?
Yes, ma'am.
All right. And have you actually requested that that be done?
I can't tell you who specifically requested it. It's been, I've been doing this 27 years. I've seen a lot of cases.
Okay. And is it a laborious process?
Oh, it's tedious. Anytime you put things together, it takes a long time.
And did you pull out some from one of the textbooks that you utilize some demos of how that's accomplished?
Yes, ma'am. I believe, if I'm not mistaken, it's Henry Lee's textbook.
Henry Lee, the criminalist from Connecticut?
Yes, ma'am.
Okay. May I have these marked, John, as demo? Your Honor, now would be a good time to break. I think I'm finished. I just would like to look at my notes over lunch, but I think I'm finished.
All right. We'll resume at 2 p.m., please.
Welcome back to Law News Network. I'm Jesse Weber. We're taking a break here in the Aaron Hernandez double murder trial. I'm here today joined by Michael Bryant, an attorney. You might recognize his face from Court TV, am I correct?
That would be correct, or post office wanted posters, yeah, whatever.
Well,
I get around.
Sounds good. That's good. Well, very nice. Thank you for coming here to us. Now, we just took a break from the testimony of Dr. James Downs, or Jamie, as he likes to be called. Great bow tie, first of all.
Very nice.
Now, he's talked a lot this morning about his prior experience. He's talked mostly about the trajectory of the bullets during the 2012 Boston shootings that Aaron Hernandez is claimed to have shot Daniel De Abreu and Safiro Furtado. From what we just saw, it looked like we got a really big break for the defense in terms of the trajectory of the shots. In your estimation, is what he trying to say that it wasn't possible for Aaron Hernandez to make the shot as the prosecution claims?
That sounds like what he's going for here. He's done two things, first of all. The magic sixth bullet has surfaced again. And by surfaced, I mean it's been raised. Nobody's seen it. And I think what he's done there is, again, call into question the investigation, who did it properly, was it thoroughly done. In his opinion, there was a sixth bullet, no evidence that that's really been recovered. So that was number one, not a bad point. But the more important point, as you mentioned, is he's saying that from the trajectory, the arm of the shooter had to be so far extended outside the forerunner that it could not have been somebody in the passenger seat. I guess theoretically, if it were a very, very large person with a 7-foot wingspan, maybe they could have. But with the people involved here, Aaron Hernandez allegedly in the passenger seat and Bradley Alexander in the driver's seat, it had to be, in his opinion, the driver that could have reached low enough to create the trajectory that led to the fatal wounds.
Absolutely, absolutely. And if you're in the jury, this trial's been going on, it's, I think, the 24th, 25th day. You've heard a lot of different testimony, especially from experts. It's a lot to take in. How much are they actually taking in from what's being heard? I mean, he's been on the stand for a few hours now, getting into specifics. For you, if you're sitting on the jury, how much does it play for you?
Even worse, he's been on and off, and the jury's been in and out because there was a foundational hearing to determine whether they could use that shirt on a similarly sized man as one of the victims to help the doctor's testimony and help him demonstrate his opinion. So that was a disruption for them. But you're right. We're day 22. Where are we? Day 23.
Yeah.
I mean, they're done. They want the case. They get it.
Right.
But again, from the defense standpoint, they haven't done that much. I mean, in terms of time, a couple of days for the defense. They certainly have their right to put on the full defense. But it wears on a jury. They want the case.
Absolutely, and not necessarily they have to, because they don't have to prove beyond a reasonable doubt. They just have to show that there's some reasonable doubt.
And in this case, there is such a thin number of dots to connect by the prosecution that it's an argument that they haven't proven their case in the first place.
Absolutely.
And I think it's going to be a tough one for them to prove. So to poke holes in that thin prosecution case may not take that long for the defense.
Now I'm going to ask you something else about Dr. James Downs.
Okay.
We saw earlier that there was a conference in terms of the charge of extreme cruelty. The defense wanted it dropped. The prosecution wants it in. Judge Locke, I believe, wisely said, let me wait till the testimony of the defense's expert to make that determination. It's my understanding that Dr. Downs would help clarify that issue in terms of extreme cruelty by basically describing the wounds of the two victims, how they were actually shot. In your estimation, is that working in order to negate that charge? Is it effective? What do you see?
I don't think the case is going to turn on that.
Right.
I just don't. I mean, was it 5 bullets fired? Was it 6? Does that really matter? Is there any real argument that says this was not extreme cruelty to pull up beside a car, to fire randomly or even pointedly into that car with the intent to kill people? I don't know that anybody could find that that is not the cruelty necessary. This is about who done it. Who had the gun, who fired the shots. So it may be a great further effort by the defense to just kind of confuse the jury, make them think about it, and maybe distract them from what's really important here?
Well, I'll tell you what. One of the interesting things about the first-degree murder statute that they have in Massachusetts, the way that I've read it, is that obviously there could either be premeditation or it says with extreme atrocity or cruelty. Now, it might be the fact that the prosecution has a strategy that, look, if we can't seem to get him on that premeditation front, maybe the heinous nature of this shooting might do it. But again, it is about who pulled the trigger. And, I think for me, when I see this and I see that the joint venture charge was dropped, in other words, that if Alexander Bradley and Aaron Hernandez were both involved in the shooting, it doesn't really matter who pulled the trigger. But we saw that charge drop because Alexander Bradley was granted immunity. So that is very different than what happened with Aaron Hernandez when he was charged in the Odin Lloyd murder. For you, what do you see happening now as we come towards the end of this case? It looks like closing arguments will be coming either today or tomorrow. What do you think that is happening for the defense and prosecution?
I think this case is all about Bradley. Okay, he's obviously not the squeaky clean witness that you'd like. He's got issues, but he came off pretty well, and he's got this, problem with the gunshot to the head and the fake eye, and certainly he has motive to try and turn on his former friend Hernandez. But on balance, if you believe even a good chunk of what he said, then the prosecution, I think, will carry the day here. I think it's all about what he had to say and whether they believe him. What I think is really critical in this case is that the lifestyle that most folks may not understand, kind of hey, can a spilled drink turn into tracking people down and killing them in cold blood? I mean, come on, that's ridiculous. I don't live in that world. I don't know. I'm not clubbing every night. I'm not.
You're not?
You may not believe this, but I'm not a gang member.
Okay.
So,
hold my assumptions for later.
I think that for the jury, it's going to be about dealing with that very different slice of life. And they may come to believe that, this guy got so irritated because who he thought he was and who he thought others how they should respect him, that he did what the prosecution is claiming, that he hunted these guys down, and that his irritation at having a drink spilled on him boiled over to that point. That's his way of life. I mean, the jury's not going to hear about this, but since he's been in prison, he's been involved in all kinds of problems. They aren't going to hear about that stuff.
Right.
But as we sit here trying to analyze him and his way of life, it starts to make more sense and almost makes it believable that the guy could have a trigger mechanism that just sent him off the edge over something so trivial as a spilled drink.
Well, I'll tell you what, you make a great point about Alexander Bradley being the key to this entire case. Now, one of the interesting things was the jury instructions that were debated yesterday when the jury had the day off. One of the charges was that the jury cannot convict Aaron Hernandez based on immunized witnesses' testimony alone. There must be corroboration. So if it's not Alexander Bradley alone, what is it that might help the prosecution really get that step ahead?
That's a good question, because we have some issues with the videotape that did and didn't exist as to the spilled drink incident, and whether or not Hernandez looked agitated at all through the course of the evening leading up to the shooting. So that doesn't help. That doesn't help him. But I think on a practical level, the jury doesn't have to quantify what they find to corroborate that testimony. They don't have to go to the judge and say, Judge, you know what, we not only do we believe Bradley, but we think A, B, C, and D supports his testimony. They don't have to do that. They can come to their decision and present that decision to the court, and then there has to be an inference and an assumption that they got to that point properly. Attacking that kind of decision for the defense is brutal. I mean, how are you going to get into their minds? The law doesn't let you invade the jury's mind. And so to get in there and prove that they somehow did not have the corroborating evidence, I think it's dead in the water.
Well, let me ask you this. Because the defense is basically not just saying that Aaron Hernandez didn't pull the trigger, but that Alexander Bradley did. Now, before the prosecution rested their case and the defense came up with their witnesses, there was debate about how much of a case the defense would put on, and specifically, how much would they elaborate on a story that this was about a drug deal gone bad, both in terms of the Boston shootings and both about Alexander Bradley being shot in the face. We haven't really seen anything about that. We haven't seen a lot of testimony or anything indicating that it would be a drug deal gone bad. So if you're sitting in the jury and you're waiting for that and you don't hear it, what do you think?
Well, you've got to wonder how strong that defense is, or really, how cocky are they that the prosecution never made their case. And so with some jurors, they could be thinking, well, we agree with the defense. We haven't seen enough to prove the initial case. And so we don't care if they don't have these other things. And in my mind, they didn't need them anyway. Of course, you got other jurors that's going to feel differently, and all you need is one.
Right. Now, I'm going to ask you about someone that I think changed the whole trajectory of this case, and I'd like to pull up the clip if we might have it possible. Antoine Salvador, the gentleman that was in the nightclub at the time of the 2012 shootings, who ran into Mr. Hernandez, asked him for an autograph, said that he, at the time, he didn't appear agitated, didn't notice anyone spilling a drink on Mr. Hernandez, didn't give any indication that would support the prosecution's narrative of that night. I think, and I've been reading about it as well, that really put a hit in the prosecution's narrative. What is your opinion about his testimony?
There's no doubt that at first you have to buy the whole spilled drink will set somebody off. And now you've punched holes in the possibility that that never even happened. Or if it did, it was such a minor event even to Aaron Hernandez that he seemed cordial and happy to help a fan. I know the fan had to ask him a couple of times, said, hey, it's my birthday, before he finally said, okay, well, let's take the photo. But the bottom line is he was fine about it. He was cordial about it. It was no big deal.
Yep.
So what we haven't really mentioned is that all of this goes to motive, which is not an element of the crime and does not have to be proven by the prosecution. But it helps regular folks, sitting in the jury box, figure out what really happened and why.
Right. You know what? Let's pull up that clip. Do we have that one? Great. Let's turn to that and we'll talk about it afterwards.
Mr. Stano, good morning.
Good morning.
Even accounting for the 56-second difference in the cure videos, even accounting for that, did your hundreds of hours of review of videos show anybody spilling a drink on Aaron Hernandez?
No, sir.
Did your hundreds of hours of review of the video show anybody bumping into Aaron Hernandez?
No, sir.
And given your hundreds and hundreds of hours of review of these videos and some time difference between Tufts and Cure, did any of your review show Mr. Hernandez in the passenger seat of a Toyota 4Runner at the corner of Harold and Shawmut at about 2:30 a.m.?
I did not see that, no, sir.
2:33 a.m.?
No, sir.
2:27 a.m.?
I don't believe so, sir. No.
So I'm trying to account for 3 minutes on either side.
There was no video camera there, so I couldn't see it.
And Mr. Hagan showed you a. Did Mr. Hagan move the mouse?
I have the mouse here. Sorry.
No. Okay. Now that is one way to slow down my cross, right? Mr. Hagan. Mr. Hagan showed you a video of a Toyota 4Runner, or a car, a silver car,
sure.
That was on the screen. It seems not to be coming up.
The Bradley circles.
Great. Can you see a license plate on that car?
I cannot, sir.
Are you aware in your hundreds of hours of review that another Toyota 4Runner left the garage about 2:15, 2:16 a.m.?
Yes, sir.
And it had a Massachusetts plate?
Yes, sir.
Can you tell whether that's a Massachusetts plate on this car?
I cannot, sir. No, sir.
Brief indulgence. No further questions.
Evidence of a spilled drink, which is such a key point in the prosecution's narrative. Do you think it was an important point?
You know, it is. I think if you've ever had a drink spilled on you, it is pretty much alcohol. Evaporates pretty quickly unless you're wearing a sweatshirt, you know, but you know, you're in your club wear, you know, polyester, whatever thin
you're looking
membrane
good.
it is. Yeah, it's probably going to wick away pretty quickly, so I don't know. It certainly doesn't help the prosecution. I don't know if it's a killer, though.
Well, I'd like to go to the man who has provided so much character in this trial, the street sweeper, Warren McMaster. This man, when he first came on, who testified when the jury wasn't present, provided some very colorful testimony. But as colorful as it is and what he presented earlier this week, when you really take a listen to what he's saying, he's talking about police pressure and police coercion. And I think that really is going to be a big key issue for the jury when they hear this. I'd like to move to a clip and then we'll talk about it. It's going to be Baez's direct examination of Warren McMaster. I believe it's clip number 2. Let's listen to it and then we'll talk about it.
Thank you. Good morning, sir. Can you introduce yourself to the ladies and gentlemen of the jury?
Warren McMaster.
And can you spell your last name?
McMaster.
And on July 16, 2012, what were you employed as?
An operator for American Sweeping.
Okay. And did you operate a street sweeper?
Yes.
Okay. And, sir, can you tell us what you saw that evening as you drove through the area? Actually, if I can get the pointer.
Pointer?
Can you show the ladies and gentlemen of the jury, there's a stick there, where you traveled as you came up to the corner of Harold and Shannon that evening?
Came from the gutter side right here, crossed down to Sharma, right side gutter going.
I'm sorry, I didn't get the end of that.
The right, I went from marginal to Sharma, right side gutter outbound, Sweden.
And did you drive by a BMW at that time?
Yes.
Okay, and what did you see as you were driving up to it?
It looked like a SUV and a BMW, side by side. Yeah.
And what could you observe as it relates to any of the passengers in the SUV?
Looked like someone out of the sunroof with a device in their hand.
Okay. The person that was out of the sunroof, did it look like a man or a woman to you?
It looked like a female.
Okay, and what did you think they were doing?
It might have been calling for help or recording or whatever. It looked like they had something in their hand.
Okay. Was that, when you say, did it appear that they were videotaping it?
Possibly.
Okay, is that why you say a recording device?
It could have been a cell phone. They could have been calling for help.
Okay, but you didn't know exactly?
Yes.
Okay, and then what happened after that? Where did the SUV go?
We just went down towards Harold Street, took a left to Harold Street and just left.
Disappeared?
Yeah.
Okay, and then what did you do after that? Now, at some point, did the police ask you to come back?
My supervisor did.
Okay, and what did you do?
I came back to Marginal and parked.
Okay. And when you came back to Marginal, what happened?
Greeted by a bunch of police officers and my supervisor and just a bunch of chaos.
Okay. When you arrived back on the scene, how did the police respond to you once you got there?
Kind of.
When you arrived back on the scene, how did the police respond to you once you got there?
Kind of disrespectfully.
Disrespectfully?
Rude, yes.
Okay, and how did they behave towards you? What did they do and say?
They just told me to shut my mouth and remain quiet and I'd be under arrest if I said anything. Just pretty much sit there until further notice, and a bunch of them kept coming up and saying the same thing.
Okay, so were the police happy to see you come back? Objection?
Sustained.
Did the police indicate in one way or another either their pleasure or displeasure of seeing you back at the scene that evening?
It didn't feel like it was a pleasurable thing. You know, it didn't feel like a good situation to be in.
Did they curse at you?
Yes.
Okay. And did they order you to either sit down or
They told me to, yeah, they told me to sit down on the side of the road, remain quiet, shut my effing mouth, or be under arrest. Just pretty much told me to shut up. No, sir.
Okay. And after all of this occurred, did they ask you to empty anything out, or your hopper or anything?
They told me to go to go to frontage road and empty my hopper out.
Okay. And explain to us how that works.
I transported my machine towards frontage road, pulled up. There was a couple officers there, one in unmarked uniform. I think there was 3 and I just dumped my hopper out, which is like a disposal for the machine. And I dumped it out, spread it out a little bit evenly, and we raked it all out and searched through the. And I just dumped my hopper out, which is like a disposal for the machine. And I dumped it out, spread it out a little bit evenly, and we raked it all out and searched through the material, whatever was in there.
So they use rakes?
Yes.
Okay, did you use anything, I guess, anything more than just a rake?
Shovels, there was a hose.
To uniformed officers, plainclothes, or both?
There was multiple, there was uniformed and ununiformed officers.
Did you to uniformed officers, plainclothes, or both?
There was multiple, there was uniformed and ununiformed officers.
Did you tell them what you saw about the woman in the sunroof?
Yes.
Okay. And did you tell them that you drove through the scene?
Yes. They're just being kind of like, you know, if you mean rude to me, honestly, they're just being rude to me and just telling me to shut my mouth and not to say nothing and just remain quiet and don't talk to no one. There was a news cruiser there. They were trying to like get questions out of me and said, shut your effing mouth or you'll be under arrest.
Did they tell you if you opened your mouth?
They're just being kind of like, you know, if you mean rude to me, honestly, they're just being rude to me and just telling me to shut my mouth and not to say 30 minutes, 40 minutes.
Okay. And then they asked, and that's when they asked you to empty out your hopper?
Yes.
Okay. And then after that, how long were you there with that?
About 20 minutes, 30 minutes.
And after that is when they let you go?
Yes.
Okay. Subsequent to that, how long before the police came to talk to you again?
Just recently, last month.
Okay, last month. And tell us about that experience.
Just they called me, they kept trying to get a hold of me. You know, I didn't have like enough time to meet up with them, and then when I finally did, I went to a building and we talked to those two officers there, I believe, detectives, and they recorded a beginning statement, and then after it was done recorded, they kind of summed a couple of things up, like, yep, you're gonna have to go to court, blah, 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 and then I left.
Okay, this time, month, and tell us about that experience.
Just they called me, they kept trying to get a hold of me. You know, I didn't have like enough time to meet up with them, and then when I finally did, I went to a building and we talked to those two officers there, I believe, detectives, and they recorded a beginning statement, and then after it was done recorded, they kind of summed a couple of things up, like, yep, you're gonna have to go to court, blah, 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 and then I left.
Okay, this time, when they called you here a few weeks ago, did they record you then?
The first time they did, and then the second time when I met up with whatever, it was another group of people. They like Wang, whatever his name is. They didn't record me.
Okay. So after they asked you here and they recorded you, did they attempt to try and get you? Do you feel that they tried to get you to change your story?
I don't know.
Okay.
They're trying to see if honestly, they were trying to say that I knew one of the detectives and knew he was there, and I just didn't remember him.
Welcome back to Law News Network. I'm Jesse Weber. That was testimony from Warren McMaster, the street sweeper in the Aaron Hernandez double murder trial. Today I'm joined by attorney Michael Bryant. We're discussing all the issues as we have a break in the Aaron Hernandez trial, lunch break. As we were talking about Warren McMaster, what did you think of his testimony?
Always a good guy, always entertaining. You know, he's a clean sweep the streets of Boston, but he's soiling the finest there. He's not helping.
Right.
You know, his goal really, he doesn't have a goal. He has no agenda. He did clean up nicely for the defense version of his testimony.
Yes, he did.
You know, and maybe he had a media coach. I don't know, but he's got the haircut. He has a look different than before. He even at one point picked up the pointer as if to anticipate his role. Well, yes, I'm now going to point something out for you. So very different guy.
I'm disappointed. I wanted more of the animated guy, but okay, can't have everything.
Far less twitchy. Still the same information the jury's getting, which is he supposedly saw somebody hanging out the sunroof of a vehicle, maybe videotaping the event, and the cops never found that, so bad on the cops. They also treated him badly, so you know, his whole testimony is really just reflective of a poor police operation. And it's been reinforced now. We saw it during the prosecution case in the twitchier form. Now we're seeing it a little more laid back, but the defense is making points with that same testimony.
And Michael, to add what you're saying, I think becomes even more relevant in terms of what happened with the jury instructions that were debated between the defense and the prosecution with Judge Locke yesterday, because there was an instruction about a Bowden instruction. And if you could just explain to our viewers a little bit about what that means and why that might really tie in with what McMaster's testimony is about.
Yeah, basically the jury's told if you find that the police were not appropriate or where there were flaws in their investigation, then you have a right to draw certain inferences from that. Well, this testimony goes right to that instruction and right to the attempt to get the jury to infer nothing but bad things against the cops and therefore the prosecution.
Right. And do you think that that will be effective here? I mean, look, we're talking about improper police tactics that would allow the jury to take that into consideration about whether the prosecution met their burden. That's a lot to ask. That's a lot to ask for a jury. How often do you see this?
I think it happens a lot. And again, whether they have to reduce their thought process to an explanation is a different story. But internally, how many cases have we seen where malfeasance by the cops or just plain negligence has been held against the prosecution? I mean, it happens all the time.
Absolutely, and I know that there's another case that we have that we've talked about the Dalia DiPolito case, where when she was on appeal, that case was overturned based upon improper police tactics. So we do see it from time to time, and it will be interesting to see the jury instructions that Judge Locke will craft based upon the advice that has been given from the prosecution and the defense. Just quickly about those jury instructions. A lot of people might not know how nitpicky you have to be with those, in terms of the exact language that's used by the defense, in terms of do you want to use, language like hid versus garaging or disposed of versus discarding. Yesterday with what you saw, what should the viewers look for when they were seeing that?
People don't understand that quite often the jury instructions are not just the law that the jury needs to apply, but it's also the basis for most appeals are problems with the instructions. So when the attorneys are crafting those instructions and each side presents their version, and there's always a handful that are the disputed ones, there's a ton that are not. But those that are disputed are hotly contested because of that fact. Not only can they sway the way a jury decides a case, but if it does go to appeal, they're going to focus on those jury instructions. So I don't see this one being any different than others. I think there are some nuances that may go right over the heads of the jurors, and they're going to get right to the guts of it. But if the attorneys representing both the state, or the Commonwealth in this case, and the defendant don't make that effort, then they're not protecting their respective clients for purposes of appeal.
Absolutely. I couldn't agree with you more. And as we are on break with the Aaron Hernandez trial, I'd like to shift gears with you for a minute, Michael. There's another case that we are going to be covering here on Law News Network live. It is the Stephen Jones murder trial. And for those of you who do not know much about this trial, this is really a case of a young man and whether or not this is murder or self-defense. And this is an instance where this gentleman was in college. He was at the University, I believe, of Arizona. And he was engaged in a brawl. And that brawl ended up with him retrieving a gun, shooting someone, and injuring 3 others. He is now charged with first-degree murder and aggravated assault, 3 counts of aggravated assault. I believe right now a jury selection in that case is about to conclude and opening statements will begin. I'd like to talk with you, Michael, a little bit about this case. We see situations about whether something murder is something self-defense. And I think really the thing that people will be looking out for here is what is premeditation and what is self-defense.
You know, premeditation that's the golden ticket. I mean, that's for prosecutors to prove that is the ultimate case, and it's tough. Malice aforethought, the ability to form the intent to kill somebody and then carry out that crime is very difficult to prove, especially in a case where things have not been laid out over a long period of time. And from what we know about this case, this was a frat party that kind of devolved, a local party underway, thinking that some of the frat boys were breaking into that party, kind of raised a stink about it, ultimately led to some sort of physical violence against the defendant, who then retrieved a gun and shot not one gentleman who he killed, but then a number of others in a kind of a separate skirmish. But it all happened within a very brief period of time. So for the prosecution to prove malice aforethought, to prove what they need for premeditation, they have to string together those events, but having given the defendant enough time to reflect on what he's doing to form that requisite intent. You know, you can't do it. It's, you know, if you run into somebody who's messing around with your wife and you snap and you shoot somebody, there's no premeditation there, okay? That's just a mental snap. The closer you get from the event that caused any sort of upset to the crime itself, the tougher it is to prove malice aforethought or premeditation.
Right, and for the self-defense claim, you know, for the defense, it's really going to be about that period between when he was being assaulted upon, when he was being injured, and when he had time to retrieve the gun. And you're going to see testimony, you know, it kind of correlates with a little bit with the Aaron Hernandez testimony that we heard earlier, you know, in terms of Antoine Salvador. How many minutes did you speak to Aaron Hernandez? Was it 5 seconds? Was it 3 seconds? Well, in total, it was 30 seconds. Well, here, I wouldn't be surprised to see the same kind of information coming up from, you know, the testimony with this attack occurred at this time. He had 20 seconds to get the gun, or, you know, what is that time period? And, you know, we see these cases because we never want to justify the use of deadly force, and you see stand your ground kind of cases in different districts. But here, you know, it's a tough case all around because you have young victims and you have a young individual who's on trial. And if he is found guilty, he will be sentenced to life imprisonment. And I thought it was very interesting that the initial charge was going to be second-degree murder, but the grand jury came back with first-degree murder. Is that something you see typically in these kind of cases?
I'm very surprised, and I haven't cleared this up. Maybe you can. Are there lesser includeds in that premeditation? Or are they going all out?
I believe that they're going all out for the
I think that's a
as far as I know.
I think that's a mistake. They can certainly try to amend that later on, but you know, if you look at the fact pattern here, there are actually two separate events, but really closely connected. You have the punching of the face of the defendant, allegedly, by the, I think his name is Colin Brough, or Bruff.
Right, he was the victim.
He was the deceased.
Mm-hmm.
He was the first victim, and that was allegedly as the direct result of punching the defendant, who then retreated to the vehicle, grabbed the gun, shot him. Then there was a follow-up skirmish, which apparently was other friends of the man who had been shot coming to his rescue and trying to wrestle the gun away from the defendant. So they're two insular events, really, separated by a very short period of time. I think they're going to be treated that way by the defense, because if you lump them all together, it makes one big crime look a whole lot worse than these two separate parts.
Absolutely.
And could you premeditate in between the two, or did you lose that intent in between the two? It's going to be very dicey.
I agree. And, you know, the first thing, I'm sure we're going to have a lot to talk about with this case, and hopefully you'll come back on when we start live streaming it here on LawNewz Network. One of the interesting things that happened with this case is with the judge's rulings early on. And there were statements that were made by Stephen Jones shortly after the shootings took place that he made to the police, basically indicating that he was scared. He apologized for what he did. I was scared, you know, I was under attack. And the judge ruled that that testimony, even though it was trying to be included by the defense, basically saying that he was scared and maybe that was a justification for what he did, he said, the judge said, I'm not going to exclude that. Just because you're scared doesn't mean you lack the intent to commit murder. What did you think about that?
Yeah, I think it's interesting because there were a number of statements, not just I'm scared, but why did they attack me? You know, he's in the back of the squad car and this is being videotaped. Why did they attack me? You know, I had to fight back. Those kinds of things. The judge only ruled on the scared reference and said that's irrelevant, as you say, because you know you can kill somebody with intent and still be very scared. But I'm not so sure if I'm the prosecution or if I'm the defense that I want all that stuff in, and I'll tell you why. If you're the prosecution and you're going to argue that he really had no self-defense. I think some of the statements crafted, if I can use that word, in the post-incident squad car and in some of the other times that he said these statements, they kind of make it look like this guy's a sneaky guy. You know, not only did he do what he did, but upon reflection, he realized what position he was in, and he started working on his own defense.
As the judge said, it was self-serving.
Very self-serving, and so I don't know if I don't want that in. Maybe it's helpful for the jury to see that this guy is so clever that not only did he do these crimes and as pursuing his self-defense, but he was already crafting evidence back on the day of the incident that would help him support that defense.
It adds a little bit of complexity to the situation as more as it already is. Now, talking, if you have the prosecutor hat on as we're speaking, there was another interesting part about this case so far where there was information about the victims, what they had in their systems, in terms of alcohol and drugs, and the prosecution tried to bar that from trial and information about that, but the Judge Slayton actually allowed that information to come in because one of the victims said, I didn't, I never done drugs in my life, even though that was a lie. That might later be used by the defense to impeach the credibility of these victims. What do you think about that?
Oh yeah, I mean, anything you can use to dirty, a victim witness is tough.
Right.
That is the strongest witness you're going to have, okay? So anything you can do to poke holes in that testimony, in that credibility, all the better. The marijuana may not play all that strongly. I mean, I don't think it has the biases and the prejudices it had years ago. College kids smoking dope, whoa, never thought of that. And can't imagine that happening. So I don't know if that is horrible, but, why lie about it?
Right.
And anytime you catch a witness in a lie, you're making points.
Now, if you're the defense, do you put Stephen Jones on the stand?
That is a tough call. I wouldn't make that call initially. I would wait, kind of see how things are playing out, kind of take the temperature of the room and of the jury. I wouldn't foreclose it, but it's never a safe move.
Sure.
You got to be pretty sure of what's coming out and how you think the trial stands at the time you do it.
From what we know about the case and the facts of this case, what would push you towards putting him on the stand later on in a trial? What would they be lacking that his testimony would definitely help their case?
I think if, the witnesses came across, the victim witnesses came across as shaky, unbelievable, that's a plus. I think if the expert testimony was very either vague or pro-defense in terms of the sequence of events and whether or not the defendant was being attacked. If that evidence looks stronger and stronger as you go along, and your guy, the defendant, can then support that, corroborate that, I think you're in a better position. But if all the witnesses are squeaky clean, they sound good, everybody's believable, if all the forensic and expert testimony says there was nobody lunging, the bullet trajectory, nothing supports anything but a certain distance from the shooter, then maybe it's not so good.
Absolutely, and I mean, again, we're correlating it to the Aaron Hernandez trial, which is on lunch break right now, and we'll touch back to that in a minute. We don't put, the defense, you don't put Aaron Hernandez in the trial because it's a much different situation than it is with this gentleman, Stephen Jones. So I'd like to, please everyone tune in to the Stephen Jones trial as we live stream it here. There'll be much to cover as the Aaron Hernandez trial winds down. But moving back to Aaron Hernandez, they're in a lunch break right now. This morning, we saw the testimony of a digital forensic expert, William Jacob Green, that was put on by the defense. He testified basically about Brooke Wilcox's hard drive, which is, and for those of you who know, Brooke Wilcox is the mother of Alexander Bradley's child, and he also testified about, and so he talked about the searches that were done on that hard drive. And then he also talks about Alexander Bradley's cell phone and what messages were sent back and forth. I'd like to move to a clip from William Jacob Green, and we'll talk about it after and see how he did. Let's do clip number 1 from, clip number 2 of digital forensic expert William Jacob Green from this morning, and then we'll talk about it.
And talk about the work you did in this case. Did you have an opportunity to receive and examine a hard drive known to be from the laptop of a Brooke Wilcox?
Yes, sir.
Okay. Tell us quickly what you did and how you go about getting this information.
Yes, sir. The evidence was released and shipped to our office directly in Raleigh from Boston Police Department. We received a hard drive that contained what's called an EO1 image. It's an in-case forensic image. It contains all the data that was recovered from that drive, more than likely by the original law enforcement examiner.
So it's like a mirror hard drive?
Similar, yes, sir.
Okay. Please continue.
Yep. We ran that that data through several different types of software. One would be Access Data. It's called Forensic Toolkit, FTK. We also ran it through a system from Magnet Forensics called Axiom.
Okay. And did your examination generate any reports?
Yes, sir.
Okay. May I approach the witness?
You may.
I'm handing you a binder that's yet to be identified. Does this appear to be your report?
Yes, sir.
Okay. And is this of the computer that you did purporting to be Brooke Wilcox's computer?
Yes, sir.
Okay. I'd like to have this marked, if I may, Your Honor.
As an exhibit or for identification?
As an exhibit.
Any objection?
I said be marked just for identification so we see exactly what's going to be put in for a rather large document.
All right, we'll receive it for identification. E.
I'm showing you now exhibit EEEE. Okay. All right. E stands for easy, okay?
Yes, sir.
So let's do this easily. Let's talk about the searches that were run on July 16th, 2012. Do you have those before you, sir?
Yes, sir, I do.
Okay. Were there any searches run for any type of shootings that evening?
I believe so.
Or that early morning?
Yes, sir.
Okay. Now, I remember we had an issue with this UTC time. Did you have a chance to have it done in Eastern Standard Time?
Yes, sir.
Okay. Can you tell the ladies and gentlemen of the jury the brief overview of the searches that were run on that morning?
Yes, sir. We have, I believe it was a total, let me just verify that. In this record, we have 15 different Google searches. All these searches were completed using google.com. This specific report doesn't outline, or I apologize, it does outline which browser was used. So Google Chrome and Internet Explorer were observed in these records as being the operating system or program that was used to search for google.com. We have a couple different searches. The first one that we can see that somebody actually, it was called an original search query, which means someone actually typed that into the Google search engine. Breaking news in Hartford, that was actually the things that they typed were breaking news in HARTF, and then of course Google auto-populated Hartford into that and guessed that that's what the user was typing.
What time was that done?
That one was done at 6:58 a.m. and that is corrected for Eastern Standard Time.
Okay, 6:58 a.m. Not later on in the evening?
No, sir. That was in the morning.
Okay, please continue.
Yes, sir. The next one that we actually have a search for that someone actually typed in shooting in HAR, and Google guessed that the person was searching for shooting in Hartford. That search was completed at 7:07 a.m.
Okay, please continue. Now, before you continue, you can't say who's running these searches, right?
No, sir.
Okay. And even whether it's one browser or another, you can't really make any determinations based on that. You can just say this browser at this time and this computer at this time.
Yes, sir.
Okay, please.
There's another search that did not provide us that the original search query, so we don't know how exactly this information was put into Google, but we have a record for shooting in Hartford last night, and that of course was on the 16th at 7:07 a.m.
Okay, and then continue.
We have another one for the shooting in it's HARTF, again at 7:07 a.m. We have a search for breaking Boston news at 7:09 a.m. On the 16th at 11:54 a.m., We have a search for Aaron Hernandez.
Okay. And is that a Google search?
That is from google.com, yes, sir.
Okay. What else?
The next one we have at 11:56 a.m. Someone searched for. We actually have a original search query, so someone actually typed this into google.com. Aaron Hernandez address.
Okay. And that is at what time? 11?
That would be 11:56 a.m.
Okay. Continue.
We have a Google search at 11:56 a.m. Within Internet Explorer for Aaron Hernandez address. At 4:25 p.m. in the afternoon, we have a search for www.gucci.com within Google.
Okay. What else?
4:25 p.m. we have another search for www.gucci.com.
Let me stop you there.
Yes, sir.
So you've got searches being run early in the morning at 6 to 7 a.m., right?
Yes, sir.
And then another sitting around 11 a.m.
Yes, sir.
And then another sitting at 4.
Yes, sir.
Okay. So someone's on the computer at different stages during that day?
Correct.
Okay. Let me just fast forward if you can.
Yes, sir.
These Gucci searches, are they for any specific type of clothing?
Yes, sir. They're searching for men's shoes, specifically sneakers, on Gucci.com.
Okay. And then does there appear to be another relevant sitting later on that afternoon?
Yes, sir.
Or evening?
Yes, sir. At 6:26 p.m., we have this will be from Internet Explorer's history, a search term for Boston, or shooting in Boston.
Another sitting at 7:30 p.m.?
Yes, sir. 7:30 p.m. There was an original search query, so again, someone actually typed this into the Google search engine for Aaron Hernandez, and then it auto-populated to Aaron Hernandez girlfriend.
Is there another sitting later on that evening?
Yes, sir. At 11:55 p.m., we have a original search query for breaking news in B, and then auto-populated to breaking news in Boston.
Judge, at this time we would move these subject to redaction, this item into evidence as exhibit.
Subject to redaction, Your Honor, I just want to see what's in there.
All right, that'll be received. NC 381. Exhibit 381.
Okay, sir, did you then have an opportunity to examine?
Welcome back to the Law News Network. I'm Jesse Weber. Here with me today is Michael Bryant. We are talking, there's a break in the Aaron Hernandez double murder trial. They are on lunch, but I believe they're coming back soon. We just saw this morning's testimony of digital forensic expert William Jacob Green, who was called by the defense. Now, he was called for two different topics. The first was about the searches that were done on Brooke Wilcox's hard drive, her computer. And for those of you who don't remember, Brooke Wilcox is the mother of Alexander Bradley's child. It was alleged that after the 2012 Boston shootings, Aaron Hernandez and Alexander Bradley went to Miss Wilcox's house where searches were done on the computer. Now, we heard this testimony. I don't know how helpful it is in the sense that we're trying to see what searches were done. We see that it was searches were done for Aaron Hernandez, searches were done for breaking news in Boston. Clearly, either whether it was Alexander Bradley or it was Aaron Hernandez, They were searching for what happened that night. How helpful do you think this is?
You know, unless you could tie the fingertips of the person on the keyboard to those searches, I don't know how helpful. You know, were they both interested in what was going on? Probably. You know, they were there that night, if not in the car, certainly at the club, and certainly whatever happened was of interest to them. But again, without that connection, I don't know where it goes.
And especially when you drop the joint venture charge, which basically was that it doesn't really matter who the trigger man was. If you have two individuals who are engaged in that crime, Aaron Hernandez could be charged with murder. It doesn't matter if he was the trigger man or not. But when Alexander Bradley now had an immunity deal and he's no longer on the hook for this, I really don't see it playing out. What I found, William Jacob Green's testimony to be particularly relevant was about the cell phone records from Alexander Bradley. And in particular, we're coming back to the text message that I've talked about, that we've talked about on this network, that we've talked about all in the news, the text message from Alexander Bradley to Robert Pickering, his attorney, where basically it says, "Will I perjure myself if I tell the truth at trial about not knowing who shot me?" Now, we know from William Jacob Green's testimony that text was sent, and we know from his testimony that that text was deleted. How much does that hurt the prosecution?
You know, I think the prosecution's attempt to minimize it gives you an idea of how much it hurts them. Because, methinks he doth protest too much. If they said nothing, then you'd go, that probably didn't mean anything. But they wanted to make a deal out of it, saying, well, it's just a random text that he just deleted. We all delete texts. We got to make room for our other texts. So they're concerned about it.
I would imagine so. I mean, how often does one delete incriminating text messages? But that's...
Personally, once or twice,
right,
maybe.
Of course. We've all been there.
Yes.
Now, here's an interesting part. We were talking, as we were watching that clip, about Aaron Hernandez. Step back from all the testimony you've heard. Look at the big picture. If he's acquitted on the witness intimidation charge, he is acquitted on the double murder charge, he's still in prison. What is he thinking?
That's what I get past the nuts and bolts sometimes, and I wonder, with a defendant in this scenario, what are you really thinking? He does have an appeal pending on the conviction that he's now serving for. Probably thin chance of that changing his life circumstances. So are you sitting there thinking, hey, I don't care what happens here? Are you sitting there thinking, hey, at least I get to put on a nice suit and eat some nice food and I'm out of the joint for 3 or so weeks? I just can't imagine what is going through the guy's head. Do you think he really cares about being vindicated? I think he just cares about surviving in prison.
It's a tough situation. I mean, because you basically you don't really see this where somebody's on trial. You usually, if they're acquitted, they go home free. He goes back to jail. It's really not a situation you see often.
Quite often you'll see, if somebody's in this scenario, life without parole, that any subsequent events are usually handled through plea or some sort of arrangement. You're not going to full-blown trial.
Right.
So it's unusual.
Right. And I'd like to talk about what I see as the conclusion of this trial. We talk about closing arguments. You can choose which one I'll give you the option. You want to be the defense or you want to be the prosecution? Which one? I want to talk about a closing argument. What needs to be included? What would really resonate in the minds of the jurors? You tell me which side you'd like to take.
I would definitely want defense for this case. I would definitely want to be the defense because I think it's easier to show what the prosecution failed to prove than to prove a defense. And they're going to try and prove a defense, and their defense is that my guy, Hernandez, wasn't the shooter. I get that. But that's kind of your fallback position almost. As the defense, I'm going to be arguing the cops didn't do their job. You have no credible evidence that my guy, Hernandez, was the shooter. You've got this cocaine dealing liar, and how can anybody believe him? And even if you do, what other evidence is there to corroborate what he said? I'm taking the defense.
And we talk about reasonable doubt. It's something we hear in if you're not even an attorney, you hear it in the movies, you hear it. But really, when you think about it, what does it mean? Reasonable doubt. Do you have a reasonable doubt that Aaron Hernandez committed the crimes? And I've taken the position that I always felt that the witness intimidation charge was lacking more than the double murder in Boston. And when you look at this, do you think it's going to be a situation where you see maybe he might be acquitted on the witness intimidation charge and be found guilty on the double murder charge? Do you see that maybe happening?
I think that could happen. The evidence is even thinner on the intimidation. I think people can infer a whole bunch, but is there really enough there beyond a reasonable doubt? I think the other thing we have to consider when it comes to the murder charges is some innocent people died. And juries sometimes want somebody to pay for that. And they're more willing to accept certain information that will get them to that point when they feel like that's their job. They have to find justice for the people who died, and we're going to go about it the best way we can with the best evidence we've got.
You know, you make a great point, because we see, as we're watching the testimony of different individuals, we see the families of Daniel De Abreu and Safir Hurtado. What justice will they get if Aaron Hernandez is found not guilty? Because Alexander Bradley, who may be in fact the shooter, we don't know, he was granted immunity. Yeah. So what, you know, for their families, but again, we want our juries to take the evidence that is given to them and make a decision based upon the merits of that evidence. We can't have a situation of jury nullification or anything like that. In your experience, have you seen situations where cases seem so downright, you know the decision that's going to be made either for or against a defendant, and you get a completely different outcome? Have you seen that?
Well, of course, and I think we can't lose sight of the families, as you mentioned, and I'm sure it went down very difficultly when they heard about the immunity agreement for Bradley. They certainly didn't want one guy getting off the hook, and I have a feeling there was some sort of, you know, the prosecutors have to, you know, be psychologists and therapists and social workers with victim families all the time, and there may have been some conversation that said, look, we want to get the guys who did this. The best way for that to happen is to turn Bradley against Hernandez. So we know you don't like the way that smells, but it's our best shot.
Absolutely. And, you know, when we see, so we've talked about the defense's closing arguments. Prosecution's closing arguments, not as strong, but I'm curious to see if you were in that position, what would you really like to stress in their minds?
Boy, you know, you have to get past the motivation issue, because there really is no reasonable motive in this case. You know, it strains credibility to think that bumping somebody and spilling a little drink on them is enough to get them to shoot up your car and your passengers. So you got to get past that, and you have to paint a picture for this jury that that's the way, that's the lifestyle, that's the culture, that's the way these folks operate. You may not get it or understand it, but that's the way it is. Once you get past that, then you got to rely on Bradley. And that's you know, as a prosecutor, you're putting all of your eggs in that basket, and then you're hoping that the expert testimony and the other precipient witnesses in some way, if not truly corroborate what he had to say, give the jurors the comfort to believe that the evidence was there to corroborate it.
Right, and especially since, as we talked about, there was that jury charge that the jury cannot convict Aaron Hernandez based upon immunized testimony alone, meaning if you believe just Alexander Bradley, don't grant a conviction, but if you believe that it's corroborated by some other testimony or other evidence, then you might have a different situation. Now, one of the most interesting things that happened today, this morning, was about a motion that was made, or maybe it was yesterday, I might be speaking out of turn. It was a motion that was made by defense, a motion for acquittal, based upon the testimony of Alexander Bradley, and saying that, you know, what you have as of right now, no reasonable juror would find that a conviction could be found, and Judge Locke basically said, I will take your motion under advisement, this judgment of acquittal. Taking it under advisement, you know, he hasn't decided any yet. What do you think about that?
That's generally a loser. I mean, you know, because the defense is asking the judge to take the case out of the hands of the jury members and basically tell them, thanks for your 3 weeks, can't really use you anymore, go home. It's got to be so clear-cut in the judge's mind to take the case from a jury. You know, this motion for dismissal, it's a routine motion.
And just to clarify, we're talking about the witness intimidation charge.
Okay.
You know, my correction. It was, you know, what the defense basically said was, there's absolutely no proof of intent here, because at the time that this allegedly happened, that Aaron Hernandez shot Alexander Bradley, he had no incentive to be a witness yet. There was no incentive in the mind of Alexander Bradley to Aaron Hernandez to shoot Alexander Bradley in order for him to not testify. But like you said, he's going to take it under advisement. So I don't know how strong that actually is going to be.
That's a closer call, but I think if you look at all the text messages back and forth, there's certainly a sense of consciousness of guilt somewhere in there that there might be enough to get past a directed verdict, or in the case a request for dismissal, on that one issue, but it's far closer call than on the larger charges. Yeah.
Absolutely. Now, before we are coming back to the Aaron Hernandez trial, we heard the testimony of Dr. Jamie Downs. I prefer Jamie over James. I'd like to turn to some of the clip of that, see some of his testimony from this morning. We'll talk about it if there's time, and we're not coming back to the live stream of the trial. I think he talked about some important things about the way that the bullets were shot, the trajectory, the wounds. We've talked about whether or not that works in favor of the prosecution or defense's narrative. We've said before, as you so eloquently put, that it doesn't seem that Aaron Hernandez could have made that shot by reaching across the passenger seat, the driver's seat, excuse me, and it doesn't seem like he might have been able to make that shot. We also talked about the fact that, does this play into the fact that it might negate the extreme cruelty charge that was put on, that the defense wants to negate and eliminate from this, this case. So I'd like to turn to one of the clips, and we'll talk about it right after.
To the jury, Mr. Favors is wearing the shirt, and I mispronounced the name, Favors and Favors.
And to do this demonstration, Doctor, does the fact that Mr. Favors is taller, is that relevant to show the trajectory of the bullet? The presence of the jury.
The general body size is going to vary between people, so this is merely meant to represent the general pathway. It's not exact, but it is the best representation that I'm able to do for the court.
Okay. Could you come off the stand, if that's okay with Your Honor? Could you come off?
Yes, sir.
Thank you.
If you would, Doctor, please keep your voice up, Ms. Kinnick. If you would keep your voice
Yes, I
up.
will. Thank you, sir. Could you sit down, Mr. Favors? All right, Doctor, could you, using the exemplar shirt with the two pieces of tape, which the two pieces of tape represent what?
On the right sleeve is the wound that we discussed earlier on the right upper arm shoulder area, and then in the roughly the center of the back is a little larger object that marks the exit wound on the back.
And could you position Mr. Favors in the position that you believe Mr. Furtado had to be based on your analysis of the abrasion collars, the trajectory, and the wounds?
The right arm would have to be extended out from the body. The body would have to be leaning to the right, and the line between those two markers, the entry and the exit, would have to then correlate back to the headrest.
Should I turn the chair, Your Honor?
No, leave the chair.
I don't have the headrest obviously to place here, but if I did, those would all form, or should all form, a straight line.
And does that show why it's different? It looks like it's a downward trajectory when you're doing it anatomically, but an upward trajectory when you're doing it based on the headrest?
Yes, ma'am.
And is there any other position that Mr. Favors has to be? His head is turning this way?
No, ma'am. Again, we discussed earlier the back head wounds. The head would have to be turned roughly in the same direction as the arm wound to get those abrasion borders. Again, the exit would roughly be here. I can't say specifically because I don't have a location out in space, so I don't know if he's tilting down or tilting up. All I know is it has to be, the shot has to come in at a sharp angle to the skin and then exit the back 2 inches lower than the entry.
Thank you, Doctor.
Anything further, Ms. Kennybud?
No, that would be it, sir.
All right. Do you have any examination on this issue?
Dr. Downs, can you just return to that same position? You have no idea whether all of this was taking place simultaneously, correct? In other words, you don't know that his head and his arm were in that position simultaneously, correct?
No, sir. All I can tell you is that there are 2 head wounds.
Yes or no?
Okay.
This arm position would also be consistent with this part of the arm resting on the door frame with the window open, correct?
Yes, sir. All I can speak to is medically what we call the arm, so the forearm I can't speak to.
Thank you.
Well, hold on now. Let's understand, what does that mean?
May I step down again?
Would the arm have been like this?
The arm had to be up, so the arm would be...
have to be extended, or?
No, sir.
I don't have any further questions at this witness.
Okay. All right, thank you. Now, Mr. Lee, as the result of
What it is that Ms. Kenny would seek to present and what we've just heard as to the visual demonstration by wearing the shirt, do you have an objection?
I just have one question to Dr. Downs.
Hi, welcome back to Law News Network. I'm Jesse Weber, and we're going to go right back live to the Aaron Hernandez double murder trial.
Doctor, your testimony regarding Mr. Furtado's position in the car was based in large part upon your examination of photographs, correct?
It was based on examination of the autopsy report, the autopsy photographs, the scene photographs, visiting the scene, and looking at the pictures of the car.
Okay. We looked at a fair number of photographs while you were doing your direct testimony regarding the position of Mr. Furtado. Do you remember looking at some of those photographs?
Yes, sir.
Okay. And some of those photographs were photographs, or at least there was one photograph showing a trajectory rod, the pink trajectory rod into the headrest of the passenger side. You remember that, sir?
Yes, sir.
Okay. And another photograph that we looked at while you were giving your testimony was the autopsy photograph of the wound to the upper part of Mr. Furtado's arm. Do you remember that, sir?
Yes, sir.
Okay. And when you look at photographs, which are obviously two-dimensional, they pose potential problems, don't they?
Yes, sir, as we discussed this morning, yes, sir.
Right. It doesn't allow you necessarily to get that three-dimensional perspective, and sometimes photographs can be a little bit misleading.
They can be misleading, and actually they can also be very specific and allow better interpretation than what might have happened otherwise.
Okay, so at times they can be really spot on, but at showing you exhibit number 372E. You recognize that as the injury to the upper right arm of Mr. Furtado?
Yes, sir, that's the entry one.
Okay, and this is an example of how a photograph might not exactly show what you think it shows.
I'm not sure what you mean by that question.
Okay. Well, you remember discussing this photograph during your direct testimony?
Yes, sir.
Okay. And you also, you agree with me that to get the best perspective of that wound, it's best to photograph it almost right on top.
Well, as we discussed, what you want to do is shoot a photograph when you get to that point perpendicular to the subject. So you would want to be with the camera going straight up and down, looking at that when you get to that point. That's not the point of this particular photograph.
Right. So in your view, this photograph, or there could have been angles taken of this injury that were more direct on, that is 90 degrees to the injury, the camera, that would have a better perspective, correct?
This photograph is taken for a different purpose. This photograph is taken perpendicular to the back to show the orientation of the body and where this wound is generally located. Later on, the close-up photograph is actually taken perpendicular to show the injury perpendicular to the surface.
Okay. But this particular photograph, now you mentioned that in a that you look at the wound and sort of you discuss it in terms of a clock, the face of a clock, right?
Yes, sir.
Okay. So if the face of the clock this wound actually looks like it's closer to 3:30.
Picture.
I'm not asking you what you know. I'm asking you that with the way this particular photograph is taken, it looks like the wound is closer to 3 o'clock or 3:30 than it does to 4 or 5, correct?
Could you erase the drawing, please, so I can... If I look at this, I get 3 o'clock. My arm's not quite as steady as yours. I apologize. 3 o'clock would be here, 6. So I'm seeing it somewhere in that kind of 4, maybe 4:30.
Well, allow me to differ with you.
What a question.
If you look at that wound, doctor, and a photograph could actually make the wound appear as if it's closer to 3:30 than 4 or 5. Do you agree or disagree with that?
Well, first of all, this body is not oriented properly, so there's a better photograph that's distant. You're looking at a cropped photograph of the back. If you can go to the whole thing, you'll see that what you've done here is basically turn the clock. So if we orient the clock properly, it's in the correct position.
I'm asking you, doctor, whether this photograph makes it appear that the wound is a little bit closer to 3:30 than it is to 4 or 5. Just yes or no.
I can't answer that yes or no, sir.
Okay. Now,
I can answer it and then explain.
There's showing you exhibit number 387. This is the photograph that Ms. Kenny Bodden was working with you in conjunction with exhibit number 385, correct?
Yes, sir.
And she lined those the photograph and the diagram up just like that.
Basically, yes, sir.
And you used that blue dotted line as a continuation out of the photograph onto a chart that was drawn, basically, correct?
That's correct.
Okay. And this can be a little bit problematic also, correct?
In what sense?
In what sense? Well, the chart is strictly two-dimensional. The photograph attempts to show some perspective, but you don't get that kind of perspective in this picture, do you?
What we're looking at is the best I can do to represent
It looks a little shallower.
No, sir. It looks like it's going at an upward angle.
Okay. And are you suggesting to the jury that this photograph appears the same to you as this photograph, for the record, 141 and 387?
I'm told they came from the same vehicle and are photographs of the same thing.
I'm not asking you what you were told. I'm asking you what it looks like to you.
It appears to me to be the same vehicle. I see the trajectory rod and the other headrest as well. So that looks to me to be the same area we're looking at.
Do you or do you not agree with me that the back end of the trajectory rod in exhibit number 141 makes it appear that the trajectory is sharper upwards than it does in 387? Just yes or no. If it doesn't to you, then it doesn't.
The rod is more angled upward the way the photograph is taken in the first one as opposed to the second one.
Okay. And in comparing 137 to 387, 137 appears even more flat than 387. Just yes or no. To you, does it or does it not?
You'd have to put both pictures up side by side, sir. And you'd have to pull it down so I can see the bottom, so I get a fiduciary, so I know what I'm looking at.
How's that?
That's pretty good. Those angles look very similar. I don't have any reason to doubt they're the same angle.
Okay. Let's assume, Doctor, for a moment that your analysis of the angles in this case, despite using photographs, let's assume for a moment that you're correct about the right arm being extended away from the body for this series of questions, okay?
Well, yes, sir.
First of all, you mentioned in your report the term right brachium. What does the term brachium mean?
Again, as I mentioned earlier, brachium medically is the upper arm. What we would call the arm is the brachium and the forearm.
Well, the brachium is the arm from the shoulder to the elbow, isn't that correct?
The upper arm, yes, sir.
Okay. And then there's below the elbow, which for layman's purposes we'll call the forearm.
Yes, sir.
Now, you filed or you submitted a report of your conclusions, opinions, and observations in connection with this case on March 5th of this year, correct?
I believe so, yes, sir.
Okay. And in that report, which was roughly, 5 to 6 pages?
I couldn't tell you how long it was. That sounds about right.
Okay. Your opinion says nothing about the position of the forearm. That is, the part of the arm below the elbow, correct?
I believe that's correct because,
All right.
again, as I said earlier, I can't position the forearm.
Correct. And, in fact, what you said was that the right brachium was raised to approximately shoulder level and extended outward. That was the conclusion that you drew in your first report there.
That's correct.
Okay. And may I have Mr. Favors, Your Honor, resume that position that he was in before with the demonstrative, as the demonstrative aid?
You may.
And, Your Honor, if I could have Dr. Downs come back down.
Doctor, if you would.
Thank you.
Selection step. And ask both to keep your voices raised, please, for our court report.
And if I could have Mr. Favors have a seat. Sure. And I'm asking you to do it because I don't want to get it wrong. Could you have Mr. Favors resume the position that is consistent with your opinion in this case?
Again, approximately hand open. And roughly something like that position. Leaning to his right. What I'm looking at is to this point. The rest of this is what we call anatomic position. That is, again, toes forward, palms forward.
And you can resume your seat. If you could just hold that position, Mr. Favors. Notice, Doctor, that when you put Mr. Favors in this position before lunch and today, you had his forearm extended.
Yes, sir. So I mentioned anatomic position.
But you don't know what the forearm was doing.
No, sir. I think I made that clear several
Then
times.
why did you have it extended as a demonstrative aid to the jury when you had no idea what the forearm was doing on the early morning of July 16, 2012?
I think I've said it 3 or 4 times. It's anatomic position, sir.
Okay. And it's true, Doctor, that you, in every chart that you did for this case, even though you had no idea what the forearm was doing, you drew the passenger of the seat with the arm extended out the window. Isn't that correct?
Every time I followed anatomic position, yes, sir.
Okay. Oh, Mr. Favors.
Sir, we're going to mark you for identification. Thank you.
Apologize, Dr. Downs, I misplaced something. So, Dr. Downs, your testimony is that the reason you had the individual's arm out like that was because that's the correct anatomical position, correct?
Yes, sir. I can't place any more than that.
And for no other reason but that?
No, sir.
Okay. Now, do you do that even when the chart that you're drawing is of somebody sitting in a car? Is it important to have correct anatomical position in the car?
You do it the best you can. For instance, in Mr. Abreu's case, I turned his position to his right a little bit in order to account for the shots to his body. The way they worked into the car, his body is turned to his right. His head is also turned a little bit to the right because this was not an instantaneous event. So in that case, I believe his head likely was turned to the right.
Wouldn't the correct anatomical position for Mr. Furtado have been to have his right arm extended as well as his left arm extended?
I don't know where his left arm was, and I was trying to be clear. It gets kind of busy in the middle, and yes, I do have his elbow with his arm in his lap there.
Well, you didn't know where his right forearm was either. And yet you drew that out straight.
But I did know where Mr. Furtado's arm was, so the fact that I have other people that I can't place precisely, I just dropped their arms down out of the way.
Well, you dropped Mr. Furtado's left arm down, but you took his right arm and you stuck it out the window in your chart, didn't you? Tell this jury that you have no idea whether his arm could have been sitting on the sill with his elbow bent. It's also consistent, is it not, Doctor, with the arm up and shielding somebody who's firing into the car. It's also consistent with just resting it up on the armrest, correct?
As I mentioned earlier, I know where the arm was. That's a fact.
You know where the upper arm was based upon your opinion. You said to this jury you had no idea where the forearm was. Didn't you say that to the jury?
I know that the forearm is attached at the elbow to the brachium. Assuming there's no break in the forearm being removed, it has to be attached. And as I've said several times, it could have been like this, it could have been out. I have that arm in anatomic position because I know that arm has to be there.
So your drawing, your rendition of the arm being out is simply to show the anatomical position, correct?
No, it's in anatomic position, sir. And again, in anatomic position, if I extend the arm out from anatomic position, that's all I can say is the arm is out this way. I don't infer anything beyond that.
May I approach the witness?
You may.
Someone objected to any pictures I didn't use with him. presenting news witness to present his opinion.
Overruled.
Do you recognize that?
Yes, sir.
Okay. That's a chart that you drew of the individuals in the car, correct? Or you prepared?
I actually prepared that, yes, sir, and placed it at defense's request after I had rendered my opinions.
Approach witness, Your Honor. That's another chart that you prepared, correct, Doctor?
Yes, sir.
Okay, and that one is different in that the only person being shown in that photograph or that chart is Mr. Furtado, correct?
That's correct. What I'm trying to do there is show him. Yes, sir.
Okay. Your Honor, at this time I'd ask that both of those be marked as exhibits.
May I see them? Sidebar that?
Welcome back to Law News Network. I'm Jesse Weber. We're taking a sidebar here in the Aaron Hernandez double murder trial. And I'm joined now by Julie Rendelman, a criminal defense attorney. Now, Julie, we were just watching the cross-examination of the forensic pathologist Jamie Downs. What was going on?
Look, I always have issues with any doctor or any expert who comes in there and says certain things are facts. He's there to give his opinion, and he's giving his opinion based on, certain things that he's assuming. And for him to, not be willing to kind of be a little more open-minded to the idea that the guy's hand may not have been actually out the window kind of troubles me in terms of his credibility in front of the jury. And I think that the prosecution is doing a nice job messing with him.
Absolutely. Look, his testimony is very important because he's basically determining the way that Safira Furtado and Daniel De Abreu were shot, the extent of the injuries, the nature of the bullet trajectory. That helps play into the defense's narrative that maybe it wasn't Aaron Hernandez pulling the trigger. And it also, I believe, attacks into the issue of the extreme cruelty charge. What was the nature of the wounds? Does this merit an extreme cruelty, first-degree murder charge? Again, I believe that it might be tough for the jury to pinpoint whether or not, can they rely on this gentleman? Do you understand what's being presented? The jurors, they're in the late part of this trial. How much are they taking in from these very specifics?
Well, I've been doing this a long time and I'm not taking in that much. and it's, I think this case, and maybe I'm naive, is about Bradley. And I think it's only about Bradley. I think that you can go back and forth between experts and they kind of distinguish each other. One says one, you expect the other to say the other, and they start to not mean anything. I mean, any rational person who's kind of looking at a scenario can take a guess as to the position of someone's arm based on where the injuries are. The person, just like the prosecution had said, could have been shielding, he could have been down further, he could have been up further. I don't think, and I could be wrong, that that at least this expert is going to make a whole lot of difference in terms of what the jury's final decision is.
You make a great point. I don't know if it was necessary to bring him on the stand. I thought the defense did a great job of poking holes in the prosecution's narrative and creating that reasonable doubt. And we've always talked, that you bring a witness on, you want to make sure you control what they're able to say, and you want to predict what they're able to say. You never want to ask a question you don't know the answer to.
Sure.
And I don't know if this will end up hurting their case, or maybe not hurting, but just not helping it in any way.
I think that's a great point. I don't think it's going to hurt them. I think it's just going to be a wash. I don't think he adds anything to them. The only negative is if they don't believe believe him, then whenever you don't believe a defense witness, you start not to believe the defense attorneys, because you start to question why they put him on the stand. And if you don't find him credible, then you start to question kind of the whole case. And that's always the problem with that.
Look, at the end of the day, it's going to be coming down to the jury, and it will be coming down to the closing arguments. You know, we have, and I find that to be very challenging. You have a whole collection of testimony and evidence, and in your experience, when you have closing arguments, how do you wrap all this around, and how would you be able to throw this testimony in there?
You know, look, I think the defense on this case has a more easy time than I think the prosecution does. That's my opinion. You know, for me, the defense really only needs to say three things, which is, you know, beyond a reasonable doubt, beyond a reasonable doubt, beyond a reasonable doubt, and I don't think they have that. I think that what you can do is take Mr. Bradley's testimony as a defense attorney, destroy it, and then use witnesses like this and other witnesses to show how what he's telling you is not correct. And so you can use him to the extent that he's credible, you know, meaning that the parts that we know are true about what he's saying. But again, if you were going to base your decision on him alone, I think that they'd have a big problem.
I agree with you. Let's see, are they coming back yet, or we still have some time? Yep, okay, was not quite yet. They're still in a little bit of a break. I want to go back to the earlier testimony from today. You know, and you know, we'll get back to that because the trial is about to resume. We'll be back with you in a minute.
Testimony was that you drew May I approach the witness? You may. That's the diagram that I showed you before, correct?
Yes, sir.
Okay, and that's the one only with Mr. Furtado in the passenger seat only, and it's got some dotted lines showing some purported trajectory, correct?
Those are the trajectories in blue, dotted arrows going through his head and his body, yes, sir.
And that's something that you prepared, correct?
Yes, sir.
You're on record on that marked by identification.
I did. I prepared it. The background vehicle is not mine. The body is not mine, other than positioning it.
All right, it'll be received K, 4 Ks.
Dr. Downs, so the right arm is extended and the left arm, is that anatomical position? Just
No,
yes
sir.
or
Again,
no?
I had to put him in the car, and so that's removed from basically there's a lot of going on in the middle, so I dropped it out of sight.
And you could have put his forearm in any number of positions, correct?
Yes, sir, but I did the best I could to approximate anatomic position.
Okay. And you could have put his left arm in anatomic position by putting it to his side, to the left of his left femur, correct?
Could you repeat that?
You could have positioned his left arm down by his side, closer to true anatomical position in this diagram, couldn't you have?
No, sir, I couldn't because it won't fit. Your arm is going to get stopped by the seat in the vehicle. There's also a space factor in there.
Okay. This is a chart, doctor. You couldn't draw that in there?
No, sir, I can't break physics. I can't move through solid objects.
Okay. So when you drew this arm out extended, that was for purposes of putting it in anatomical position, even though you had no idea what the forearm was doing. You actually drew a diagram here as part of your preparation showing Mr. Furtado holding a gun, didn't you?
That wasn't for my presentation, no, sir.
Who did that chart with Mr. Furtado holding a gun? Did you do it?
I created that from this artwork at the request of the defense. It was not part of my report. It was part of what I created.
Okay. So it wasn't just to put it in anatomical position, doctor. It was so you could show a depiction of Mr. Furtado allegedly holding a gun out the window of the car. Isn't that correct?
No, sir, you're misrepresenting.
Doctor, among the things that you examined in this case, you examined the autopsy report, medical records, radiographs, incident police reports, Mr. Haig's report, evidence reports and photographs, photographs of the BMW, the 4Runner photographs, videos of the 4Runner. You examined a site video. You examined physical examinations. You did physical examinations of the 4Runner, radiographs, and other evidence items. You looked at trial exhibits, and you looked at a number of photo downloads. During the time that you prepared for this case and prepared for your report, did you see one scintilla of evidence that Mr. Furtado was armed with a weapon the night of July 16, 2012?
The only evidence I would say...
Can you answer that question, yes or no? In all the materials that you reviewed...
Stop. All right, hold on. I think our poor court reporter could not get both of you speaking at once. Mr. Lee, you put the question, if you would.
Yes or no, in all the materials that you reviewed in preparation for your report and your testimony in this case, did you find one shred of evidence suggesting that Mr. Furtado was holding a gun out the window of that BMW on the morning of July 16, 2012?
Yes, with an explanation.
Please tell us what your explanation is.
The explanation is I know the arm had to be up. You asked for any scintilla of evidence. That's the only thing that I see is that his arm is out there. I don't know what his hand is doing. I know his arm's out the window.
Doctor, you said you said you had no idea what his forearm was doing.
Yes, sir. You asked me if I had any scintilla of evidence. I said that his arm was up. Again, I said multiple times, I don't know where his forearm was. I can only speak to this. I put him in anatomic position. I was done. I had my pictures. Again, defense asked me to create exhibits. You'd have to ask them why they wanted those exhibits created.
In the materials that you reviewed, Doctor, in connection with this case, was there any shred of evidence showing that Mr. Furtado had a gun on the morning of July 16, 2012, other than your conclusion that his arm was out?
Sustained as to that question, rephrase.
Leaving aside your professional opinion in this case that Mr. Furtado's arm was outstretched, did you see anything in the materials that you reviewed, showing that Mr. Furtado was in possession of a gun on July 16, 2012?
Hold on a second. Is it your professional opinion, Doctor, that Mr. Furtado's arm was outstretched?
Yes, sir. His arm being the upper one.
All right. His arm from fingertip to shoulder, outstretched or not?
Only to the elbow. I can't speak from the elbow beyond.
So meaning his
brachium
arm was raised?
Yes, sir. His brachium was raised. Again, he could have had his hand on his chest. He could have had it up to a certain extent because of the angles that the shot takes. It could have been fully extended. It could have been somewhere in between. But all I can say is this part, I can't really make my arm disappear at the elbow, but if I could, I can only speak about this part. I don't know about the forearm and the hand.
And that is the opinion that you hold to a reasonable degree of pathological certainty?
Yes, sir.
Very good. With that said, Mr. Lee, put a question.
So your testimony, Doctor, is that you don't know what his forearm and his fingers and his hand was doing.
Again, I think I've answered that several times that I don't know.
And yet you created a chart that purported to show what his forearm and his hand was doing, correct?
It's created to show the anatomic position that I can show.
I'm talking about the chart you created showing Mr. Furtado holding a weapon. You created a chart with him holding a weapon even though you just told us you have no idea what his hand was doing and what his forearm was doing and what his fingers were doing.
Again, I was asked to do that after I had completed this artwork, and you'd have to ask defense why they wanted it created. That's their business, not mine. Part of what I do in consulting is create courtroom exhibits.
And in the materials that you reviewed, there was no evidence that Mr. Furtado was in possession of a firearm on July 16, 2012, was there?
Well, no, this is limited to materials reviewed.
Again, if you're talking about the autopsy materials, I think I've spoken to that. There wasn't anything else that I saw that mentioned him having a firearm. if that's your question.
Now, Dr. Downs, you filed that report, or you submitted that report on March 5th of 2017, correct?
With great haste, yes, sir. I believe you needed it by midnight that day, and I frantically worked to get it out to you.
Okay. Doctor, you submitted your report on March 5th of 2017, correct?
Yes, sir.
Okay. And then you filed another report on March 26th of 2017, correcting some errors that you made in the first report, correct?
Correct. Standard practice when you find an error in a report is you draw attention to it and you issue an amended report.
You filed an amended report on March 26th of 2017 to fix a couple of errors that you made in your first report, correct?
A couple of typographical errors and a verb tense issue.
Now, Doctor, you then filed at 11:30 on Sunday night a 25-page supplemental report in this case, did you not?
Yes, sir.
Okay. I'm not talking about 2 Sundays ago. I'm talking about this past Sunday at 11:30. You submitted a 25-page report, almost 4 times the length of the first report that you filed, correct?
You're talking about adding photos in the supplemental report that weren't present. All told, I can't tell you how many pages of text the first report and the amended report were just text. So I really don't have a page count if you're looking at them to try to do apples to apples. Also, I believe I had more evidence in the first one, and I had my bio in there as well.
Approach witness, Your Honor.
You may.
Is that the supplemental report you filed, Dr. Downs?
Yes, sir. Just briefly leafing through it, it seems to be yes, sir.
Okay. And how many pages is it?
There's 25 pages total. Again, I don't know how many of just text.
And this time, Doctor, when you filed this 25-page report at 11:30 on Sunday night, your opinion changed, didn't it?
I don't know that it changed. I was more informed. I had additional information.
Let's talk about that. What additional information did you have Sunday night that you didn't have before?
I hadn't visited the scene. I hadn't seen statements about the shooting event. I hadn't heard the pathologist correct her error on the stand in her report. I went on the route from the Cure Club to the scene on Shamet, and I got additional weather information because that was an issue when I was here on Friday.
Okay. You heard Dr. Lindstrom's testimony on Friday, which you sat in on, correct?
Yes, sir.
All right. You already had the autopsy report. That was nothing new to you, correct?
Except for the parts that were changed.
Okay. And you had Mr. Haig's report. That was turned over to you.
Yes, sir.
One of the things that you looked at long before you filed the supplemental report, correct?
I looked at that. The supplemental report really was only that day, so it would have been the amount of time I had to look at that before I wrote my report.
Okay. And your new report contained the following new conclusion. Mr. Furtado, with head turned to the right, facing the other vehicle, and right arm extended towards the other vehicle, with body lunging somewhat towards the other vehicle. That was your new conclusion, Doctor, after listening to Dr. Lindstrom's testimony on Friday, correct?
That's correct.
Okay. So let's talk about that. Right arm extended.
Yes, sir.
You changed from the right brachium now to the right arm.
Again, they're the same. They're interchangeable words.
Okay. So you did not mean, when you filed your report, for arm to mean the entire arm. You continue to have the opinion that you do not know what the arm was doing from the elbow down, correct?
Medically, the term brachium is arm. So they mean the same thing. What I'm saying there is the brachium was extended.
Okay. But you used brachium in your report consistently. Then when you filed your new report, after taking in all this new information, you decided to call it arm.
Misrepresents the report as a supplemental report.
All right, let the question be completed, then voice your objection, and the objection is overruled.
So after using brachium consistently in your other report, you filed a 25-page supplemental report with a new conclusion, now calling it arm.
I don't believe it was a new conclusion. I believe I'm saying the same thing.
So you are, what you're saying, you're asking, doctor, you're saying that what I just read to you is the exact same conclusion that you drew in your original report?
I don't believe my conclusion has changed. I may have phrased it differently, but I'm saying what I meant to say the first time is the same thing I'm saying. Perhaps I'm using different words, but they mean the same thing.
Approach the witness, Your Honor.
You may.
Does that look like your amended report, the one that fixed the typos and such?
Yes, sir.
Okay. Can you show us in that report, or can you find in your report, your conclusion with head turned to the right, facing the other vehicle, arm extended towards the other vehicle?
I believe that was given to you photographically in the diagram that we're looking at here.
Doctor, is it in your report?
To me, they're one and the same thing, sir.
Can you show us in your report where the words "with head turned to the right, facing the other vehicle" appear in your original report?
On page 3, number 6, bullet number 5, the eccentrically prominent marginal abrasion border associated with the head wounds, more prominent with the posterior wound, indicates an angled entry traveling down, back, and left.
And are those the words "with head turned to the right, facing the other vehicle"?
That's what it means. It's the same thing.
That's not what I asked you, doctor. Are those words in your report, "with the head turned to the right, facing the other vehicle"?
No, sir, it wasn't.
Okay. And what about "with body lunging somewhat towards the other vehicle"? Can you show us where that's in your original report?
Same section, next bullet under that. The eccentrically prominent marginal abrasion border associated with the right brachium wound indicates the entry was anatomically directed upward during the initial portion of the path. The shirts had corresponding defects. The overall wound track courses, quote, right to left, slightly front to back, and without significant deviation upward or downward, end quote. The combination of the appearance of the entry defect, exit defect, and overall wound track indicate that the decedent's right brachium was raised to approximately shoulder level and extended outward.
Well, we covered that part of it, doctor. I'm looking for the 4 words "with body lunging somewhat." Are those 4 words in succession in your original report?
No, sir, they're not.
Okay. So your supplemental report contained additional words as part of your opinion that did not appear in your original report, correct?
Not in the written statements. Again, that's what I'm trying to show with the photographs or the exhibit, whatever number this is.
Now when we had Mr. Favor sitting here, you had him positioned with his arm out and with the lean, correct? You're not suggesting that all those positions were happening at one time, do you?
I don't know if they were happening at one time, other than the head wounds, I believe, happened virtually simultaneously.
Okay, so you positioned Mr. Favors with all of them happening at one time so that it looked very clear to this jury like he was shooting out the window of a car, didn't you?
I can't tell you what he was doing. Certainly that position would be consistent with that.
Did you explain to the jury that not all of the positions would be, you couldn't tell whether they were all being assumed at the same time?
I believe I tried to testify for that, and there was an objection.
The lien could have taken place before the raising of the brachium, correct?
I doubt that or the shots to the head.
Are you saying, no, I'm asking you whether the lien could have taken place before or after the raising of the brachium?
That could have happened immediately before or after if we're isolating just that injury.
Correct. So you don't know that the position Mr. Favors actually took in front of this jury was ever assumed in the car?
Both elements were taken at some point in time.
I'm not asking you that, doctor. You have no way of promising or showing to this jury that the position that Mr. Favors assumed in this courtroom was a position that he ever assumed in that car. You're just taking all of the positions and putting them together when you posed them. Isn't that true?
I put him in the position that the injury showed as I was asked to do.
Now, your CV is in the is in evidence, but there was a page on top of that.
Objection to the CV going in evidence, Mrs. Markman. Commonwealth objected.
And it was admitted.
It was marked by reputation.
No, it was admitted, counsel. It is an exhibit. You may put a question.
Doctor, your CV was admitted as an exhibit, but you recall that the top page of your CV was removed. Do you remember that here?
He may not have known that.
I don't think the doctor's aware of that.
Do you know what appears on the first page of your CV?
My logo and motto.
Okay, and what else?
It's kind of that sort of thing.
Does that look like the top page of your CV?
Yes, sir.
Okay. And there's a fairly lengthy first paragraph there, correct? And it's basically a paragraph about what you do. Fair to say?
What I've done in my career, yes, sir.
Okay. And that paragraph, towards the end of that paragraph, lists a whole bunch of TV shows that you've been on, correct?
Yes, sir.
National Geographic.
Yes, sir.
C-SPAN.
Yes, sir.
The New Detectives Case Studies in Forensic Science.
Yes, sir.
Forensic Files.
Yes, sir.
Street Stories.
Yes, sir.
Dateline.
Yes, sir.
48 Hours.
Yes, sir.
And also contain the fact that you consulted on some movie called Rosewood.
No, that's actually a television series. The movie was The Insider with Al Pacino and Russell Crowe.
Apologize, I don't get out much. And that you consulted with Patricia Cornwell, correct?
Yes, sir.
Okay. All those things that you have on the first page of your CV, they appear before where you went to medical school. Doesn't it?
I'd have to read it.
Well, what page is your education on?
I believe it's on the second page.
Second page.
Actually, this ran over a page, so I cut out a whole lot to make it fit on a page.
So where you went to undergrad, where you went to medical school, where you did your fellowship, all came on the second page of your CV, and all your TV appearances came on the first page of your CV, correct?
Again, this was an introduction that's used for people that want me to come speak before groups. They like that kind of thing.
That information also appeared before information that you provided about your medical licensure, correct?
If you say so, sir. I don't see that on the first page, so I assume it's on the other pages.
I have your CV for you.
And this is actually my CV bio. That's why the second page is actually listed CV, and the first page is not. So on my CV, my specialty certification, all of my education is on page 1 of my CV.
And all your board memberships and professional memberships and your publications all appear after your TV appearances, correct?
Not in my CV, sir. Actually, my CV doesn't list any of that at all. The cover sheet that isn't numbered, that's why when I was asked if there were 8 pages and she had handed me 9 pages, I made the distinction, the important distinction of saying, I've got 9 pages. The first page, it's called a CV bio. The computer file is actually CV bio. So what you're reading from me, to me, is my bio.
So, Dr. Downs, your testimony is that when you did this chart and when you changed your opinion or augmented your opinion about what Mr. Furtado was doing in the front seat of the passenger of that car, front seat passenger seat of that car. Your testimony is that you didn't do that because it would make a better opinion if you said that his arm was extended and that he was lunging out at the other car.
Hey, I don't believe he was lunging out at the other car. His body was lunging. By that I mean he's going toward the window. I only added a supplement to my report to reflect additional opinions that I had based on everything that we've talked about.
Well, you added a supplement to your report so that you could say that the body was lunging toward the vehicle, didn't you?
To use those words in there, obviously I didn't have it stated in that way in the first report, but in the supplement it's clearly as stated.
Okay. Now, Dr. Downs, what do you bill out your services at?
In this case?
Yes.
I've worked about 150 hours. I got paid for 2.
And what do you bill for an hour's worth of work?
Depends on what I'm doing and depends on who I'm working with. My typical rate would be $500 an hour.
Okay. And you are only to be paid for 2 hours, or that's all that you've been paid thus far?
That's all I've been paid. The artist that did the diagrams actually made over twice what I made in the case.
Have you submitted an invoice?
No, sir. I plan on getting reimbursed for my expenses, which have been a couple $100 maybe.
And how many hours of work are you going to include on your invoice?
0. As I said, I've been paid. I got 2 hours payment. I agreed to take the case for that. So I've donated 148 hours on this case to date.
And you donated your time on a case that's received tremendous amounts of publicity, correct?
I wouldn't know.
You don't know that this case has received a tremendous amount of publicity?
Not in my area, sir.
Didn't you and I have a discussion about that this morning?
You'd have to refresh my memory. I think I said, up your way it's getting publicity. In my area, we didn't talk about it.
Okay. Didn't we talk about Mr. Hernandez and Mr. Hernandez's role in the sports world here in Boston? You don't remember that conversation?
We talked about that he played football, and obviously I think everybody knows the Patriots.
Okay. So when you say you did not know that this was a high-profile case, that's not exactly accurate, is it?
I knew that you were working very hard, and figured cases like this are bound to get attention, but honestly, I can't remember seeing a single story in my local newspaper about this case at all.
Well, your local newspaper is what, Charleston?
Savannah.
Savannah. Are you saying that you've seen no coverage of this case?
Not from trial. It may have been years ago, but honestly, I read the sports page. My wife will tell you, I start with a sports page every day.
Dr. Downs, you also formed an opinion as to the number of shots that were fired in this case. Is that correct?
Yes, sir.
Okay. And you state, or your opinion is that there were 6 shots fired.
Yes, sir.
All right. And are you saying that there were 6 shots fired to the exclusion of any other possibility?
No, sir. There could have been more shots, but I believe there were at least 6 shots.
Well, do you believe there could have been 1 less shot?
No, sir. I don't think the evidence shows that.
Okay. So your opinion is that there were at least 6, but absolutely not 5, correct?
I can't see any way to account for all the victims, the vehicle, with 5 shots.
Your opinion, doctor, is that there were 6 shots, but not 5, correct? Yes or no?
Yes, that's correct.
Okay. And that 6th shot, as we discussed today, is the graze wound to Mr. Frier's left forearm, correct?
That is one of the likely possibilities, and I believe that's the one I came up with based on what I had originally.
Right, and that's what you called in your report the 6th shot.
That's correct, the one that we saw in orange.
And the conclusion that you, well, let me back that up. The information that you based that on is what?
Everything that's listed on both of those reports. Okay. If you'd like me to go through it again.
Well, when you say both of those reports, did you take into account Mr. Frier's version of events?
I believe I saw that after the initial report. If you bear with me just a second. I believe that's correct. I saw that video
Okay.
after the first report.
Well, you submitted, as part of your materials, highlighted reports, police reports, in which Mr. Friere stated that he believed he was hit in both arms. You highlighted those reports, so did you read those?
Yes, sir.
Okay, so you had an account from Mr. Friere about what he thought happened, correct?
That's correct.
Okay.
As well as the medical records.
Okay. Now, the medical records, you reviewed those, correct?
Yes, sir.
All right. And you'd agree with me that nowhere in the medical records is the term graze wound from a bullet or bullet graze wound used.
That would be redundant. You wouldn't normally say graze wound from a bullet because a graze wound is a bullet wound.
I see. So when when Ms. Kenny Vodden was questioning you today and asked you to tell the difference between a graze and an incised wound, you said the word an abrasion is like a scrape. Didn't you say that in response? You didn't even use the word grazed. You used the word abrasion, didn't you?
Never use the word scrape.
I believe what I said. I'm sorry, Your Honor.
No, you have good instincts. The objection's overruled. You may answer.
I don't believe I said scrape. I believe I said like falling on the sidewalk and skinning your knee.
And that's what you described twice as an abrasion, correct?
Yes, sir.
And that's the word you were using in the context of graze.
Yes, they're in this instance they're interchangeable.
And now you're telling us that bullet graze wound is redundant because that's what a graze wound is, a wound caused by a bullet. Isn't that what you just said to the jury?
If I'm understanding what you're saying right, what I said, I'll try to repeat it, is grazing bullet wounds cause abrasions.
Okay. What I'm asking you is, in your review of the medical records, did you see an entry anywhere that described the wound to Mr. Friere's left arm to be a bullet graze wound or a graze from a bullet?
No, sir. Again, I wouldn't typically see that.
Okay. The question is whether you did see it, doctor.
As with other cases, sir, no.
Okay. And you have no idea what that wound looked like, correct?
Other than what's documented 5 times in the medical record with a picture, no, sir.
Well, you didn't see it, did you?
No, sir, but I have the medical record of the wound, and I have Mr. Friere's statement and Police Officer James and Detective McIsaac referring to it.
Right. Detective McIsaac and Officer James repeating what Mr. Friere told them, correct?
I couldn't tell you that. I don't believe anywhere that's made clear.
Well, you don't know. You know from having read or seen Detective McIsaac's testimony on video that he wasn't at the scene when the shooting took place, right?
I don't remember specifically. Whatever I saw from that testimony was very brief. It was only directly related to the injuries, and I don't know who said what.
So is it your testimony, doctor, that in your mind, Officer James and Detective McIsaac could have possibly been at the scene when the shooting took place?
Objection, that's not what you're testifying for.
Those statements that were made to Officer James, strike that. Officer James's account and Detective McIsaac's account both indicate that the information came from Mr. Friere, don't they?
I would have to go back and specifically read the report. You could ask them where they got the information. All I know is that in the official document it's referred to.
First witness, Your Honor. You may.
Doctor, if you take a look at that report and just take a look at the highlighted sections. That's a report you reviewed, correct?
Yes, sir. Okay.
Does that refresh your memory as to whether Detective McIsaac was reporting what Mr. Friere was telling him?
I can only tell you what he says here. Mr. Friere was suffering from
Doctor, don't read from the document. My question is, does it refresh your memory as to whether Mr. Friere was the source of the information that he may have been shot in the arms?
It does, yes.
Okay. And what is your memory now as to the source of that information?
Again,
Not what the report says, sir, but what is your present memory as the result of having reviewed?
yes, sir. It attributes one statement directly to Mr. Friere with no statement that it came from anywhere else. And another specifically separated by half a page specifically states, attributes it to Mr. Friere.
Thank you.
And the second, Mr. Friere's statement follows the one from Detective McIsaac.
So you didn't see the wound, you didn't treat the wound, and you have a description of the wound from the medical records, correct?
That's correct.
And the description of the wound in the medical records does not indicate at all that it's a bullet graze or graze from a bullet wound, correct?
It says twice that it's a graze wound, and 3 times I believe that it's an abrasion.
Okay.
So that's a total of 5.
And is it your testimony that abrasion and graze wound in that context are not interchangeable, or they are interchangeable?
Bullet grazes can cause abrasions. Not all abrasions are gunshot wounds.
What I'm asking you is there anything from the medical records from which you could conclude that the graze was caused by a bullet?
Independent of removing everything that I know about the case and the circumstances, it says an abrasion, which is a scraping injury.
Okay. And you are aware, doctor, or are you aware that the doctor who treated Mr. Friere testified here and said that he did not intend to in any way suggest by his use of the word graze that it was a bullet graze? Are you aware of that testimony?
That's an objection. Sustained.
May we approach, Your Honor?
No, I don't see a need.
So you have a description of a wound as an abrasion and a graze, and Mr. Friere's conclusion or opinion that he was struck in the arms by a bullet. Is that correct?
And Detective McIsaac's statement that it was a graze gunshot wound.
Now, would you agree with me, doctor, that if Mr. Friere turned out to be incorrect, that indeed the injury on his forearm was not caused by a bullet, that you would have to rethink your opinion?
If you were to be able to show me that that was not a graze wound, then I guess you'd have to relook at the data and consider it in that context. But
well, my question is, would you agree with me that if Mr. Friere turned out to be incorrect and the wound on his arm was not caused by a bullet, that you would have to rethink your conclusion that there were 6 shots fired in this case?
I think it's safe to say I would have to look at the case. There are other possibilities that could account for 6 shots.
Okay. Now, you're aware, doctor, based upon your experience of instances in which people under high-stress situations, such as being fired at, either think that they've been shot when they haven't been, or don't realize that they have been shot until some time afterwards. Have you ever heard of that situation?
I've seen people that have not known they've been injured. That's not the situation here. Apparently, Mr. Friere, according to the records that I've seen, was quite aware that he had been shot and stated that multiple times, and that was then carried over into other medical records, police records.
Okay.
The other part of your question of people not knowing it's there, that can happen, that people are unaware.
Okay. So when Mr. Friere says he was shot, clearly he was shot in the right arm because there are 2 holes and a bullet was recovered from his right arm, correct?
That's correct.
Okay. Now, in your review of the materials in this case, did you review any grand jury testimony?
I believe at some point I was told or shown something about Ms. Freer saying his arms were up, after I had come to that conclusion myself.
Were you aware, Doctor, in your assessment of whether Mr. Freer's opinion about the wound on his left forearm, whether that was caused by a bullet or not, were you aware that there were 2 witnesses who testified in the grand jury and at trial?
I'll see you.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'm your host this afternoon, and I'm joined today by attorney Julie Rendelman, and we're listening to this really tricky cross-examination, heated at times, of this pathologist, forensic pathologist named James Downs. He goes by Jamie Downs, and I think it's been effective. I think that the state has gotten some good jabs in at this particular witness, including his one drawing where the one victim has a gun in his hand, and he said, well, I just put that there because the defense asked me to.
Sure.
I think that probably summed it up for the jury.
Yeah, I think that certainly shows a lot of bias on the part of the defense witness. With that said, I will say one thing, though. I think it's enough already. I think they've just, I think they should have hit their points and hit them a little more quickly. I think the jury starts to get a little bored with the repetitive questions. That's my take on what I see.
Is this designed perhaps to be a little bit of a closing argument wrapped up in a cross-examination?
Sometimes, and every prosecutor does their own thing when it comes to cross-examination. Sometimes I think we're all guilty of not knowing when to sit down. And so, there's so many points he can make regarding, how much he was paid by the defense and his bias towards the defense, and the fact that it seems to me that the TV seems to be the most important thing to him, like the attention and the fame. I just think they can be covered a little more quickly and getting to the point. I think it starts to get lost to the jury if you're up there a little too long.
Yes, and this case has not been one that's had. It's not been known for its brevity.
No,
It's been known
by any stretch.
It's been known for being long-winded, and even the judge himself chastised not only the prosecution but the defense on it at one point, saying that he was struggling to remember a case where he heard more argument wrapped up, especially in sidebar, and we're in the middle of one again.
Yeah, I mean, one wonders if part of the reason that there's so much talk is that this is a trial that's being shown to many different people in the media, and so one wonders if there, because of that attention, both the prosecutor and the defense feel even more obligated to kind of speak more and to be a little more, I guess. I don't want to use the word theatrical, but in a way, because you're performing not just from the jury, but you're performing for those who are watching.
Yeah, I want to go and play clip 7 from today, if I can, so we can listen back into some of the more colorful testimony from this particular forensic pathologist. We might not get to that because it looks like they've just come back from the sidebar, so we're going to cut you back into the courtroom in Boston as soon as we can. I also want to mention that we're monitoring our second trial here. This is the trial of Stephen Jones in Arizona, who's accused of shooting and killing one person, shooting and injuring 3 others just outside a college campus in Arizona. So as soon as opening statements begin in that case, we're going to bring it to you. We don't anticipate that happening until a little bit closer into the evening, but let's go back to the courtroom in Boston.
All right, Mr. Lee, put the question.
Dr. Downs, are you, in your assessment of whether to credit Mr. Freer's version of having been grazed by a bullet, did you take into account Mr. Freer's grand jury testimony on that score?
I believe I saw a snippet, maybe 4 or 5 lines, that was just talking about the hands being up.
Okay. Did you review his grand jury testimony at all?
The only thing I believe I saw was that snippet. It was like a screen capture, 4 or 5 lines of typed words.
And is it your testimony that that's all you saw or reviewed?
That's all I remember seeing, yes, sir.
Okay. In looking at the video testimony from this trial, did you look at Mr. Friere's video testimony?
Yes, sir.
You did?
I watched everything. It was about an hour-long segment. But I was really only paying attention for the part where he's talking.
You realize, do you not, Doc, trial testimony was that he didn't know what caused the graze wound on his arm, correct?
Again, I'd have to go back and look at that to tell you what he specifically said.
Well, in assessing whether to credit Mr. Friere's version, did you take into account Mr. Friere's trial testimony that he didn't know what caused the injury to his left forearm?
I took into account everything when I saw it, so this was obviously in my supplemental report. What I'm looking at is contemporaneous stuff that was recorded when it happened versus 5 years later.
Doctor, in assessing whether to credit Mr. Friere's version of events, did you take into consideration his trial testimony that he had no idea or did not know what caused the graze wound on his left forearm? Yes or no?
That was a minor consideration. I held more credibility to the earlier statement.
Okay. So is the answer yes, Doctor?
I believe that's how I started that answer, sir.
Okay. Did you read Mr. Friere's grand jury testimony?
Again, I believe I saw 4, maybe 5 lines that were a screen capture of something.
Were you aware, sir, that Mr. Friere testified in the grand jury that when he got out of the car that he thought he had been shot in the foot?
I believe somewhere in the records I saw the thigh. I don't remember seeing foot.
Did you take into consideration when you were assessing whether Mr. Friere was accurate about whether the wound on his left forearm was caused by a bullet, did you take into consideration that he thought he had been shot in the foot originally?
I didn't see that anywhere, and just so it's clear, the thigh shot, I don't know that that was attributed to Mr. Friere or not.
So the answer, Doctor, is that no, you didn't take it into consideration. Isn't it?
It's your testimony, Doctor, you were not aware of that. Is that correct?
That is correct.
So you couldn't have taken it into consideration.
That's correct.
All right.
So you were unaware that Mr. Friere thought that he was shot in the foot when he first got out of the car. Yes or no?
No.
And you didn't see any indication in the medical records of Mr. Friere that he had been shot in the foot, correct?
No, sir.
Okay. Now, in assessing whether Mr. Friere may have been right or wrong about the injury that was caused to his left forearm, did you take into consideration trial testimony from an individual who said that a person fitting Mr. Friere's description was on the ground in front of near the car after the shooting?
Sustained.
Were you aware, sir, that Mr. Friere had
And welcome
fallen
back
down?
to the Law News Network, everybody. I'm Aaron Keller, and we're in another sidebar in the Aaron Hernandez double murder trial in Boston. We're listening to a forensic pathologist testify about how he lined up whether or not there were 5 or 6 shots fired. He's saying there were 6. We've heard from many of the witnesses that there were either 5 or 6, and all of the Commonwealth's experts say that there is forensic evidence of only 5 bullets being fired. So Julie Rendelman, former prosecutor, you're here with us watching this. If you were prosecuting this case, how would you try to deal with this discrepancy between 5 bullets and 6 bullets?
When you're talking about that, do you mean in terms of cross-examining this witness or just in general?
In general trial strategy.
I mean, you know, I don't think it really matters at the end of the day. I think that, you know, when you're a witness to something like a shooting like this, first of all, a lot of times when shots are repetitive, you don't know exactly how many are fired. You know, secondly, people either don't remember or that's not what they're paying attention to. Do I think that whether there's 5 shots, 6 shots, or 7 shots, that is going to define whether or not Mr. Hernandez is guilty of murder? I don't. And so I have to be honest, that wouldn't be my focus as the prosecutor. It would be used to corroborate things that my main witness said, at least in the areas that I can corroborate. But other than that, it's not, my case better not be defined by that, or I'm going to lose and lose quickly.
Well, here's the thing. We've heard from the judge that one of the jury instructions will say that the jury cannot convict based solely on the testimony of an immunized witness.
Sure.
Well, The witness is immunized, Alexander Bradley. In theory, he could be an accomplice, okay? At a minimum. At a maximum, the defense believes that he's the one that actually pulled the trigger here, and he's just trying to blame it on his old friend. So they have to corroborate something here, or under Massachusetts law, there can be no conviction. And one of the things that the state, the Commonwealth, is trying to use to corroborate that Aaron Hernandez was tied up in this thing is this tattoo with a gun that he has that shows 5 bullets in the chamber, but not 6.
Right.
And the judge allowed this testimony from the tattoo artist saying that he specifically requested this, meaning Hernandez specifically requested 5 bullets in the chamber. And the defense attorneys yesterday tried to argue that it makes no sense that there should be 5 empty chambers if he truly shot 5 bullets and not 5 loaded ones, but that seemed to be a cart before the horse argument for me, because maybe the tattoo is in theory depicting the number of bullets he had in the chamber before he pulled the trigger to indicate that's how many he fired. So this 5 or 6 bullet thing, I mean, is that enough to corroborate and to go over the testimony of whether or not there were 5 or 6 bullets? You know, they need something other than Alexander Bradley, and it seems like the tattoo is one of the few things that they have.
But I think that there's other aspects of corroboration. Remember, corroboration doesn't have to be huge. It can be simple things. So merely having a witness in the other car saying that there was a drive-by going on where individuals were in the car, that can be enough to corroborate. Witnesses or evidence that the guys were in the bar is corroboration of the witness's testimony. So keep in mind, it doesn't have to be necessarily anything specific, just as long as there's some evidence of corroboration. I don't, you know, the tattoo is certainly helpful. That's certainly going to be something that I would certainly use as prosecutor to show that Hernandez is responsible. But corroboration can come in the most subtlest forms in this case.
So it need not be a very high bar.
Correct.
Okay, very good. We cleared that up. So I think that it accounts for some of the belaboring of the points that we're seeing here. And then some of it goes back to the way the attorneys are asking questions, because some of these questions, in my opinion, and I've said this before, could be way more pointed than where they are. And you rolled your eyes and you seem to agree.
Yeah. Again, everyone's style is different. And I didn't pick this jury, they did. And so when you pick a jury, you're picking a jury that you think kind of likes you and understands you. And so they may be playing to the jury. So their questions may be, you know, what they think the jury is going to like. I would like, if I was sitting there, to have just, you know, I think we talked about brevity, you know, like, you know, more succinct and getting to the point. Because I think people, just like anyone, get bored.
Yeah, and we do too.
Yes, we do.
You know, we're waiting for them to return from a sidebar here, and it's one of many. But of course, this witness hasn't been interrupted as often as some of the other witnesses we've seen in this case, thankfully. So when they come back, we will come back. I also want to update you while we're waiting, though, on the next trial that we're following here at the Law News Network. That is the murder trial of Stephen Jones in Arizona. He is a young man accused of shooting 4 people, killing one of them outside a college campus in Arizona. The jury has been selected, we have learned, from the courtroom, and the jury is taking a break until about 2 p.m. Pacific time. That's 5 p.m. Eastern, and around that time we're expecting to hear the opening statements in that case. If those opening statements do indeed happen today, we will carry them live for you. We will be here until they conclude in that case, which would be around 8 p.m. Here in the East Coast, or 5 p.m. out on the West Coast. So that's what we're doing with Stephen Jones. We're standing by for that. And in the meantime, while we're waiting for things to come back in the Aaron Hernandez trial in Boston, I want to go back and play clip 7 from today, because this is where we heard some of the discussion about whether or not the particular witnesses' drawings were truly accurate to the evidence that we have on the murder scene.
First of all, you mentioned in your report the term right brachium. What does the term brachium mean?
Again, as I mentioned earlier, brachium medically is the upper arm. What we would call the arm is the brachium and the forearm.
Well, the brachium is the arm from the shoulder to the elbow, isn't that correct?
The upper arm, yes.
Okay. And then there's below the elbow, which for layman's purposes we'll call the forearm.
Yes, sir.
Now, You filed or you submitted a report of your conclusions, opinions, and observations in connection with this case on March 5th of this year, correct?
I believe so, yes, sir.
Okay. And in that report, which was roughly, what, 5 to 6 pages?
I couldn't tell you how long it was. That sounds about right.
Okay. Your opinion says nothing about the position of the forearm. That is, the part of the arm below the elbow, correct?
I believe that's correct because,
right.
again, as I said earlier, I can't position the forearm.
Correct. And, in fact, what you said was that the right brachium was raised to approximately shoulder level and extended outward. That was the conclusion that you drew in your first report there.
That's correct.
Okay. And may I have Mr. Favors, Your Honor, resume that position that he was in before with the demonstrative, as the demonstrative aid?
You may.
And, Your Honor, if I could have Dr. Downs come back down.
Doctor, if you would, please watch your step. And ask both to keep your voices raised, please, for our court report.
And if I could have Mr. Favors have a seat. Sure. And I'm asking you to do it because I don't want to get it wrong. Could you have Mr. Favors resume the position that is consistent with your opinion in this case?
Again, approximately hand open, and roughly something like that position. Leaning to his right. What I'm looking at is to this point. The rest of this is what we call anatomic position. That is, again, toes forward, palms forward.
And you can resume your seat. If you could just hold that position, Mr. Favors. Notice, Doctor, that when you put Mr. Favors in this position before lunch and today, you had his forearm extended.
Yes, sir. As I mentioned, anatomic position.
But you don't know what the forearm was doing.
No, sir. I think I made that clear several
Then
times.
why did you have it extended as a demonstrative aid to the jury when you had no idea what the forearm was doing in the early morning of July 16, 2012?
I think I've said it 3 or 4 times. It's anatomic position, sir.
Okay. And it's true, Doctor, that you, in every chart that you did for this case, even though you had no idea what the forearm was doing, you drew the passenger.
Okay, folks, we were listening back to some of the earlier testimony that we heard today from this defense witness who's a forensic pathologist, but we had to cut out of that old testimony because they're coming back into session in court. So let's go straight to the courtroom in Boston live.
I considered that glass might have caused an injury to his arm.
Okay. You did consider that?
Yes, sir.
Did you consider that he could have hurt his arm or scratched his arm falling down on the street?
Certainly, you can scratch your arm from falling.
Okay. And in fact, you specifically used a skinned knee as an example of an abrasion, correct?
When you fall, typically you hit pressure points, so you would hit elbow, knees, shins, that kind of thing.
Doctor, you indicated that you watched some of Mr. Frier's testimony on video. Did you happen to watch the portion of his testimony in which he was describing to the jury the position of his arms at the time he thought the shooting took place?
I believe that is it was about an hour long. That's the segment that I actually watched.
Okay. And approach with it, John?
You may.
Do you recognize that, I guess it's really a capture of a still?
Yes, sir.
All right. And that's Mr. Friere actually in that witness box testifying or on the witness stand as part of this case, correct?
I believe that's what it is, yes, sir.
All right. And fair to say that in that particular image, he appears to be demonstrating something. Is that correct?
Yes, sir.
Is that among the things that you took into consideration when you watched and viewed his trial testimony in this case?
Yes, sir.
All right. Your Honor, at this time, I'd offer that as the next exhibit.
No objection.
Without objection.
389.
Showing you what's been admitted as exhibit number 389. Doctor, did you take that into consideration when in determining whether Mr. Friere was correct about whether the inside of his forearm had been grazed by a bullet?
I considered his position, his relative position, that captures him on the stand going through what he's recalling now.
Okay. Now, the chart that you created in connection with your work on the defense case also has Mr. Friere positioned in the middle of the back row, correct?
That's correct.
And the way you have him positioned in that is with his arms directly in front of him, outstretched. I don't know, was it palms down or palms up?
I didn't really put that either palms down or palm up. What I did was look at that point in time, the shot I knew had to come to his right arm and lodge there. Again, that one comes back to the back shot, ends up starting as the arm shot to Mr. Furtado. So that's all one line. So that allowed me to say, okay, this arm has to be relatively up. Again, I don't have the vehicle, which would be ideal to position it exactly, but that's what I'm working with to position that arm. The left arm I positioned because I know I've got this graze wound here. And that, again, I account for by that sixth shot. You asked me earlier if there are other possibilities. There are other possibilities for another sixth shot.
So, Doctor, so when you positioned Mr. Friere with his arms forward, you're not suggesting that that's the way he was sitting. You're suggesting that his arms were forward of his body, relative to his body, correct?
Yes, sir. That's correct. And
all right. The answer is yes.
Yes, sir.
Thank you.
And Doctor, when you just demonstrated that the position now, you had your left hand with your left hand facing the right, correct?
Correct.
All right. And that would expose the inside of the forearm to the person's right. Is that correct?
That's correct.
All right. And you realized that the graze wound was to the inside of his forearm, correct?
It was to the front of his forearm.
To the front. When you say front of his forearm, what do you mean? Could you point on your body?
Again, anatomic position. As you were positioned, it would be rotated, so it would be the inside in this position. But anatomic position, this would be the inside.
And so, as you just had it, with the left hand facing to the right, with the front, did you call it the front of the forearm? I'm sorry.
The front, yes, sir.
The front of the forearm also facing to the right. You'd agree with me that if gunshots were being fired from the right, his inside forearm would actually be in the line of fire, correct?
Depending on where that forearm is positioned, yes, sir.
So a bullet coming from the right, approaching the inside of somebody's forearm, actually wouldn't graze it, it would actually hit it.
As you have your arm positioned, yes, sir, it would. That's what I meant about motion. It depends on when that shot occurs.
Well, that's how you had your arm positioned, Doctor. I was just doing what you did. Isn't that how you had your arm positioned?
I was just doing what you had me look at, sir.
Did you take into account this version of events from Mr. Friere? That is what's shown on 389 when you considered whether Mr. Friere could have been right or wrong about having a graze wound caused by a bullet as opposed to broken glass, falling down, or anything else like that?
Again, glass causes incisions, not abrasions. But I did consider reasonable possibilities, such as possibly falling down, that type of thing.
Now, you also mentioned that your belief or your opinion was that the graze on the inside of Mr. Freer's forearm possibly could have been caused. Mr. Haig's report in connection with the shooting reconstruction that he did?
Yes, sir.
All right. And other than some issues that you took with some of his medical assessments, you found his ballistics analysis and his shooting reconstruction analysis to be quote-unquote valid, did you not?
Generally valid, I believe, was a term I used, and I wouldn't rely on a layperson to have medical opinions.
All right, so leaving aside the medical opinions for a second, Doctor, did you not say, in general, as regards his non-medical findings, Mr. Haig's reconstruction is valid, correct?
That's what I just said, yes, sir.
You're aware that Mr. Haig's reconstruction has the bullet exiting Mr. Furtado's head as striking impact areas B and C in the vehicle. Do you remember that?
That is, I believe, one of his opinions, yes, sir.
Okay. And that the jacketing that was found on the back seat of the car, as well as the piece of fragment found on the left elbow rest, you're aware, sir, that Mr. Haig concluded that that was a candidate for the projectile that struck impact sites B and C, correct?
That's correct.
And that the fragment that was found on the left elbow rest had embedded glass in it, correct? You remember that?
It had scoring on the surface, excuse me.
And embedded glass?
I believe so, yes, sir.
Okay, and no blood?
I believe that's correct.
So that was on a completely different trajectory, wouldn't you agree, than the one that Mr. Freer was in the line of?
I'm not sure I'm following you in terms of this position.
Well, what I'm asking you is that you opined to this jury that one of the possible causes of the graze wound in Mr. Furtado's left arm was the projectile that exited Mr. Furtado's head.
That is a possibility.
Okay. And when you say it's a possibility, did you take into account Mr. Haig's report that you found to be valid that suggests that that bullet was on a different trajectory than the one that Mr. Freer was on?
Again, I said generally valid, non-medical.
Okay, so you have an issue with that aspect of Mr. Haig's report? Is that what you're telling us?
I have to see exactly how he phrased what he phrased. Generally, he accounted for 5 shots and said there could be a 6th, and I believe that clearly the evidence shows that there are 6.
Okay, and that's if you believe that Mr. Freer is correct that that graze wound was caused by a bullet, correct?
Well, there's other, again, you asked me if we exclude that, are there other ways to account for 6 shots? And yes, there are. Easily.
You called the injury to Mr. Freer's arm, inside arm, as having been caused by, quote unquote, the 6th shot, correct?
That's correct.
Okay. So if he's right, if he's incorrect about what caused his wound, there would be no 6th shot in that context, correct?
No, sir, that's not true.
Okay. The 6th shot that you referred to was a reference to the bullet that purportedly or supposedly caused the wound to Mr. Freer's inside left forearm, correct?
I believe that's, if I'm following your question, I believe, could you repeat it for me?
Well, it's in your report. You called that shot the 6th shot.
Based on the totality. Let's say, for example, yes, sir.
Doctor, all I'm asking you is whether you referred to the shot that you allege caused Mr. Frier's wound on the inside left forearm was the shot that you called the sixth shot, correct?
The objection is sustained. I think the witness answered that in the last response. That is what you wrote.
Yes, sir, that is what I wrote.
Very good.
And therefore, if Mr. Frier is incorrect that that wound was caused by a bullet, there would be no sixth shot in that context, correct?
No, I don't believe it has been.
If you're asking if that was not caused by a bullet, there's still a sixth shot.
And that sixth shot that wasn't called by a bullet, even though that's what you did call it, the sixth shot that injured his left forearm. The other sixth shot now is the bullet that you're alleging came from the exit wound in Mr. Furtado's head?
No, sir, I have to account for the projectiles in the car. One of the projectiles fragmented. That fragment either went one way or the other. It's not going to do both. If that bullet fragmented and caused this injury, then another shot track has to follow in the vehicle.
What fragment are you talking about?
Well, I don't have a specific fragment because the windows were open.
So you're saying if there was a fragment that never got recovered, that fragment could have caused the wound?
Well, we know there were pieces that weren't recovered.
Doctor, what I'm asking you is, are you telling this jury that the sixth shot is some imagined fragment that went out the window?
No, sir, there's no imagined fragment, sir. What I'm trying to explain is under the scenario that I've demonstrated, clearly shown the 5 bullets within the vehicle, there's a sixth shot. The arm is up there in the scenarios I've laid it out in my report. That's the sixth shot.
That's not what your opinion is in your report, is it, Doctor? Your opinion in your report is that the sixth shot is the shot that hit Mr. Furtado, or allegedly hit Mr. Furtado, on the inside of his forearm. I have nothing further.
Is there any redirect?
Yes, sir. I'll try to be very quick, Mr. Mark, may I have the
Dr. Downs, I'm back. Dr. Downs, Mr. Lee just questioned you for well over a half an hour about this graze wound. You looked at the grand jury testimony of Mr. Ferrer on July 10th, 2013?
I don't recall the date. I think I just saw grand jury testimony and about 4 or 5 lines.
That approach. Would you just look at this for yourself and see if that refreshes your recollection about seeing grand jury testimony, Mr. Ferrer?
Yes, ma'am.
And that was grand jury testimony from July 10th, 2013?
I didn't look at the date, but I'll take your word for it.
But you remember seeing this testimony, correct?
I remember seeing the part that I put on top of the stack as I handed it back.
And do you remember then reading questions to Mr. Freer by Mr. Hagan? By the prosecutors. You wouldn't know who's who.
Yeah, I don't know who asked the questions. I just remember like a question and answer response.
And do you remember seeing that the question was asked under oath in a grand jury to Mr. Freer? Where did you get shot?
Yes, ma'am.
And do you remember him seeing in my right arm?
Yes, ma'am.
And do you remember Mr. Freer getting asked by the prosecution, and did that bullet stay in your arm or did it exit your arm?
Yes, ma'am.
And you remember reading, answer, one stay, one just passed, you know, just crossed. You remember seeing that?
Yes, ma'am.
And you remember seeing the question to Mr. Freire, sorry, say that again for the record. Answer, one bullet, stay inside. You remember that?
Yes, ma'am.
You remember seeing the question? Yes. And the answer, and another one just, you know, just cut a little bit. You remember seeing that?
Yes, ma'am.
And you remember seeing the question by the prosecution to Mr. Freire, question, just grazed you?
Yes, ma'am.
And you remember seeing the answer, Mr. Freire, yes?
Yes, ma'am.
And did you take that into account when you determined that Mr. Freire, along with the medical records that you saw, had a graze wound to the left arm?
Yes, ma'am.
Now, with regard to your testimony with regard to the sixth bullet, besides a bullet, did you see anything that could have broken the glass in the left rear car of that BMW?
No, ma'am.
And with regard to your CV, sir, or your bio, which is one page, not your CV that you testified to, when you did those TV shows, was that when you were a medical examiner for various counties?
For various jurisdictions, I believe. Charleston, South Carolina, Mobile, Alabama, Savannah, Georgia.
And did those jurisdictions want and or authorize you to do those TV shows?
Yes, ma'am. The last one I...
Hold on. Sustained.
Did you get permission to do those TV shows from the jurisdictions you were working for?
Sustained.
Sir, were you were there to promote yourself individually, or you were there to promote in those TV shows the medical examiner's office for which you worked for?
Overruled.
I was there to basically work for the office and the agency. We had police agencies as part of the same program to tell the story.
Okay. So it was not for your personal benefit?
No, ma'am. Actually, I'm kind of a private person.
Did you get paid any money for those TV shows?
No, ma'am. I actually did all of them while I was on salary, so I was paid by whatever jurisdiction I was working for while I was doing those, so they had full knowledge that I was doing it and full support. In fact, the last ones I did it for GBI, we were in the autopsy room at GBI filming segments of it, at the conference room at GBI filming segments of it. They had a hotel room that the Dateline was in, I think, and we had the investigative agent went before me, and they filmed all of that.
Okay. And that's not on your CV, that's on your bio, correct?
That's correct.
Okay. Now, with regard to another couple other questions that Mr. Lee asked you, were you aware, sir, that two men left the BMW and left the scene?
That's my understanding, yes, ma'am.
Were you aware, sir, that one, Mr. Sanchez, destroyed evidence to wet his clothes?
Sustained.
Were you aware, sir, that Mr. Sanchez burned his clothes?
Sustained.
Sir, when you did this, let me have this marked, if I may.
For identification?
Yes.
Show it to the Commonwealth if you would.
It's no picture.
Okay. Thank you.
Not as a chalk
Judge, I intend to use it as a chalk fish. To open the door.
I'll see you at sidebar.
Doctor, I'm going to show you now what has been marked for identification, LLLL. That's the exhibit that you had drawn under your tutelage at our request, correct?
Yes, ma'am.
Okay. Now, sir, the prosecution asked you some questions about that and about the placement of the arm. Sir, is there anything in your report that precludes Mr. Furtado from holding a gun as pictured in that exhibit, that drawing, excuse me?
Not at all.
Did you see anything medically that prevented him from holding a gun until he was shot?
Not at all.
And you drew this at our request, correct?
I created that at your request. The parent images, if you will, were provided to me, and I then painted it from this.
And then, sir, when you went to the scene at Chalmette, did you see something that was interesting to you? Mr. Lee discussed you just going to the scene recently, correct?
Yes, ma'am.
And did you see something that was interesting to you?
Very interesting, yes, ma'am.
What was that?
As you come down Chalmette to Herald, the road dips as you're coming to Herald. And in addition to dipping, the left-hand lane dips toward the curb a lot. I noticed this, we were in the middle lane, and I could see the cars to my left were all angled.
No, overruled.
Right. And what does that mean for your opinions that you gave today with regard to the ability of the shooter to require to have free arm movement?
Sustained.
Did that hill affect your opinions in any way?
Yes, ma'am.
Sustained.
Now, let's talk about the additional supplemental report that you did at our request. First, let's go to the original report. When you read questions from Mr. Lee, did he ask you whether you mentioned the exemplar shirt, which seems to have...
He didn't ask me about that, no, ma'am.
All right, and could you go to page 3 of that report?
I don't have it in front of me, but I probably can answer the question.
All right, well, let me walk up to you if the judge okay. So I want to go a couple of page 3, the last page. First one? First one. I'm holding also the exemplar shirt. Could you tell the jury? He questioned about what opinions was not in his report. I can't. I'm sorry. I apologize.
The objection's overruled.
Could you read the ladies and gentlemen jury what you told all of us with regard to this exemplar shirt?
Bottom of page 3, quote, the latter, that would be the right arm raised to approximately shoulder level. The latter is confirmed by means of comparison of the decedent's shirt with an exemplar shirt with defects placed in the exemplar corresponding to the position of those in the decedent's shirt, end quote.
And sir, when you did your supplemental report, it was not an amended report, right? It was a supplemental report, correct?
That's correct. It supplemented the original.
The answer's yes.
Yes,
yes.
Sorry.
Thank you.
And that was after you sat here and listened to Dr. Lindstrom testify, correct?
Yes.
And your report indicated observations that you had regarding our testimony, correct?
Yes.
That you conveyed to us, correct?
Yes, ma'am.
And you know that we were going to convey to the prosecutor.
Objection. Sustained.
Did you change any opinions in your original report that discussed the angulation and the abrasion borders and the trajectory?
No, ma'am.
Did you change any opinions at all from the original report?
No, ma'am.
And sir, as you sit here after you were cross-examined by Mr. Lee, does anything that you were asked change any of the opinions that you testified to this jury this morning?
No, overruled.
No, ma'am. Nothing changed.
And were those opinions held within the reasonable degree of certainty that somebody who does wound analysis, reconstruction, and pathology holds?
Yes, ma'am, they were.
Thank you, Dr. Downs. I have nothing further.
Commonwealth? Thank you. Doctor, you may step down, please. Watch your step.
Thank you.
Could we take the item off of the screen
And I'll give it to Ann.
and collect our exhibits? And Mr. Baez.
Yes, Judge. We have one composite group of photographs that we'd like to be stipulated with Mr. David.
no objection on it. They are duplicates of a lot of what we have, but we have no objection to a separate exhibit. Assistant clothing.
All right, these will be received as Exhibit 389. I'm sorry? 390. I've been off by one almost all trial. Exhibit 390.
Then, Your Honor, Mr. Hagan, ladies and gentlemen of the jury, the defense rests.
Commonwealth.
No rebuttal evidence, Your Honor.
No rebuttal evidence. Ladies and gentlemen, the defense has rested, meaning all the evidence the defendant deems appropriate for your consideration has been presented, and the Commonwealth is not seeking to present any further rebuttal evidence. That means the evidence is now closed. All of the evidence upon which you will deliberate to determine the facts of this case has now been presented. There are 3 remaining segments to this trial. The closing arguments of the attorneys, followed by my instructions of law, followed by your deliberations by 12 of the 15 of you. I think, as I told you at the beginning of the trial, which 12 that will be is not yet known, because we will draw 3 of your probably seat numbers out of a barrel to serve as alternates, and that's not yet occurred. That will happen tomorrow before deliberations commence. We are going to adjourn, as far as you're concerned, until tomorrow morning at 9 a.m., when we will hear the closing arguments of the attorneys, and then I suspect tomorrow afternoon the instructions of law that I will be giving you, and then 12 of you will commence your deliberations. Please understand, all the restrictions that have been in place throughout this trial remain in place. By that I mean, between now and ultimately, when you have returned verdicts or been discharged, you must avoid any contact with the case. You must avoid any discussion with the case other than by 12 jurors during deliberations, and you must avoid any outside contact with this matter. So between now and tomorrow morning, put the case out of your mind. Please don't discuss it, read, hear, or see anything about this case. Don't attempt to learn anything about this case on your own. Enjoy the evening. We'll see you tomorrow morning.
Welcome back to the Law News Network, everybody. I'm Aaron Keller, and I'm joined by attorney Julie Rendelman, who is a former prosecutor. She's been watching the case along with us here at the Law News Network. And Julie, we just heard 2 interesting things. The defense rested, and the Commonwealth said it would not present a rebuttal.
Yep. Look, I mean, the truth is usually rebuttal in New York, rebuttal evidence can only exist if there's something new to introduce. One would think that everything they had that was worth anything was introduced from the start. So I'm not really surprised. And I think any rebuttal evidence they would have used at this point, again, and I hate to repeat myself, would be kind of, again, belaboring a case that should go to the jury already. That's my take.
Let me ask about this, because one thing that's concerned me about this case is this discrepancy about the murder weapon. And I've discussed it frequently, and I would think that if I were sitting on the jury, that I would still have questions about whether or not the weapon that the Commonwealth was parading around in front of me was the actual murder weapon, because it wound up into evidence through this lengthy, convoluted chain. The state police in Massachusetts found it in a case in the trunk of a car down south of Springfield, Massachusetts, between Springfield and Hartford, Connecticut, right on the state line after a car accident, about a year after the double murder. And then they sent it off for testing, and the striations on it, the ballistics, indicated that it matched the bullets that were fired in this double murder. And then it turned out that the person driving the car had gone to the same high school as the defendant, although she wasn't there at the same time as the defendant, and she knew some football players, but then who would have wound up with a gun and when and how is just a big question mark. So and I'm sitting there scratching my head saying, okay, so what's up with the gun? And then, we get the state's key witness on the stand, Alexander Bradley, and he says that it was a different type of weapon that was used in the actual killing, in his words. And then he said that the murder weapon was thrown out the window somewhere on the Mass Pike. So if I'm to believe Alexander Bradley, which of course the Commonwealth wants me to do because he's the one who's pointing the direct finger at the defendant, then do I believe him in saying that the murder weapon was a different type of weapon and that it was thrown out the window on the Mass Pike? And then how does it wind up in the trunk of this car this lengthy amount of time later?
I think your version is as convoluted as the version is in terms. I mean, because it doesn't make sense. Here's the thing, though, about the one thing that I think that I think about when it comes to Mr. Bradley and his testimony. I think everyone would agree that someone from that vehicle shot the two guys in the car and killed them. Whether it was Bradley or Hernandez is a question, obviously, for the jury to decide. But I think that they've made it clear that Bradley was in the car with them. Mm-hmm. And so, if Bradley was in the car with them, you would expect Bradley to know what the weapon was and what happened to the weapon. Is it possible that he's telling the truth, that Hernandez is the shooter, but he just can't remember, and so he's filling in those blanks so he sounds more credible to the jury? That's possible. Or is it possible he's just making it up because he doesn't want it to relate in any way back to him? That's also possible.
Yeah, it's just one of these discrepancies that I was wondering if we were going to see that cleaned up, possibly with some kind of a rebuttal, but apparently not. So I'm anxious to see how the closing arguments go. But I think the judge is back on the bench in the courtroom, so I want to go to that as soon as we're able to take the feed, because there may be a few matters to discuss here that we want to listen to. So we do have it. Let's listen in.
I find that there are other factors or circumstances that could explain and would explain why certain witnesses were not called. What that means by way of missing witnesses is the defense is free to argue that the evidence presented at trial is insufficient to meet the Commonwealth's burden of proof, and in doing so may argue the absence of evidence, including the absence of certain witnesses. Counsel may not, however, go on to argue that because a witness was not called, their absence permits an inference that their testimony would have been unfavorable to the Commonwealth. As the SJC has stated in Salatino, there is a clear distinction between those two arguments, and holds that while the first is permitted, that is, commenting on the absence of evidence, the second, mandating or permitting an adverse inference, is not. I am going to distribute to both sides a synopsis of Massachusetts case law as regards what our appellate courts have talked about in terms of proper and improper arguments in closing arguments in Massachusetts. This submission is taken from Jury Trial Bench Book, 3rd edition, published by the Flashner Judicial Institute, and serves as a fairly helpful guide as to what is proper and improper in closing arguments. I'll also let both sides know that in advance of closings tomorrow morning, I may give the jury an instruction with regard to closing arguments. That instruction, Commonwealth versus Finstein, and Ms. Fein, S-T-E-I-N. Finstein found at 426 Mass 200. And it's pretty good guidance to the trial court by the Supreme Judicial Court. All right, is there anything else we should attend to now? Commonwealth?
We did file a motion, may be taken care of by what the court just handed out, but we filed a motion relative to precluding certain impermissible
Arguments by both.
Well, the two top ones. Voir dire questions were. The court, I don't think, ever gave a limit. Bias, well, again, something that.
Have to hear what is argued in cause. If you feel that something is argued that is improper, or in the context in which it's argued improper, object at the time. I know that particularly experienced trial attorneys, and you are certainly one, don't like to object during the closing argument. But to ask me to rule in advance on what is permissible and impermissible depends in large part on the way in which it is argued and presented. So I'm not inclined to rule in advance.
Your Honor, I'm hard pressed to find a way in which it would be permissible to comment on the Commonwealth's voir dire questions.
I don't know, I'd have to think about that.
Welcome back to the Law News Network, everybody. A couple of points there, and we're sorry that the feed was cutting in and out, so we're just going to do some analysis here in the absence of having anything more coming to us from the courtroom. But the defense rested, and the Commonwealth indicated that it would present no rebuttal. The closing arguments will occur tomorrow, and then the judge will give instructions to the jury, and then 12 of the jurors will deliberate with 3 alternates drawn out of a barrel. So that's the procedure that we plan to be able to give you tomorrow. We were listening in, though, to some discussions between the judge and the attorneys outside the presence of the jury. The judge gave both sides proper case law on what Massachusetts courts consider proper and improper during closing arguments. There have been many discussions about exactly what can be said by both sides, and the hope is that by following those arguments, the closing arguments will be done without interruptions and objection. One thing that the judge did say is that the defense cannot argue that missing witnesses would have been damaging to the prosecution. But the judge said that the defense was free to argue that evidence is insufficient and that certain evidence and certain witnesses are absent, therefore giving an incomplete picture of what may have gone down with regards to the murder and the investigation. So I actually wrote an article on LawNewz.com, if some of you want to take a look at it, about the Bowden instruction that the judge is planning to give, and under Massachusetts law that basically is an instruction as to how the jury can consider testimony about an incomplete police investigation. Before that case was decided by the appellate courts in Massachusetts, there was an issue with whether or not a jury could actually consider specific pieces of evidence that were not brought in, and a defendant in that case had argued that, wait a minute, there's just not enough evidence here because the police did an incomplete job investigating my case. The judge in the Bowden case said that was an improper argument, and it was overturned, which led to the so-called Bowden instruction as to exactly what a jury can and can't consider when a police investigation is incomplete or when there are allegations of incomplete investigation and incomplete evidence. So if you'd like to read that article, it's on LawNewz.com. I explain the case, and we also have a copy of the model jury instruction on that particular situation, which of course is highly relevant even here. So that's where things are going throughout the day here and what we expect to hear tomorrow. So that's where things are headed. And Julie Rendelman, you're listening into things with us here. This is almost the end.
Yes, it's almost the end.
You say it with a smile.
Yeah, I think it's time. Unfortunately, I think we're going to have some very lengthy summations on both sides. I would think that there's not that much to cover because although it was a lengthy trial, there's not that much evidence. But I think neither side is going to be able to sit down with covering their points quite aggressively and arguably repetitively. They're going to be hard pressed to sit down in short of an hour, if not much more.
It would be nice if we had brief closing arguments here, but I don't smell that in the wind.
No, I don't smell that. I don't smell that either.
Yeah, so I'm hoping that we get this issue with a gun cleaned up, or that the Commonwealth at least makes some effort to try to indicate who we're supposed to believe.
Yeah, look, I mean, their case rises and falls again with Mr. Bradley, and that's why I think they have problems. It's hard enough when you have one witness. Now you have not only a witness with a record, but a witness who now has immunity with a record. And so to sell that person to a jury is very difficult. So I think that they're going to have quite a tough time getting that jury to buy kind of what he's selling. And so I think you're going to hear what I hope that the prosecutor's going to do is try their best to build on every single thing that Bradley said, to corroborate even the most subtle things, because any little bit you can show, if that's corroborated, that there's truth to what he's saying. And also, I think one of the issues is in regards to Bradley being shot. I think that will be something that really aids the jury, if they buy it, that he was involved in tying Mr. Hernandez to the murder as well.
I'm very interested to see how the Commonwealth tries to tie all this together. We had these people from this cabaret, this nightclub, whatever you want to call it, in Florida, testifying about Hernandez's behavior there and who he was with, where they were. They were in this hotel room and then at this cabaret, and then Bradley winds up getting shot, and the people at the nightclub said, oh no, Hernandez wasn't upset, he was cool, he got along with everybody, he was better behaved than any other athlete, which opened the door for character evidence, which apparently the Commonwealth doesn't have anything to rebut. Interesting. We've talked about that before, because under the evidence rules, both federally and in Massachusetts, they could have thrown everybody on the stand to say Hernandez punched him out after a Pee Wee football game,
Sure.
assuming that such a witness might be out there. They're not even going there. So, I thought that was interesting as well, legally.
Yeah, I'm not sure why they wouldn't go there. There's nothing better than getting a jury to think he's just a bad guy, so he did it, and they gave him an opening to do that. So I'm not really sure. I don't know if are they giving up? I don't know what. I don't know what it is.
I wonder. I really
there's
do.
Certainly, I can promise you that there's people out there that have plenty to say negative about Mr. Hernandez, other than Mr. Bradley. As to where they were going, I don't know.
Yeah, so closing arguments tomorrow. We are going to be waiting with bated breath to see where those go. And in the meantime, here at the LawNewz Network, we're going to jump into the Stephen Jones trial in Arizona. Before we do that, though, I want to thank you, Julie, for coming in and watching this and trying to make sense of it with us, because we know you have to run. So we'll see you on the next case at some point, we hope. But here's what's going on in Arizona. We have Stephen Jones, a young man who's on trial for allegedly shooting 4 people, killing one of them outside a college campus there. This whole thing came to be after some attempt to wreak a bit of havoc with the fraternity rush season, and it resulted in an argument spilling out on the streets, and then the defendant allegedly going back to his car about 90 feet away, coming back with a gun with a light on it, and then firing shots at 2 people, and then stopping, and then at some point point later firing shots at 2 more people. So that's what we're expecting to discuss here coming up on the Law News Network with relation to the Stephen Jones trial out of Arizona. Here's where that stands right now. The jury selection started yesterday in that case. And that spilled over into the day today, but a jury has been impaneled and they're on a break. And we're expecting the opening statements in that case to start at around 5 p.m. today here on the East Coast, 2 p.m. out on the West Coast. We don't know whether both sides will get their opening statements in or not, but that's what we're expecting. So while we're waiting for those opening statements to occur, and of course we will be carrying them live, I want to go play some of the material we have gathered here at Law News from preliminary matters in this case, so you can get up to speed on the attorneys and the judge and the defendant and exactly what we're expecting to hear in the trial. So let's listen into some of the preliminary hearings in the Stephen Jones case in Arizona.
All right, good afternoon, everyone. This is CR 2015-00862, State of Arizona versus Stephen Jones. Mr. Jones is present with counsel, Mr. McCowan, Mr. Davidson. Good afternoon to all of you. The state is represented by Mr. Ammon Barker, Mr. Brian Shea. Good afternoon to both of you as well. There's several motions, 2 motions that we're here to decide and to hear, have argued. The defense has filed a motion to remand to the grand jury for a new determination of probable cause, and also a motion to review conditions of release. I should also indicate that I believe we have some victims here, and we have victim representatives here as well. Is that correct?
That is correct, Your Honor.
Okay. I'm going to take the motion to remand first. So, Mr. Davidson, it's your motion.
Thank you, Your Honor.
Go ahead.
Your Honor, the defense raised several issues in the... Your Honor, we can get my address to court from here.
Whatever's most comfortable for you is fine, just as long as you can keep your voice up so that Steve can take down the argument.
Certainly, Your Honor. Your Honor, the defense raised several motions in its motion to remand. The state filed a rather expansive response, including a lot of facts that not only are in dispute but aren't really germane or even relevant to the discussion and the issue of whether this case should be remanded back to the grand jury. As the court's well aware, the grand jury is there to act as a check. It's there to act as a balance against the prosecutor's power. It provides the accused the ability to make sure that there's probable cause before felony cases can be filed. I wasn't there, Mr. McCowan wasn't there, obviously Mr. Jones wasn't there. It was incumbent upon the prosecutor to present clearly exculpatory evidence. It was incumbent upon the prosecutor to present evidence in a fair and impartial manner, and they failed to do that. And irrespective of how many pages of irrelevant facts they include in their response, talking about double taps and tactical flashlights and .40 caliber Glocks, they spend actually very little time addressing the issues that are problematic for them with regard to the way that they presented this case to the grand jury. And I think that's pretty apparent. In terms of the actual issues themselves, Your Honor, I think the 2 or 3 that are most troubling and to defense and should be troubling to the court is the manner in which Nicholas Peering's hospital statement was presented to the police. Let's be very clear about this. Nicholas Peering, who is one of the alleged victims as to the aggravated assault charges, was shot during this incident last October. He was transported to the hospital. He was in the emergency room. He was contacted by Detective, I believe Jacob Ellis is his name. Detective Jacob Ellis conducted 2 interviews with Mr. Peering. They were both recorded. The state has those recordings. They disclosed them to the defense. In those recordings and in those interviews, both times that he talks to Mr. Peering makes it very clear. He basically says that he went across the street from the courtyard and that he came up behind a group of people where Colin Broad, the decedent, was, And essentially, just as Stephen approached with the flashlight, which we now all know was attached to his gun, and said words to the effect of step back or get back, that from an elevated position, essentially either right behind or shoulder to shoulder with Colin Rowe, that Mr. Peering jumps forward. That's important. And the state knows that's important because this is a self-defense case. This is a case where they've taken the somewhat astonishing position that Mr. Jones acted with self-defense, or acted with premeditation. Excuse me. Now, Mr. Jones made it abundantly clear, he was interviewed by the police well before they went to the grand jury, Your Honor, that he believed that these two people were advancing on him. Those two people being Mr. Breaux and Mr. Peering. Mr. Peering himself, Your Honor, admitted as much to the police at the hospital hours after the shooting that was basically what he was doing. It may not have been his intent, according to his statement to the police, to jump at Stephen or to attack him or to do him harm, but we have to look at this through the lens of how it was perceived by Mr. Jones. And when Mr. Jones tells the police that these two gentlemen, these two individuals were advancing at me, and the state, incidentally, is going to take issue with that, it would seem like a rather important fact that one of those two individuals himself essentially admitted that he was jumping towards Mr. Jones. But they didn't present that. And it's worse than that. If it ended there, it would be bad enough, but it's worse than that, because when they present the case to the grand jury, what they presented was this second interview that Mr. Peering gave. Curiously, a week and a half later, with two detectives and two prosecutors in the room. And now all of a sudden, Mr. Peering is, well, I was actually 10 to 12 feet away when I saw Colin get shot, and then I approached where Mr. Jones and where Colin were. That's the only statement from Mr. Peering that they presented to the grand jury. And the worst thing about it, Judge, is that they not only completely ignored the statement that Mr. Peering gave at the hospital, but when they presented the subsequent statement that Mr. Peering gave to Mr. Shea and Mr. Barker, they characterized it as being the statement that he gave at the hospital just hours after the shooting. There's no dispute that that wasn't what he said at the hospital. And they characterized it as such. That, Your Honor, is a misstatement, and it's not a trivial one. It's a misstatement that operated to prejudice my client and to deprive them the right to have a grand jury make an informed decision about this case. Now, the state takes the position in its response. The state takes the position in its response that, well, Mr. Peering's initial statement at the hospital was ambiguous, and geez, he was being treated for injuries, and gosh, how did we even know that he knew what he was talking about? That's why we went and talked to him later. Well, his statement was actually pretty clear. I mean, the detective not only didn't have any problems writing in a report what Mr. Peering said at the hospital, but he actually recorded it. And I want to play for the court. I don't know if it's marked, if I could inquire of your clerk what exhibit the disc is. 2. Exhibit 2, Your Honor, is a CD or a DVD with 2 audio recordings. One of them is the interview with Nick Peering at the hospital that the state characterizes as being taken out of context in Mr. Jones's motion and being less comprehensive than the subsequent statement that they obtained.
Without objection?
No objection.
2 is admitted.
Thank you.
All I know is altercation. They were going across the street. I went over there and see what was going on. He was talking. I'm listening. He was talking to one kid. If he was talking to one kid, the other kid is back there where he comes. Kid comes from the parking lot.
Okay, stop. I gotta get listen to it. I mean, I can't. That microphone is not working, so I gotta get it. Sure. Go ahead, play it again.
All I know is altercation apparently. They were going across the street. I went over there and see what was going on. He was talking. I'm listening. He's talking to one kid. And he's talking to one kid. The looking, and back away, the little one comes. Kid comes from the parking lot. East side, comes to the parking lot, shines a flashlight, back up. Actually, everyone else saw wrestling and make the move. Next thing you know, the flashlight and the gunshot. Colin, my roommate, to the left of me, south. Next thing you know, he drops to the floor. And I didn't even take a step in. I jumped over a bush, and I get hit once, and this one doesn't form. I think I hit my arm first. This is facing, and I didn't even know what was going on.
And Your Honor, actually there's one other. There was a pause where medical staff was attending to Mr. Peering. The interview recommenced.
I don't know, so I ran up, I knew there was no location, I was trying to calm people down. I jumped over Brad Avenue into a roadway, right, and it's a 2-foot gap in the roadway and the parking lot. So I was trying to calm people down. And I went over there and I was like, hey, come down, come down. I stepped back and at the exact moment he said step back, I jumped from the top to the lower part, and I got shot in the theater. So we more towards that east side, or more on the street in Franklin. I was running up behind people, trying to calm it down. Mainly trying to calm my roommate down. Yeah. And there's about 4 people on the opposite side of us, and then 3 of which were like, okay, they were like, leave. I don't even know if it's more than shot the flashlight, like step back as I was jumping. Colin was like kind of heading towards me, and kind of looking towards someone else. And he put the flashlight up, and as soon as he did, he started shooting. No, I didn't.
Thank you. The audio speaks for itself, Your Honor. Mr. Peering said that he ran up. There was a 2-foot gap between the elevated position where he was and the edge of the parking lot where Mr. Bro was. And at that exact moment when Stephen said, step back or get back, he jumped. He said that twice. Where's the ambiguity? There is none. It was all too ambiguous. That's the unambiguous, and that's why they didn't present it. And again, this is no trivial, unimportant fact. This is central to the issue of whether Stephen acted with premeditation and whether he acted with reasonable self-defense. Similarly, Your Honor, we have a situation where Kyle Zintek's statement was not properly conveyed to the jury. Although perhaps not as blatant as the omission from Mr. Peering, Mr. Zintek says that Colin, the decedent, stepped up to Stephen right before shots were fired. The state tries to accuse that and say, well, when pressed on it, he said it was 4 feet away, as if someone stepping up from 4 feet away is somehow less intimidating than someone stepping up a distance of 3 feet away. Whether it's 3 feet or 4 feet or 2 feet or 6 feet, when looked against the backdrop of all the underlying circumstances and the assault that he had just suffered, the fact that you have one of the victims, a friend of the decedent, telling the police that the decedent, who was shot by my client, who claimed self-defense, had stepped up to him the very moment before he was shot, could not be more exculpatory. And to characterize it as anything other than clearly exculpatory simply doesn't hold water. I simply can't envision a scenario where we could have a situation where someone is shot and the person who fires the gun says, he was attacking me, I was in fear for my life, and the state sits on a statement from another witness who was present that the alleged victim stepped up to the defendant or the shooter just seconds before the shooting happened. I think these two omissions by themselves, Your Honor, certainly collectively require that this case be sent back to another grand jury to be reconsidered and to be reevaluated whether probable cause exists. There's also some dispute, Your Honor, about whether the state should have presented evidence about Shay McConnell's statement that Mr. Breaux had punched Stephen right before the incident occurred. I don't think there's any dispute that Stephen was punched. He had a bloody lip. His glasses got knocked off his face. He had a lot of injuries that were noted by the detectives who investigated the case, okay? So it's not a question of whether he was hit. It's a question of who hit him. Shay McConnell says that he thought it was Colin Breaux, identifies him as wearing the same white shirt that Mr. Breaux was seen wearing as the one who punched Stephen. Now, the state goes out of its way to point out that no one else says that Mr. Breaux was the one who punched Stephen. What they don't point out, though, is that no one says that it wasn't Mr. Breaux. So the only real statement we have identifying the person who punched Stephen was from Shay McConnell. And Shay McConnell said it was Colin Breaux. Well, that fact isn't particularly expedient to the state's case, and that likewise was left out. The fact that Colin being identified as the one who punched Stephen was couched in terms of I thought it was him, or that Mr. McConnell used the word thought or believed when he described to the detectives that it was Colin who threw the punch, doesn't give the prosecutor license to omit that information from the grand jury. If they want to cross-examine Shay at trial and say, well, you said you thought, you didn't say you were certain, that's fine, but we're not at trial. This isn't supposed to be a mini-trial. This is supposed to be a fair, impartial, and complete presentation of the evidence for the grand jury to consider. If they were so hung up on the fact that Colin Breaux was identified by Shay, and Shay used the word thought or believed when he identified Colin, they could have conveyed that to the grand jury judge. They could have said that Mr. McConnell said that he thought Mr. Breaux was the one who punched Stephen. They didn't even do that. They withheld it from the grand jury. And again, the grand jury made a decision, a non-unanimous one, I note, to indict Stephen without knowing that one of Stephen's friends identified the decedent as the person who punched Stephen just moments earlier. One of the other issues that the state takes issue with and suggests that because Mr. Jones is cited as the source of that information is the fact that Colin Breaux was leaning or lunging towards him when the shots were fired. I don't think the court requires me to elaborate in any great measure of detail as to why that is perhaps one of the most important issues of this case. When the post-mortem was conducted, the track path, or the wound path, for the two wounds, gunshot wounds that the decedent suffered, had a downward path. It's interesting because in my motion, Your Honor, I addressed two things related to that as it pertains to the grand jury presentation. One is that when it was presented to the grand jury, that being the description of the wounds, it was done in a very muddied and inartful way. The state elicited testimony that the projectile was shot at kind of a down angle. Well, what in the world does kind of a down angle mean? Does that mean that the wound path is going down from here? That we're starting from the resting location of the bullet forward anteriorly? Or does it mean that it was coming down from above, as was the case? It certainly isn't clear from the way that it was described to the grand jury. And without benefit of the medical examiner's report that Mr. McCowan and I had, how in the world would the grand jury have known that? I think the state tacitly conceded that point because in their response that was so long they had to file a request to include more pages than the rules would otherwise permit. They don't even address the issue that we raised in our motion, that it was muddied and unclear as to what exactly the wound path looked like. So putting that aside for the moment and the ambiguity as to how that was portrayed to the grand jury, we have the second issue of the importance of the wound path itself. This goes directly to the position of Mr. Breaux's body at the time the shots were fired. You have a round that went in, I believe, just above his left nipple and was removed from just above his lower back. You don't need to be a doctor or a medical examiner to reasonably infer from that Mr. Breaux was in a leaning or lunging position going forward when the shot was fired. And especially given the fact that they are going to try to impugn Mr. Jones' assertion that Colin was lunging at him when it happened, The jury should have known that there was indisputable physical evidence, medical evidence from the medical examiner, demonstrating that the injuries suffered by Mr. Bro were entirely consistent with what Stephen said happened. They didn't do it. At best, they provided this muddy explanation, and without a clear picture of what the wounds looked like, the jury had no way of knowing that that was the case. Now, in its response, the state says, well, sorry, I have to look at it. I can't find it. Essentially, it sounds like the state intends to offer some type of magic bullet theory as to how this occurred, and that because Mr. McCowan and I are unable and unqualified to explain that away, that it would have been inappropriate for that evidence to be presented in its raw form to the grand jury. Well, that's just nonsense. I mean, a layperson without a medical degree is perfectly capable of drawing reasonable inferences based on an accurate description of a wound path. Certainly if this were some other case where there was some dispute about whether somebody shot in self-defense or not, and you had an entry wound in the victim's back, I'm quite certain the state would have no problem making some unfavorable inferences against the accused based on that wound path. This is really no different. The grand jury should have heard that, and they didn't. Your Honor, the remainder of the issues I raised are essentially responded to by the state with their fallback position, which is that, well, maybe we didn't present this, maybe we did, but in any event, it's irrelevant because there was no self-defense here, and it's such a clear-cut case. I mean, that's basically what they say. They basically say even if the grand jury had known about it, it wouldn't have made a difference. And they repeatedly cite the fact that Stephen supposedly walked 90 feet from his car to where the shooting took place. I mean, that's basically the centerpiece of their position that everything we're talking about here today is somehow a moot point because it's so patently obvious that this was premeditated murder based on those alleged 90 feet that he walked. It's interesting, though, that when they presented the case to the grand jury, not a shred of evidence was presented as to the distance between Stephen's car and where the shooting occurred. It wasn't important enough for them to present to the grand jury, but now that they're being challenged based on the way they presented the facts to the grand jury and the theory of the case that they foisted on them, now we're hearing about these 90 feet. And now, based on evidence that wasn't even presented to the grand jury, the state's taking the position of, hey, look, Judge, it's so obvious that this kid is guilty. Why are we even arguing about whether he was crying and trying to arrange for medical attention for these young men right after the shooting was occurred? Or why does it matter that these people were drunk and had blood alcohol concentrations that were well beyond the legal limit where somebody could legally drive a car? Similarly, the state tries to muddy the waters as to the defendant's argument with regard to his injuries. No, we don't know which injuries that Stephen had were caused when he was punched, most likely by Colin Bro. And no, we don't know which injuries were specifically caused when he was pummeled thereafter as this large group convened on him and tried to take the gun from him when the second round of shots went off. But we don't have to know because his defense of justification, his self-defense, his reasonableness in discharging the second group of shots wherein Mr. Peering and Mr. Zintek, where Mr. Prado and Mr. Zintek were injured, were the direct result of the fact that he was being pummeled and that he had concerns for his safety. These people were trying to grab his gun. Certainly the injuries that he sustained during that melee goes directly to the reasonableness of his conduct, the reasonableness of his concern, and the reasonableness of his fear that he was going to get seriously hurt or killed unless he continued firing his weapon to get all these people off of him. But they didn't bother to present any of those injuries, Your Honor. At best, they said, well, he had a split lip and he lost his balance. Well, the report from the police quite clearly says that there were more injuries. Observed on Stephen's person. Injuries to his head, his back, his chest, his arm, his knees, and his wrist. But when asked what were the results of Stephen being punched in his face, the state's witness testified, his glasses get knocked off and he loses his balance. And then they compound it. They compound it by having the nerve in a response to say that Mr. Jones went back and fired because his pride was hurt. He was wounded. It wasn't his pride that was hurt. It was his entire body that was hurt. He had injuries just about on every portion of his body. And all the grand jury heard was that his glasses were knocked off and his lip was cut. They downplayed what he had gone through. They downplayed the injuries that were inflicted on him, again, because it plays into downplaying the self-defense concerns that he had and the reasonableness of the actions that he took to protect himself. We talked briefly in chambers, Your Honor, about the remaining issue concern. Well, actually, I'm sorry, let me back up. There's also the issue pertaining to Chase Irwin's statement. I don't want to take up everyone's time continuing to split hairs here, but I would respectfully submit that that's exactly what the state is doing with regard to this issue. Chase Irwin makes it very clear in his statement that he observed Colin Breaux running across the street, and he thinks he was going to help Nick Peering, presumably, who got into a tip with that guy. And the state says, well, that is a gross, that's their word, gross mischaracterization of what of what Chase Irwin said. Well, that's exactly what Chase Irwin said. And no, maybe Chase Irwin did not see Mr. Breaux after crossing the street go into the parking lot where the confrontation occurred, but we didn't say that he saw Mr. Breaux go into the parking lot where the confrontation occurred. That being said, it's not an unreasonable inference. In fact, any contrary inference would be unreasonable, that when Colin Breaux's friend sees him running across the street directly towards the parking lot where all these other individuals are, according to Mr. Peering, continuing to advance on this group of kids to make them go away, that's exactly where he was heading. The state didn't present that, and the reason they didn't present that is because had the grand jury known that Mr. Breaux was essentially running, maybe not, we couldn't show directly at Mr. Jones at that time, he at a minimum was running directly towards his location where this whole episode played out just moments later. They didn't hear that, they should have. Is Mr. Breaux's running subject to maybe varying interpretations? Sure. And maybe they can try to advance those arguments at trial. But the obvious interpretation of that, Your Honor, the most obvious inference that the grand jury would have drawn is that Mr. Breaux was running across the street because that's where Stephen and his friends were, and he was the aggressor in this situation. The grand jury didn't know that. It would have been impossible for them to have made an informed decision about the indictment in this case without knowing that information as well. I don't know when exactly the police found out about the high PACs of the alleged victims in this case. What I do know, Your Honor, is that Detective Jacob Ellis was at the hospital at Flagstaff Medical Center from approximately 1:30 in the morning to at least 5:30 in the morning. He was the detective who took the statement from Mr. Peering that we listened to a moment ago. It's obvious that he was there continuously. It's obvious that he was interacting with the medical staff. It was obvious that he at least noted with respect to Mr. Peering that he had some slurred speech or some other symptomatology that was consistent with alcohol consumption. When and how he found out specifically about the toxicology report from the hospital, which incidentally, according to the hospital records, those labs were done while these young men were still in the emergency room. So the county attorney's office may not have had the printed records until some days or weeks thereafter, but the tests themselves were done while these two young men were still in the hospital. I don't know, given the significance of the other problems with the prosecution's presentation of this case to the grand jury, frankly how important it is to Your Honor that they likewise left out the fact that these young men were, one of them at least was over a .200. But to the extent that that is a relevant issue, if Your Honor denies the motion to remand today, but believes that if that offer of proof would be developed factually with an evidentiary hearing, we would simply ask leave to adjourn these proceedings and to recommence with the defense, to conduct some discovery with Detective Jacob Ellis and make a determination as to when exactly they found that out. Because if they knew about it, that certainly should have been provided as well. Thank you. Thank you, Mr. Davis.
Mr. Parker. Thank you, Your Honor. Well, Your Honor, we've heard a lot about things that the defense does not like about the presentation, but we haven't really heard why they are clearly exculpatory. And that's really the standard. We didn't hear much about the law. We heard a lot about some of the facts that they dispute. The defense's argument fails on every single point, and I'll go through those in order. As the court is aware, the standard is whether the state denied the defendant a substantial procedural right. That's the rule. And there's a couple ways that that could happen. And the two ways that the defense raises is that we failed to present clearly exculpatory evidence, or that we provided inaccurate or incomplete information that was material to the indictment. None of those occurred here. As the court is aware also, the court retains broad discretion in these matters. There's no mechanical test. There's no factors really to consider. It's just the language of the rule and the common law that we have, the case law that we can glean some of these rules from. Let me talk about clearly exculpatory evidence first. That is defined as evidence that would deter a grand jury from finding the existence of probable cause. That's the definition the case law gives us. And by way of illustration, let me talk about the Morrow case. It was a Coconino County case, actually. The defendant cites it in his motion. We cited it as well. This is a case where the defendant had killed his own child. He indicated that he did it because the child was the devil. There was indication that he had some mental lapse, that there was mental health issues that he had in his background. And in fact, it was clear that he had been to multiple hospitals for mental health issues. None of that was presented to the grand jury by the state in that case, and no insanity language was read to the grand jury. The appellate court found, however, that while it tended to be exculpatory, it was not clearly exculpatory. It didn't meet that standard that we just talked about, that it would tend to deter a grand jury from finding probable cause. So that is the standard. It's a fairly high standard. The defense has not met that in any of these points. So let's talk about the things that the defense claims are clearly exculpatory. Kyle's statements, Kyle Zentek, one of the victims, you'll recall that the victim, Kyle, was shot twice in the back. He lost a kidney because of his injuries. He stated in a statement that he made to Sergeant O'Hagan, myself, Mr. Shea, in his hospital bed while he was recovering from these injuries, that Colin Breaux, he said, had gotten into, I think the words were, gotten into the defendant's face, or gotten into the guy's face. When we asked him what he meant by that, he said, well, it was about 4 feet away. That's what he meant by getting into his face. He was not nose to nose. And yes, there is a difference between being 10 feet away, 5 feet away, 1 foot away. Of course there is. But regardless, Judge, how Kyle Zentek, there's no dispute, by the way, that Kyle Zentek had no weapons, or I'm sorry, Colin Breaux had no weapons. There's no dispute even that his fists were down. He didn't have his hands up at the time he was shot twice by the defendant in the torso. Even if we took that statement out of context, as the defense does, that Colin Breaux was in the defendant's face, the defendant had no right to shoot him twice, to shoot him even once. So when we talk about clearly exculpatory evidence, we need to be very clear here. Is that the type of evidence that the grand jury would be thinking, oh man, okay, now that I know he was in his face, I guess it's okay for you to shoot an unarmed person? Of course not. That's not clearly exculpatory. The defense doesn't even talk about that standard. So there's one down. That does not change anything about the grand jury presentation. And again, the defense is cherry-picking statements that they would like presented, but don't look at the other statements about how Kyle indicated he was 4 feet away. Let's talk about Shea McConnell's statement that Colin was the one who punched the defendant. First, it wasn't clear. It's not clear in Shea McConnell's statement that it was Colin. He indicated that the person who had a white shirt on, he thought, also punched the defendant. Who was shot was also the person who punched the defendant. That's what Shea McConnell said. Nobody else in the area, and we're talking about a dozen people or so, say that they saw that Colin was the one who punched the defendant. But let's just suppose for a minute that that was true. Does that change anything about the case? Does it change the fact that the defendant went to his car, which by all accounts was about 100 feet away? By the way, no one was chasing him, even though he told the police that afterwards. He later said, well, when I looked around, no one was actually chasing me. He got to his car. At that point, he decided to unzip the case to his gun, pull out a .40 caliber Glock pistol, load a chamber, turn on the light on that handgun, and then walk some 90 feet to where this fray was happening. And when I say fray, there's no fighting occurring at this point. All that is occurring, and this is evidence that we knew at the time of the grand jury, evidence we know now. What was occurring at that point was a confrontation, an argument, verbal, maybe some chest puffing, nothing more. No weapons. Again, no weapons. The only person who had a weapon was the defendant, who walked the 90 feet and then confronted some people. And it's unclear exactly what he said. Accounts vary. He said some words, and then he began shooting unarmed people. Now, the defense, let me talk about that distance for a minute, because 90 feet is significant. I think 90 feet is probably twice the size of this courtroom, twice the distance or the width of this courtroom. We did present evidence of that to the grand jury. Maybe the defense forgets. We had a witness, Zach Volpo, who testified, or actually made a statement to the police, that he estimated the distance that the defendant traveled to be 30 to 35 yards. So yeah, we didn't have distance. That was presented to the grand jury, so they were aware of that. Getting back to Shay's statement, does it make it more justified that Colin Breaux, a minute or two before the defendant got his gun and fired upon him, punched the defendant in his face? Of course not. We know that the self-defense instruction indicates, the statute says, you're not justified to use deadly physical force unless you are threatened by someone who is by deadly physical force. You cannot bring a gun to a fist fight. That's what the law states. So if he was punched in the face, he doesn't get to get his gun out and walk 90 feet and then shoot people. So it's not clearly exculpatory evidence. It's not the type of evidence that would deter a grand jury from finding probable cause in this case. The state disagrees with that.
Is there a totality of the circumstances on that cause, that position, in terms of leading to the defendant believing that he was actually the reasonable person who believed that he was justified in using physical force? So you have the confrontation, you have the punch, you then have, according to the defense, some sort of pursuit or something to the extent that he is injured or believes he's going to be injured. You're talking only about the punch. Was he punched? And that's it. It kind of stops.
Right.
What about the totality of the circumstances leading up to the punch and just after the punch?
Of course. Yeah, and we presented all that to the grand jury, Judge. I'm going to get to that in a minute, but let me just say, the state presented evidence to the grand jury that the defendant was punched in the face, that his glasses were knocked off, that he said that he feared for his life, that these guys were saying they're going to kill him. We presented all this to the grand jury. You have the grand jury transcript. You might remember we presented that. We presented the fact that he thought people were chasing him to the parking lot, that when he arrived, he said that he had a gun, that people charged him or lunged at him. We presented that to the grand jury. So all of that stuff was presented to the grand jury. So the question is, does this statement from Shane McConnell, does that change anything? Would that deter the grand jury from finding probable cause? And the answer is clearly no. It's not clearly exculpatory evidence, but I get what the judge is saying. Of course, and that's why you need to look at the whole picture. And the state did present all of those, the background, the foreground. We presented all of that to give the grand jury a picture of what happened. Chase Irwin's statements, the defense claims, is also clearly exculpatory. First of all, they did grossly misstate the evidence. Chase Irwin never said that the defendant that Colin Breaux ran at the defendant. And that's what they put. I'm almost surprised the defense didn't just stop talking about this, because they said that in their motion. I'm looking on page 12, top of the page. Irwin's observation of Breaux running towards Stephen, That's not a fact. That's not evidence. That's not what Chase Irwin said. So yeah, they did grossly misstate the evidence. So that's not misleading, or that's misrepresenting the evidence, but it's also does not fall under the category of clearly exculpatory evidence. That Colin, an unarmed individual, ran across the street does not then give the defendant a right to shoot him dead. That's a ridiculous argument. The BAC of the victims, blood alcohol concentration, I'm not aware. We have Sergeant O'Hagan here. Maybe we could ask him if he knew about the BAC. I'm not aware that anyone knew what the BAC of these victims were at the time of the grand jury presentation. Obviously, we're not required to introduce evidence we don't know about. But regardless, let's just suppose that we knew what the BAC of these victims were. Does the law say that if someone's intoxicated, you get to shoot them? Does the law even say that if someone's aggressive, you get to shoot them? No. How is that clearly exculpatory? Again, we didn't hear the defense explain how that is clearly exculpatory evidence. Detective Jacob Ellis was at the hospital, but he wasn't there taking the victim's blood. He wasn't there noting a lot of symptoms of intoxication. He was there to get some statements to find out what had happened. And these victims, we could hear on the recording that the judge heard earlier. Nick Peering, he's in the hospital. Nick Prado, he's in the hospital. Kyle Zentik's in the hospital. You can hear the beeping behind them. They're being treated for gunshot wounds. Wasn't the time to figure out what their BACs were. It's not a DUI case. Let's talk about the other category that the defense points to that they say is inaccurate or incomplete information. And again, it's not enough just to be inaccurate or a little misleading. It's got to be material to the indictment. So talking about that, in Peering's statement, we heard a little snippet, a little section of Peering's statement that he made at the hospital. There's a whole other interview that took place a few days later that the court has, that we submitted as part of our response, where he gives a more comprehensive interview. He talks about what had happened in more detail, about what happened in more detail. The state did not mislead the grand jury about this. If you look at the grand jury transcript, it doesn't differ that much from even his first statement, but it certainly follows and parallels Peering's second statement, where he gave more detailed account, gave a longer account about what happened. The recorded statement bears that out. And again, it's not material to the indictment. Whether or not Peering actually lunged at the defendant as well, and by the way, the state does not concede that any of his statements indicate he did that. He was running towards Colin, his friend, to intercede when the defendant shot him twice. Even supposing, let's just argue for argument's sake, Peering ran at the defendant. He was unarmed. The defendant just shot another person twice. Does the defendant just get to shoot anybody who walks towards him? At that point, the only people in that area who were allowed to use self-defense were the people around the defendant. So the people that jumped on the defendant, they were acting in self-defense at that point. They were afraid for their lives at that point. And that's the reasonable person standard there. The defendant was the only person who had a weapon at that time. Let me talk about the trajectory of the bullets. The state, I'm kind of surprised we're arguing about this, but the state does not have an expert report from Dr. Zarnicki or anyone else opining about the trajectory of the bullets and what that means. We're not in a position, the state cannot be placed in a position where we are telling the grand jury, this is what this means. What we heard from Sergeant O'Hagan at the grand jury presentation was that they were at a downward angle over there, a down angle, I think is how he said it. We can argue about semantics, but how is the fact that there's a downward angle, that the trajectory of the bullets on Colin's body were at a downward angle, how does that change the calculation? How does that make it seem like the defendant is now acting in self-defense? Again, does that deter a grand jury from finding probable cause? No. Colin had no weapons. Even if he were lunging at the defendant, which by the way is disputed by a lot of independent witnesses, he does not have a right to then shoot him dead. So the trajectory of the bullets, again, does not meet any standard that I could find in the law. The defense has failed to adequately explain that as well. The defense just, I guess they're not addressing the defendant's self-serving statements he made in the patrol car. I think our response, we can just rest on that issue. The defense injuries, these were not materially misleading. The statement that I believe Sergeant O'Hagan made to the grand jury was that he was punched in the face. There may have been an indication that he had a split lip, that he lost his balance at one point. The injuries were superficial. All the injuries that the defense pointed out in a police report, I noticed that they didn't include any photographs of the defendant's injuries because they are just little scrapes and bruises, nothing more. So we don't know where they came from, what or when they happened. It's possible he received a bloody lip when he was initially punched in the face. But either way, it's not clearly exculpatory information. The defendant is only allowed to use physical force, not deadly physical force. So the fact that he got some scrapes and bruises did not indicate that he was in that position where he needed to use deadly physical force. His injuries don't add anything to that analysis. So basically, Judge, what the defense is arguing is that the state didn't present the defense's entire case to the grand jury. And that's not the purpose of the grand jury proceeding. And let me, by way of an example, talk about some of the case law to understand what type of information the state is supposed to present. In State v. Harrell, which was cited by the defense, although they cited just for a generic purpose, in that case the defendant had chased down a car that he thought contained his daughter. He was looking for his daughter, he thought she was in trouble, and so he was chasing this car down. He had a little BB gun with him. He ended up going around the neighborhood, following this car, had a confrontation with people in this car. It turned out it was the wrong car, okay? And the people in that car was just a family not related to this incident. They called the police, he was arrested. The grand jury, at the presentation of the grand jury, they were read the crime prevention statute, but the state failed to present information, any background information, that he was looking for his daughter, that he thought she was in harm's way. And so that, the court decided, was enough to send it back to the grand jury. That's completely distinguishable from this case. Here we read all the applicable justification statutes. You have the grand jury transcripts. I know you've read it. We read all the self-defense statutes, crime prevention statutes, spent time explaining what those meant, read the definitions, and then we included all these events in a grand jury presentation. Let me just go through them. Information that while the defendant was in the street, he got punched in the face, that his glasses got knocked off. Information that Shay McConnell and Jacob Mike, who were the defendant's friends, were pushed to the ground initially, and that McConnell was also punched. Information that the defendant thought people were chasing him, which turned out not to be true, but we presented that anyway. That he thought he was going to die, that he needed to defend himself, that was presented. That later one of the Delta Chi members lunged at the defendant when he had the gun. That two guys rushed toward the defendant. That afterwards several people piled on the defendant. That the defendant yelled out to call the police. That Jacob Mike actually called the police and said his friend was being assaulted. This is all included. That there were statements from the defendant that he didn't want to do this, that he didn't want to hurt anyone, or that Colin and Peering were angry about guys who crashed the party earlier. Information that the defendant tried to help one of the guys or to render aid. Information that according to the defendant, people were saying they were going to kill him, although that's disputed by everyone else. Also that he warned the people around him that he had a gun, and that when he displayed the gun, he thought they were going to kill him. We presented essentially this self-defense argument for the defendant. This is a fair and impartial presentation to a grand jury. I would agree with the defense, had we left all that out, just read the statute, for instance, like in Harrell, just read the statute of self-defense and just didn't include any of that information, we'd have a problem. But we didn't. We included all of this information, included all the justification statutes. How can the defense now say we didn't present a fair picture? We presented their entire case. Now, the grand jury rejected that self-defense claim. We don't know exactly why they did that, but perhaps it was because the defendant went to his car, made a decision to get his Glock 40, and then walked 90 feet toward the spray and start shooting unarmed people. We don't know exactly what the grand jury was thinking, but clearly they rejected this self-defense claim. Judge, as the court is aware, the state is only required to present a fair and impartial picture. We're not required to present the defense's case or argument. Again, I agree with the defense. This is not the time to try the case. This shouldn't devolve into a mini trial. And credibility, as I quoted from Trevis, credibility or consistency of statements is not the issue at this stage. Neither is the sufficiency of the evidence. The state made a fair and impartial presentation to the grand jury. We're asking the court now to deny the defense motion. Thank you. Thank you, Mr. Barker.
Mr. Davidson, brief reply.
Yes, Your Honor. These aspects of the case and the evidence that the prosecutor lists off that were ostensibly favorable to Mr. Jones and were offered to the court to ostensibly leave it with the impression that they did come into the grand jury and give them a fair and impartial presentation, completely ignores the fact that when they did provide information about what Stephen said, they disparaged it and they presented it as self-serving statements, much like he has this afternoon. It's astonishing to me, Your Honor, that we have a case where the discovery is so voluminous, it takes up 3 notebooks like this. We have a group of drunk undergraduate college men chasing my client and his friend through a parking lot. There's no dispute, excuse my language, that they're calling him pussy, that they're calling him faggot. No one else may have actually heard the word kill, but to represent to the court that no one else heard somebody making threats against Stephen other than Stephen simply isn't so. So they present the evidence, they say, well, yes, Stephen might have said that, but we all know it's true because all these other people, all of the decedent's likely impaired friends didn't corroborate it, that somehow we should ignore it and that the state was entitled to downplay it during the grand jury presentation. Well, A, that's just not so. B, I don't think that anybody, myself or the prosecutor, could stand before you with such great certainty of what happened and what didn't happen when you have dozens of witnesses who have been interviewed and provided conflicting accounts about some of the minor details of this case. What we do know, Your Honor, is that Mr. Jones made it abundantly clear that he fired that gun because he was acting in self-defense and he thought these 2 guys were lunging at him. Yes, they conveyed that statement to the police, to the grand jury, but they made it sound like he was making it up. They made it sound like it was just a self-serving statement. He was saying to get out of trouble. And it makes it very easy for them to do that when they leave out all this corroboration, when they leave out the fact that Peering says that he was basically right behind Colin, jumping from an elevated position, mind you, towards Mr. Jones at the very moment when Jones says, step back. Now, the fact that Mr. Peering's subjective intent at that point may have been to assist Colin Rowe or do something other than attack Stephen is irrelevant, and it's a distraction from the issue before the court, as is all this talk about Glock pistols at 90 feet of distance. The reality of it is that statement from Peering himself corroborates what the victim, what Mr. Jones says happened. And it's not just that they left it out, Your Honor. I would invite the court to look directly at page 56 of the transcript. They told the grand jury that that's what Mr. Peering said at the hospital. Now, the story today is, well, there was a heart monitor beeping in the background. We couldn't possibly give any credence to what Mr. Peering said under those conditions. Well, obviously, they thought a hospital setting right after the incident was a very reliable scenario in which to obtain a statement from somebody, A, because they took the statement. They took 2 statements during that period of time. And B, when they presented to the grand jury, when they presented Mr. Peering's subsequent statement to the grand jury, the one that fit the narrative, they misrepresented it. They said he said at the hospital. It's right there in black and white. Now, Nicholas Peering was at that scene too. Is that right? Answer, yes, he was. Question, and was he spoken to? Answer, he was. Question, was he spoken to at the scene or later at the hospital? Answer, later at the hospital. Well, he was spoken to at the hospital. They just didn't like the information that he gave at that point, so they substituted in what he said a week and a half later. And that statement from the hospital, had they presented it, would have corroborated what Stephen said. It's very easy for the state to stand here and have the court look just at Mr. Peering's statement, just at Mr. Zintek's statement, just at Stephen's injuries, and say, you know, Judge, that by itself doesn't entitle Mr. Jones to grab his gun from his car, walk across a parking lot 900 feet and start shooting people as if that's what happened. Well, of course it doesn't, and it's not the defendant's position that that happened. But as the court correctly noted, it's the totality of the circumstances here. It's not the appropriate analysis to look at each of these by themselves and say whether each individual omission or misstatement by the state on its own would have been a basis for the jury to find that Stephen acted with reasonableness or that he didn't act with premeditation, an issue that I didn't hear the state discuss just now. Certainly when you view these things collectively, and certainly when you view these things against the backdrop of the larger fray in which this all happened, yes, it was clearly exculpatory that Peering said he was jumping in the defendant's direction when the shots were fired, and at a moment, obviously, when Stephen was fearing for his life, because the words that he was uttering at that point were to step back. Obviously, it's clearly exculpatory, particularly when they continue to dispute to this day that Colin Breaux was leaning or lunging towards a defendant, that the medical report all but corroborates that fact, and they left it out. What exhibit number is that document? Yes. No, I'm sorry. May I approach, Your Honor? Sure. Okay. This is Defense Exhibit 1, Your Honor. This is a search warrant that was authored by the police prior to the presentation of the case to the grand jury. Signed like all search warrant affidavits are under oath. By Detective Con Baronet. I would invite the court's attention to the third paragraph on what's date stamped 77. An autopsy was performed on Colin where it was determined that he was shot once in the chest and in the shoulder. The trajectory of the shoulder injury suggested that the round was incurred by the victim as he was leaning or falling forward. So here we are today. The state takes position that without medical expert testimony that we can't draw any inferences from the trajectory of the bullet, but when they presented the case to a magistrate to get a search warrant, the police obviously had no problem making that inference, and of course they made that inference because any reasonable person could make that inference. So it's a non-starter that the medical examiner's findings were not relevant and didn't draw or didn't allow the grand jury to draw any conclusions.
Mr. Davidson, yes? Which shot occurred first? The one to the chest or the one to Mr. Breaux's shoulder?
I don't know.
Well, your position is that Mr. Breaux was lunging forward.
Both bullets were described in the medical report as having a downward path. May I have a moment?
Sure.
Referring to date stamps 445 and 446.
What exhibit?
Well, it's not before your court. I could have this marked if you'd like. This is Dr. Sarnecki's report. He describes the gunshot wound to the chest. The trajectory was the wound track reveals from the decedent's front to back, right to left, and downward. He then separately describes the gunshot wound to the shoulder. Trajectory. The wound track travels from the decedent's front to back, right to left, and downward. Both shots are described by the medical examiners having a downward track, so the sequence of the shots, I would respectfully submit, are not relevant with respect to that particular issue. If it were an undisputed issue as to whether Colin Rowe was lunging or leaning towards the defendant, maybe it wouldn't be a big deal. If it was an undisputed issue as to whether or not Colin Rowe's physical demeanor towards Mr. Jones was something that he considered in perceiving the threat that he was facing was not important, it wouldn't be that big of a deal. But neither of those things are true. This is perhaps one of the most
and courage. And these boys spent 2.5 years here, working hard and doing what they were supposed to. The shooter was here for 6 weeks, and I think if Colin was standing here today, I promise you he would not say, I wish I had a gun that night so I could have fought back. He would have said to Stephen Jones, you're here for 6 weeks. This is where we come to learn, to grow, to become men, to figure life out. We don't solve our problems with pulling out a gun. It's not an option. Colin's last words that night were, why did you bring a gun here? And I think he would still say the same because it was so foreign to him. So I ask that you, just like the others, would protect them this time and protect this community, their school, that they loved. Thank you.
Thank you, Mr. Taylor. Okay.
Thank you, Your Honor. Your Honor, I'm aware that the court is familiar with the facts of the case up until this stage, and I don't want to spend a lot of time talking about the facts, except for to say that the state does take exception with the factual representation with regards to these circumstances presented by the defense. And I think it's important to note that part of what the defense does is essentially ignore the fact that the defendant traveled from his vehicle more than 90 feet back to the location where he shot Colin. He went from his vehicle where he collected a gun, went back across the parking lot, and shot 4 people. There wasn't even a physical confrontation going on at the time. He walked across the parking lot and shot 4 people. He killed one of them. He almost killed another. The other 2 are lucky to have their lives. And the defense ignores that traversing of distance between the vehicle and the car. And I point out specifically, this is the defense indication of the facts. Stephen reached his car and obtained his pistol from the glove box. Unsure of his exact surroundings because his glasses had been knocked off his face, Stephen announced that he had a gun and yelled at subjects to stop. Unbeknownst to Stephen, the subjects had discontinued their pursuit of him, but 2 of them quickly started running back towards him after he shouted commands at them. As Stephen held his pistol at the low ready position and again yelled for them to stop, alleged victims Colin Rowe and Nicholas Peering stated that they were going to kill Stephen and charged towards him.
And I would point out a few things there. The first is, it certainly is written and suggests that this occurred just outside of the defendant's car, which is provably untrue. Second, it suggests that both Nicholas Peering, it doesn't suggest, it says that Nicholas Peering and Colin Rowe ran towards the defendant, and then he warned them again, and they continued to run towards him, which is also provably untrue. And I would suggest, Judge, that the reason that I'm pointing all this out to you is because the defense is indicating that the defendant wants to clear his name, and that really this is a self-defense case. I would suggest, Judge, that the facts for the charges in the indictment against the defendant are extremely strong. There's a whole bunch of weaknesses to the self-defense argument, perhaps the best being that the defendant left the confrontation and was quite a distance away from it when he armed himself, and then recreated, with regards to him, a new confrontation. When the defendant leveled his gun at the other individuals who were out there that night, that's him creating a new confrontation, introducing into that second confrontation deadly force which didn't exist prior. Clearly self-defense isn't going to cover this situation. The other evidence that the defendant gathered his gun, walked across the parking lot, and shot 4 people is very strong. And therefore, the strength of the evidence against the defendant is strong. The likelihood of the success of his defense is low. And the potential penalty that the defendant faces is extraordinary, as the court is aware. With that strength of evidence against the defendant, and with that potential penalty that he faces, there's an inherent flight risk, a strong flight risk. Of course, that's only part of the concern. A major concern in a case like this, where somebody introduced extreme deadly force into what was, at best, a fist fight, is that this person is dangerous. The provable information in this case, the information that's on the table, is that under circumstances that strain credibility to argue that deadly force was even something that should have been contemplated, this person armed himself and shot 4 young men. He's clearly dangerous. And he represents that danger to the community, whether he's on pretrial services, whether he's on electronic monitoring, unless there is somebody standing next to him to watch his everything that he does. That dangerousness continues to exist, and it's expressed by the victims who are obviously terribly saddened and tortured by what has happened, what the defendant did to them. And I would argue to the court that it's also a representation of the senses of the community on the subject of whether or not the defendant represents a danger should he be released. I would argue that that danger is very strong, and it's felt, and it's observed by the victims and members of the community.
How about the assuring the appearance of the accused?
Well, Judge, like I said, the primary argument on that is the strength of the case and the potential penalty against the defendant.
Then are you arguing that he shouldn't be bailable?
I'm arguing that I'm arguing at this time the conditions of release should not be altered.
Okay, I have assuring the appearance of the accused. This is the purpose of bail, assuring the presence of the accused. I think it's interesting that that's the first thing that's mentioned in our Constitution and in the criminal rules. That's the first thing that's mentioned. I think that's what they're directing judges to look at. What is going to assure his presence? You've offered me and I'm trying to figure out. I'm trying to listen. I mean, these are serious charges. But what I haven't heard is, and I understand the weight of the emotions in this courtroom is palpable and significant. But I know you and Mr. Barker and Mr. Davidson and Mr. McCowan and Mr. Rabb for that part and Mr. Diesel do not take the presumption of innocence that is upon Mr. Jones to be a legal fiction or a trite nicety in our law. And I don't hear anyone arguing about the presumption of innocence. And looking at that, all I hear is presume him guilty. And is that what I should be looking at? Presume him guilty.
Judge, I certainly never suggested that the presumption of innocence is a trite nicety.
And I know you didn't, because I said you believe in it.
And the state certainly never suggested that there should be a presumption of guilt. But what the state is suggesting is that, as indicated by the statute, the factors that are taken into account are the strength of the case. And the state is presenting to the court the extraordinary potential penalty that should the defendant be convicted, and arguing that because of the strength of the evidence, the likelihood of conviction is strong, that the impact of that information on the defendant is going to be that if he presents himself for trial, he may never leave outside of custody. And that fact has an impact on somebody who's deciding whether or not they're going to present themselves for trial.
You're aware of the case law that says the strength of the evidence is actually one of the least factors that a court should consider, correct?
I am aware of that, Judge, but only in the respect that the court is thinking of it, which is whether or not he's probably guilty. But I'm suggesting that that piece of information becomes important when you consider the impact that the potential penalty is going to have on somebody who's deciding whether or not to present themselves for trial. If it was a very weak case, or if the defendant's self-defense argument were strong, maybe more stock or more weight could be placed into the idea that he does want to clear his name.
How about 24-hour real-time GPS monitoring? Not summary now, because I know that we used to at one time had summary, but 24-hour real-time GPS monitoring.
The state still believes that the defendant represents a danger to the community.
Okay, all right. Would that address your issue regarding the flight risk?
Judge, I would suggest that technology like that, I'm not saying that there's evidence to suggest that this is going to happen, but just in response to the judge's question, can technology be beaten? Of course it can. And so,
what I hear is you're inviting me to do an awful lot of speculating. He may flee. He's got serious charges, so he may flee. So he may disable the bracelet. So he may get access to weapons, even though I could order that his home be subject to 24-hour search. He may go down to downtown Phoenix, at 3 a.m. in the morning and pick up some 38 or Saturday night special. He may do this. There's nothing in the rules or the statute or the Constitution that allows me to speculate about that.
I think that
and I guess the thing about it is, Mr. Shea, is really what I am left with is, what is it that you have? You have the charges. You have the investigation. Do you have anything that shows that he is? Do you have any evidence, any suggestion, other than a speculation based upon the charges? Because if I just go by the charges, nobody gets out. A lot of cases, nobody gets out. Because anybody charged with an offense for which they even could go to prison would represent a flight risk.
I think that argument exists. I think that
in the context of our Constitution, in the context of the presumption of innocence.
Well, Judge, let me take it from the other perspective then.
Okay.
There's nothing that the state is offering here that is different than what is often offered in many, many bail arguments in this courtroom.
Not your strongest argument, because I've released a lot of people who the community may have thought presented a danger, and I released them to pretrial services under some extremely onerous conditions, the least onerous, and they appeared for trial. I'm thinking of one young woman, I'm not going to get into specifics of it, that was facing mandatory prison. Same as Mr. Jones. Serious offenses. Very serious offenses.
The only reason that I'm suggesting that, Judge, is because whatever the court is indicating requires speculation is in fact just the weighing of the factors that the court is instructed to weigh in making these determinations and see what conclusion the judge is pushed in. And it's clear to me, Judge. It's not wise for me to try to go toe-to-toe with you on these issues. You're much more familiar with the posture of a jurist on a question like this. But the state's position is that the defendant does, based on the evidence in this case, represent a danger to the community. It's exhibited in the evidence of this case. It's exhibited in the inferences that can be drawn about his decision-making process when he elected to engage in this series of events, series of decisions that wound up with a young man dead and 3 others shot. His dangerousness is right there. In terms of his likelihood of flight, I don't know him personally, and there isn't a psychological evaluation of him to which I can reference. But I can offer that...
There is our pretrial services report, right? Shows him at a very low risk, and to reoffend and a very low risk of failing to appear. In fact, the lowest risk on a nationwide assessment that has been validated and shown repeatedly to be accurate. People do show up charged with first-degree murder. They do show up for trial.
It's true. Also, some people don't. And I would point out that with regards to that evaluation, not a single question is asked of the defendant in order to draw that conclusion. So the state's position is that he does represent a danger. The state's position is that spending decades in prison would be a significant impact on somebody's decision on whether or not to appear. For what it's worth, the weight of the evidence is strong, and the state believes that, the bond is based on this idea that if somebody has to actually post the money, then that encourages them to make sure that this person gets to trial. I mean, that's the whole idea behind somebody having to post money. When the motivation to flee is so significant, the bond must be significant in order to counterweigh that.
Well, here's the question that I have then. What do you know? Were you present when the bond was set? I think it was set out at Justice Court. Okay. So, what was the bond that was asked for?
The state moved for the defendant to be held without bond, and if I may.
Asked that he be held no bond based on the offenses that are non-bailable, as the court referenced. And then I said, because I believe that the presumption was great, evidence was great at that time, and it still is, that he should be held without bond. And then I asked that he be held, if a bond was imposed, something in excess of $1 million, and the justice of the peace, I can't remember who it was at the time, set $2 million cash only. That was my recollection.
Okay. So it brings up the question, then, that at one point, the state believed that if Mr. Jones was capable of posting a $1,001 bond, that would be enough to assure his presence and the safety of the community.
Well, I can't dispute that summary. Of course, I think that the safety issues exist, whether it posts a bond or not.
Sure, but here's the problem. A bond is not supposed to be a punishment. It's not supposed to be a pre-jury verdict punishment, right?
I agree with that, Judge. I don't think that anybody's suggesting the imposition of bond for specific purposes.
So in the prosecution's opinion, a $1,001 bond was sufficient to assure his presence in court, the safety of the victims and their concerns, and to address any concerns about flight risk.
I don't dispute that.
You don't get to tag team, Mr. Parker.
Well, I'm just going to say, because I was the one that asked for it. Okay. So I represented the state in that instance. I did not agree with that, Judge. In fact, I asked for no bond. I asked for non-bailable. It was a non-bailable offense in my opinion. And by the way, that is just based on a charge, as the court was asking about. We just hold people no bond based on a charge. So
is that the defendant has since been indicted by a grand jury to first-degree murder and 6 counts of aggravated assault, which are of a dangerous nature and each carry their own mandatory prison sentence.
Oh yeah, I mean, if Mr. Jones is convicted of all of them, I mean, basically it's a life sentence. I understand that, but in terms of what I'm being asked to do to review conditions of release, I can take into, you're absolutely right, I can take into the weight of the evidence. I can take into consideration the danger to the community that Mr. Jones may present. I have to take in a lot of other factors that are listed in 3967, which for the record, I want to make it clear I have considered. Some of them are not applicable to the determination in this, in this case. But I guess what I'm getting at is, the state asks for a bond, and in asking for the bond, I mean, on a charge like this, the state has the opportunity, and they have the right to present a case at a conditions of release hearing and say, I'm sorry, we don't want a bond here. We're going to show that the proof is evident, presumption great, that this should be a non-bailable offense. And the state has not done that. It's not asked for a non-bailable offense hearing.
Well, just to be clear, we did ask for it initially.
Well, you asked for a no bond, and that's normally what's done at the time. But the Constitution and the case law actually is something different than just simply going to a JP and saying no bond, because at some point in time you're challenged.
Well, we would have had to present evidence.
Correct.
But we were prepared to do that when we made that request. I think there's a time limit with which we would have to have that hearing.
And that wasn't done.
Well, we asked for it. Cash bond was set instead.
I understand, but you could have asked. You could have said, Judge, we want a hearing on this because we think this is a non-bailable offense. You could have asked for that hearing, correct?
I believe so. I would have to go back and look at the specific procedure on the subject. However, $2 million was imposed, and $2 million appears to be sufficient to satisfy the state's concerns, the safety of the community, appearance for trial.
What's the difference between $1 million and $1 cash only and $2 million?
I guess that's something for the court to consider.
Okay, and that's the whole, that's the issue that I have to struggle with on this. Is we're asked, as judges to basically take risk. I mean, we're in the business of risk management. That's what we do. And so we're putting a number on the factors of 133967, Article 2, Section 22, Rule 6, I think, so on and so forth, and we're going, this is all of 13, 39, 67, all of those statutes and rules are met by a number. And that's, that's the issue that I have, is it just a number, or are there other aspects that I should hear about that are not necessarily present? And I do. I have this. Now, you're right. They don't ask any questions on it. It doesn't necessarily. It may go to the weight that I give it, and I've certainly, not been shy about my views on certain pretrial services assessments. But I cannot state, and it's been drilled into us, and we're going to have it again repeatedly by judges and by those involved, and former judges, retired judges that I respect, that this is validated.
I understand
and it has shown that you can allow persons charged with the most serious offenses, and under certain circumstances, you can release them.
I suggest, Judge, though, that as the court is pointing out, deciding what is the appropriate bond is something that can't be reduced to a question of weights and measures and numbers and no questions to the defendant. It's still always something that's left to the discretion of the court, and I suggest there's a reason for that.
All right. I appreciate it, Mr. Chairman. Thank you, Judge. Thank you for your argument. Briefly, Mr. McCown.
A moment ago, you just asked what's the difference between 2 million and 1 million. Of course, it depends on who you're asking. I would assume for just about anyone in this room, there is no difference. For probably just about anyone in this room, there's probably not much of a difference between 2 million, 1 million, and 100,000.
Well, Mr. McCown, the other aspect about it is that a bail is considered the bail is set not only to consider the return of the person to the assurance that a person will appear for trial, but it also calculates into it the safety to the community.
I understand Your Honor's concerns with that, but as we discussed earlier, there are things that Your Honor can do to provide those assurances. We should not assume that this man, who at this point is innocent until proven guilty, is a danger to the community because of this isolated incident. He has no history of violence. There's nothing in his past. He was here on scholarship. There's nothing in his past to indicate he's a threat to the community, and we should not just assume because of this incident where he was attacked. I understand there are very many heavy hearts in this room, and a lot of people think he is guilty. They're entitled to those opinions, but at this point he is innocent until proven guilty. There's nothing in his past to indicate that he's a threat to the community, and it is not fair to assume that he is going to try to intimidate, frankly, when he is very much outnumbered as he was that night, or that he's going to flee when he does very much want to clear his name.
Here's the thing. I can envision circumstances under which, I could see Mr. Jones being released. My overarching concern is the safety of the community, because this was such this was just an act that it wasn't like, somebody loses it, snaps, and then takes a baseball bat to a windshield. Something along this is actually the loss of life and the near loss of life for 3 of the young men. And so this aspect about the danger that Mr. Jones presents, it's actually the fact that he really has no history and took this action that night that causes me more concern than anything. I can envision circumstances that I could consider, but I don't have them in front of me. I could consider releasing him, that being real-time GPS monitoring, with urinalysis testing, with the fact that pretrial services, an actual physical officer has the ability to go into the home and search the home and make sure that there are no weapons present. Basically a dusk to dawn curfew on this. I don't know I don't know that that exists. So I don't think I have enough information and enough concreteness for me to be able to consider that at this time. What I'll do is I'll give you an opportunity to see whether or not that can even be done. But if it can't be done, then I'm going to maintain the bond. And I'm going to maintain the bond today. I'll give you an opportunity to see if that's even possible. And then I'll set up for a hearing again to see whether or not that's done. But if it's not, then I don't think I have enough to give me the assurance that I need for the safety of the community. And I believe that Mr. Jones will come back to trial if he's released. I have nothing to suggest that he won't. This shows me that, he is absolutely at the lowest level for flight. And candidly, I have to say, I would probably put my money on this one than I would on the idea that simply because somebody is charged with an offense, that automatically throws them into, they're going to flee to Mexico or parts unknown. But the concern that I have is that Mr. Jones, for whatever reason, without any prior history whatsoever, took the actions that he did on that night. And so at this time, I'm going to deny the motion to modify the conditions of release. But I'm letting everyone know that I will consider that. I'm not saying I'll agree to it. I will consider it, though, if you're able to determine whether or not any of the concerns I have or the conditions that I would consider can even be accomplished.
Your Honor, we'll certainly look into that.
Let me ask for where we are with regard to discovery and disclosure and witness interviews.
No witness interviews have been conducted as of yet. Well, let me say, the state's witness interviews, I believe, are all finished. No defense interviews of those witnesses have been conducted. Disclosure, I believe, is up to date. We discovered yesterday there was a recording that we did not have, and so we've asked for that. But it's substantially complete. We're making a phone call over to DPS Labs today as well to see where they're at with some of the testing. I know serology has been completed on a number of items, and we're looking to see what the timeline is for some DNA testing as well. We'll be sending out some information out to our reconstructionist, and so we'll be getting a report from him as well. So that's, as far as disclosure, that's where we're at.
Mr. Davidson, Mr. McCown.
Your Honor, I know that last time we were here, we were told that probably the end of February is when we would get that expert's report. I don't know if that's still the timeline. Doesn't sound like it, so obviously we're still waiting for that. I know at one point we had talked about a pared down list of witnesses that we could interview, the state was going to provide us. We don't have that yet. So if Your Honor wants us to get going on an interview, certainly we're eager to do that as well.
Well, within the realm of whatever you can with the disclosure that you have, obviously.
We don't want to get ahead of ourselves.
We did provide a pared down list. I don't know if the defense realizes that. I think it was before the end of the year. We have a list. It was disclosed. So I'll get with Mr. McGowan again and let him know.
This is, I really think that this is, given the number of witnesses that have been disclosed and the issues in this case, I really think that both the prosecution and the defense need to get together and give me basically a joint Rule 16. I know we don't call it, it's Rule 16 in civil rules of procedure, but a joint scheduling memorandum where I have clearly defined dates that the parties have agreed to where discovery and disclosure will be done, witness interviews completed, expert reports, rebuttal expert reports, interviews of the experts. It's difficult for me to set dates and deadlines that are in fact meaningful and significant if I don't really have a roadmap that's given to me by the attorneys who do know an awful lot more about the case than I do. Can I get that within the next 30 days?
Absolutely.
Yes. Okay, and then I can then I will set the next CMC based upon the date that I have, by the next date that I think a significant event should take place, either close of discovery, the disclosure of the prosecution's expert report. That might be an issue. I just don't know I don't know how this is going to proceed, because I don't know, what the parties anticipate in terms of the discovery and disclosure process.
I understand, Judge. We'll get together and figure that out. Thank you.
Mr. McCowan, Mr. Davidson, anything further? Mr. Shea, Mr. Barker, anything further?
Nothing further. Thank you.
Right. Gentlemen, thank you for all your hard work. Thank you.
Ladies and gentlemen, please stay in the courtroom. I'll release you in just a couple minutes.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. We've been listening to some of the previous hearings in the Stephen Jones case. He's the young man who's accused of shooting 4 people, killing one of them outside of a college campus in Arizona. The opening statements in that trial are expected to come any minute. We're monitoring the feed from the courtroom, and we're hearing that they should start in about 10 minutes from now. So as soon as they start, we, of course, will bring them to you live. In the meantime, I want to go back and review some of what happened in the Aaron Hernandez trial today, because the defense rested its case and the prosecution did not have a rebuttal and will not give a rebuttal. So closing arguments in the Aaron Hernandez case from Boston will occur tomorrow morning. A couple of notes from what the judge said this afternoon. He's giving both sides proper and improper closing argument guidelines as indicated by the appellate courts in Massachusetts. So giving both sides a sense ahead of time of what he expects them to do and not do. Hopefully that will starve off any attempt at an objection during closing arguments, because that just gets more messy and more time consuming. And in that case, we've already seen plenty of time go by. He told the defense that the defense cannot argue that a missing witness would have been damaging to the prosecution had that witness testified. That is a standard under Massachusetts law that he wanted to point out. He also pointed out that the defense was, however, free to argue that evidence could be insufficient and the absence of evidence or witnesses could be helpful to a finding of reasonable doubt. So that was some of what the judge got into, and of course he'll be giving his full jury instructions after the closing arguments tomorrow. He said that 12 people will deliberate and they will select 3 alternates tomorrow who will not be part of the initial deliberations, and hopefully the 12 jurors selected will be able to go and reach a verdict without too many hiccups along the way. I want to go back and play some of the testimony from the defense expert that we heard from today in the Aaron Hernandez trial in Boston. This is Jamie Downs. He goes by Jamie. His first name is James. He's a forensic pathologist, and he was challenged about a drawing that he put together that had a gun in one of the victim's hands, and he said in a fiery exchange on cross-examination that he was told to draw the gun in the victim's hands by the defense. But of course he had no way of knowing if the victims had a gun, and the other evidence would suggest that they probably didn't. Let's listen to some of the testimony of this defense expert from earlier today.
First of all, you mentioned in your report the term right brachium. What does the term brachium mean?
Again, as I mentioned earlier, brachium medically is the upper arm. What we would call the arm is the brachium and the forearm.
Well, the brachium is the arm from the shoulder to the elbow, isn't that correct?
The upper arm, yes.
Okay. And then there's below the elbow, which for layman's purposes we'll call the forearm.
Yes, sir.
Now, you filed or you submitted a report of your conclusions, opinions, and observations in connection with this case on March 5th of this year, correct?
I believe so, yes, sir.
Okay. And in that report, which was roughly, what, 5 to 6 pages?
I couldn't tell you how long it was. That sounds about right.
Okay. Your opinion says nothing about the position of the forearm. That is, the part of the arm below the elbow, correct?
I believe that's correct because,
right.
again, as I said earlier, I can't position the forearm.
Correct. And, in fact, what you said was that the right brachium was raised to approximately shoulder level and extended outward. That was the conclusion that you drew in your first report there.
That's correct.
Okay. And may I have Mr. Favors, Your Honor, resume that position that he was in before with the demonstrative, as the demonstrative aid?
You may.
First of all, you mentioned in your report the term right brachium. What does the term brachium mean?
Again, as I mentioned earlier, brachium medically is the upper arm. What we would call the arm is the brachium and the forearm.
Well, the brachium is the arm from the shoulder to the elbow, isn't that correct?
The upper arm, yes, sir.
Okay. And then there's below the elbow, which for layman's purposes we'll call the forearm.
Yes, sir.
Now, you filed or you submitted a report of your conclusions, opinions, and observations in connection with this case on March 5th of this year, correct?
I believe so, yes, sir.
Okay. And in that report, which was roughly, what, 5 to 6 pages?
I couldn't tell you how long it was. That sounds about right.
Okay. Your opinion says nothing about the position of the forearm. That is, the part of the arm below the elbow, correct?
I believe that's correct because,
right.
again, as I said earlier, I can't position the forearm.
Correct. And, in fact, what you said was that the right brachium was raised to approximately shoulder level and extended outward. That was the conclusion that you drew in your first report there.
That's correct.
Okay. And may I have Mr. Favors, Your Honor, resume that position that he was in before with the demonstrative, as the demonstrative aid?
You may.
And, Your Honor, if I could have Dr. Downs come back down.
Doctor, if you would,
Thank you.
please watch your step. And ask both to keep your voices raised, please, for our court reporter.
And if I could have Mr. Favors have a seat. Sure. And I'm asking you to do it because I don't want to get it wrong. Could you have Mr. Favors resume the position that is consistent with your opinion in this case?
Again, approximately hand open, and roughly something like that position. Leaning to his right. What I'm looking at is to this point. The rest of this is what we call anatomic position. That is, again, toes forward, palms forward.
And you can resume your seat. If you could just hold that position, that's your best. Notice, Doctor, that when you put Mr. Favors in this position before lunch and today, you had his forearm extended.
Yes, sir. As I mentioned, anatomic position.
But you don't know what the forearm was doing.
No, sir. I think I made that clear several
Then
times.
why did you have it extended as a demonstrative aid to the jury when you had no idea what the forearm was doing in the early morning of July 16, 2012?
I think I've said it 3 or 4 times. It's anatomic position, sir.
Okay. And it's true, Doctor, that You, in every chart that you did for this case, even though you had no idea what the forearm was doing, you drew the passenger of the seat with the arm extended out the window. Isn't that correct?
Every time I followed anatomic position, yes, sir.
Okay.
Mr. Lee?
Oh, Mr. Favors.
Sir, we're going to mark you for identification. Thank you.
First of all, you mentioned in your report the term right brachium. What does the term brachium mean?
Again, as I mentioned earlier, brachium medically is the upper arm. What we would call the arm is the brachium and the forearm.
Well, the brachium is the arm from the shoulder to the elbow, isn't that correct?
The upper arm, yes, sir.
Okay. And then there's below the elbow, which for layman's purposes we'll call the forearm.
Yes, sir.
Now, you filed or you submitted a report of your conclusions, opinions, and observations in connection with this case on March 5th.
Well, we had to cut that clip early, folks, because the judge is on the bench and he is speaking in the Stephen Jones trial from Arizona, so let's go straight to it.
From the officer's car, and then the officer, was it Park?
Officer Park, yeah.
His body cam, the audio was working, but the video didn't play. I just got the audio. Is that consistent?
No, it should have been playing
Okay.
on our computer before we brought it.
Okay. Well, I listened to the audio, and I think that was probably the portion that I really need to hear. So I am determining there was a statement that Mr. Jones made. He, quote, "I thought I was going to die." And then there were 3 why statements that I heard in the car. And I'm going to rule that those are self-serving hearsay statements that cannot be brought in through another witness in that case. Let's go off the record for a second. Do we have everybody?
And everybody, we're waiting for the opening statements in the trial of Stephen Jones. So right now you're looking at the courtroom feed coming in. The judge just said that he was not going to allow certain self-serving statements by the defendant to come into this case through other witnesses. Those statements have been the subject to other motions in this case before. The specific one that the judge just referenced was a quote from the defendant where he said, quote, "I thought I was going to die." That apparently had been recorded. The judge will not allow that in and will not allow other witnesses to discuss it. The self-serving statements in this case go back to the defendant's insinuation or claim that he fired these shots in self-defense. And the judge has kept much of that discussion, if not all of it, out of this case. So we're waiting for the opening statements in that case to kick off here any moment. We, of course, will be carrying the case live in its entirety for for you here on the Law News Network, along with our usual expert analysis from attorneys here in our studios in New York. So let's run through some of the counts that this young gentleman is facing. His name is Stephen Edward Jones. The first count is first-degree murder, and this came from a grand jury indictment. At one point in the earlier part of the case, the counts had actually been lowered to a lesser degree, but the grand jury pushed the indictment back up to first-degree murder. That carries a penalty under Arizona law of death or life in prison. After that count, this gentleman faces 6 other counts of aggravated assault based on different shots being fired and different type of injuries being inflicted on the 3 victims who did not die as a result of the attack. Those aggravated assault charges, which are counts 2 through 7 in the grand jury indictment, carry under Arizona law a punishment of 5 to 15 years, assuming no prior convictions, which I don't believe this particular defendant has, but there is a presumptive sentence of 7.5 years on each one under the strict language of the statute. It lays that out. It lays out a 5 to 15 year window with a presumptive 7.5 year sentence, assuming no prior convictions. An interesting note, Arizona presumes consecutive sentencing, but the court can declare otherwise. That's right in the Arizona Criminal Code. So the presumption is that if convicted on even the minor counts, then this particular defendant would face consecutive sentences rather than concurrent ones. They're back in session in court, so let's listen back in.
Mr. Barker, go ahead, sir.
Thank you, Judge. The defendant, Stephen Jones, murdered a young man and seriously injured 3 others because his pride was hurt. In the early morning hours of October 9th, 2015, the defendant was confronted by a group of college students, and he was punched 1 time in the face. Instead of punching back or walking away altogether, the defendant went to his car to get his gun, a fully loaded .40 caliber handgun, and then he went another 90 feet back toward that group to shoot 4 unarmed college students. Now these college students were Nick Peering, Nick Prado, Kyle Zentek, and Colin Brew. The defendant shot Nick Peering twice, once in his arm and once in his hip. He shot Nick Prado once through his neck. He shot Kyle Zentek twice in his back as Kyle was running away. Now, miraculously, these 3 victims survived. Sadly, Colin Brew did not survive the defendant's rampage. The defendant shot Colin twice in his torso, lacerating vessels to his heart, causing massive internal bleeding. Colin died within minutes after the defendant shot him. Now, before this night, none of these victims knew the defendant, never associated with him, didn't know him to like him or dislike him. But that night, to the victims, the defendant was an assassin emerging from the darkness, and they had no chance to protect themselves before the defendant unloaded 10 rounds from his gun and changed their lives forever. All this because the defendant wanted payback. Now, ladies and gentlemen, during this trial, you will learn that what the defendant did was not an accident. It was not self-defense. This was aggravated assault, and it was premeditated murder. Now, earlier that night, the defendant and 3 of his friends decided to go to a party off campus, off NAU campus, Northern Arizona University. And the defendant's 3 friends that night were Shay McConnell, Jacob Mike, and Hunter Todd. All of them were freshmen at NAU, all of them newly pledged members of the Sigma Chi fraternity. Now, the defendant was driving that night, and he and his friends to this location. This is a 2-scale diagram, you'll see this during trial, of the parking lot where the defendant parked his car and ultimately the area where the defendant shot the 4 victims in this case. The defendant parked his car here, and then he and his friends walked across the parking lot and up Franklin Avenue toward an area called the Grove, where the party was at. Now, at the Grove, like many college parties across America, there was alcohol, and some of them had some drinks, but nothing excessive. And at around 1 a.m., the defendant's 3 friends walked back down Franklin Avenue the same way they had come, across this area near the courtyard. Now, the courtyard was a location that right across the street from Mountain View Dorm, just off NAU campus. And at around that time, there was another party, a separate party occurring at the courtyard. Now, the courtyard housed a number of members of the Delta Chi fraternity as well as the Sigma Chi fraternity, the same fraternity the defendant and his friends had recently pledged to. Now, the courtyard also housed 2 of the victims in this case, Colin Brew and Nick Peering. Well, at this party at the courtyard, just like the party the defendant attended, there was alcohol. And you'll hear that the victims in this case all had quite a few drinks that night. You'll also hear that none of them were in a particularly bad mood that night. In fact, the party was pretty uneventful. At around 1 a.m. that morning on October 9th, this party was winding down. People were leaving the party or were just about to leave. It was at that point that the defendant and his 3 friends were nearing the courtyard area, coming down Franklin Avenue. And one of the defendant's friends, Hunter Todd, decided to leave the group and go into the courtyard to visit some friends. Now, he didn't tell the others exactly where he was going, and so the defendant, Shane McConnell, Jacob Mike, his 2 other friends, stayed outside of the courtyard area on Franklin Avenue, tried to get a hold of Hunter, didn't know exactly where he'd gone. And as they waited outside that area, Jacob Mike, one of the defendant's friends, had an idea that he thought would be funny, which was to go knock on the door to one of the houses in this courtyard complex and then to leave. Doorbell ditch. Nothing sinister, just a little prank. And so he did. He knocked on the door to one of these houses, and then he and the defendant and Shane McConnell, the other friend, started walking across the street. At this point, the door to that house opened, and a group or a handful of college students came out into the street, and they confronted the defendant and his 2 friends, asked them what they were doing there. Now, it didn't appear that either group knew each other, but as sometimes happens with young men, especially when alcohol is involved, tempers began to flare. And there were some words exchanged and chest puffing in the street. And pretty soon these 2 groups were squared off in the road in this approximate area, and it looked like a fight might break out. At this point, one of the partygoers from the courtyard area ran up and punched the defendant in the face. Now, you'll hear during trial that there was only one person that punched anybody in the face that night, and it was Austin Contreras, who is not one of the victims in this case. Now, it's unclear why Austin decided to do that, but he did, and after he punched the defendant in the face, he ran off from that area, had no further interaction with that confrontation. Now, it's important to understand that at this point, of the 4 victims, the defendant Now, meanwhile, this group in the street migrated onto the sidewalk that separated Mountain View Dorm from this parking lot area. And the words were going back and forth. But they weren't overly aggressive. In fact, the words being exchanged were words to the effect of, "Get out of here," mixed with some profanity. Nobody was punching anybody, kicking anyone. There was nobody surrounded. People in Mountain View Dorm actually were now watching this interaction. They could hear the argument happening. And they'll also testify in this case that they didn't see any physical interaction. It was merely a verbal argument. The dynamic of that situation was about to change drastically when the defendant got to his car. You'll see this photo during trial. This is the defendant's car, parked in that same stall indicated in the diagram before. When the defendant got to his car, he didn't stay there. He didn't drive away. He reached into his glove box and he pulled out his handgun. You'll see this as well. This is the defendant's handgun retrieved at the scene, .40 caliber. It had a magazine extender on it, which meant he could shoot up to 17 rounds. It had a light attached to it that you can see here, which allowed him to shoot in the dark. The other advantage this light gave him was that it would blind his targets. The defendant chambered around, racked that gun, turned on that light attached to his gun. He was armed for battle. But it was a battle only he knew about. You see, while he was in his car, there was nobody around. He was alone. He was a man on an island. And while he was in his car, there was no threat to his safety. In fact, with that gun in his hand, he was the most deadly person in sight. Well, the defendant decided at that point that he was not going to stay in his car. He was going to walk across that parking lot. And it's hard to see in this photograph because it was taken at night. But you see the defendant's car in the foreground, and you see lights on a building in the background. Those are lights on Mountain View Dorm. He walked across this dark parking lot approximately 90 feet toward the corner where this group was arguing. Again, having a verbal argument. Colin Brew was in that approximate location on the sidewalk. He was not fighting anybody, not punching anyone. He had no weapons. In fact, nobody out there that night had any weapons except the defendant. Now, people could see the defendant approaching from the dark parking lot because of that light, and they thought somebody with a flashlight. Or maybe it was a police officer, or maybe a security guard. Nobody thought it was a gun. In fact, the defendant's own friends, Shane McConnell, Jacob Mike, will tell you, at no point did they believe that they were in a life or death situation. They did not expect a gun to show up. And yet the defendant approached. And nobody else knew what was coming. Again, Colin was in that approximate area. As the defendant approached, some people heard him say, the defendant, say something, although it's unclear what he said. One person heard, "Get on the ground," another, "Stop." Some nearby didn't hear anything at all. Nothing about a gun. Whatever the defendant may have said, Colin Brew then turned toward the defendant. And it wasn't 1 or 2 seconds later before the defendant shot Colin Brew with his weapon from just a few feet away. 2 shots in quick succession, a tactic known as a double tap. One bullet bored through Colin's chest, through his lung, through vessels to his heart, lodging into his spine. The other bullet bored through his shoulder near his neck, tore through a couple of his ribs. Colin fell face forward into some rocks that separated this parking lot from the sidewalk area. And he didn't get up after that. Now, these bullets entered Colin's body at a downward angle or trajectory, suggesting that Colin was leaning forward or falling when the defendant shot him. You'll see photos of this area. You'll see that this rock section where Colin fell slopes downward from the sidewalk down to the parking lot where the defendant was standing. One witness described Colin as lunging toward the defendant, although he later clarified that it was simply a step forward. Others described Colin as walking or taking a step forward with his hands at his sides. Everybody agreed that Colin was unarmed, that he had nothing in his hands, and that he said nothing aggressive to the defendant before the defendant shot him down. Now, in the moments before, one of Colin's friends and his roommate, Nick Peering, was approaching from the direction of the party, up that sidewalk, He could hear Colin's voice. He didn't know exactly what was going on, but as he approached, he could see this light. Again, this light attached to the defendant's gun. But he didn't know it was a gun, just like many in the area. All he saw was a light. And as he approached Colin and the defendant, he saw the defendant shoot his friend, and he saw Colin fall to the ground. At this point, Nick Peering was a few feet away from Colin, and he jumped over a small hedge or bush that separated the sidewalk from the rock area. And as he jumped over that hedge, the defendant turned on him as well. Shot him twice, double tap, just like he'd shot Colin. One bullet went through Nick Peering's arm, through his hip. Nick Peering stumbled forward. He fell onto the pavement just a few feet away from where his friend, Colin, was dying. Now, Nick Peering will tell you that he was trying to get to his friend, his roommate, his buddy who he'd seen fall to the ground. But he didn't make it. He lay there in extreme pain, unable to move. Now, at this point, people in the area were shocked, and they were horrified. Nobody expected this. Nobody expected there to be a gun at what wasn't even a fist fight, but merely a verbal argument. Some ran to Colin's aid to try to help him. One of the friends that came to Colin's aid was Nick Acevedo. Nick took Colin's head and he propped it up on his leg, and he put his hand on Colin's shirt where his wound was. He could see the blood soaking into his shirt. And as he cradled his friend, he could see the defendant in front of him still clutching onto that gun. And he asked the defendant, why? Why did you do this? And the defendant said, I don't know. I don't know. Others went to help Nick Peering, who was in the area also injured, unable to move. He was alert, responsive. And people who had seen what had happened were now trying to figure out how they were going to get the gun away from this shooter. They had seen what he was capable of. They did not want him to shoot anybody else. People in the area, in fact, asked the defendant to put the gun down, but he refused. Now, the defendant's two friends, Shane McConnell and Jacob Mike, were there, and they saw what happened. And they'll testify in this case. And they'll tell you how in shock they were when they saw what the defendant had done. Shane McConnell will tell you that he kept wondering why the defendant brought a gun, that maybe he was on some type of rampage, that he had lost his mind. Shane McConnell decided to run away from that scene, not from the group they had confronted earlier, but from his friend, the defendant. Jacob Mike was also in shock. He saw the defendant shoot Colin Brew, shoot Nick Peering, and then the light of that gun swung over and it rested on him, and he put his hands up and he said, don't shoot. He didn't know what was going to happen. Jacob Mike will tell you that the only reason he was actually in that area was not because he was surrounded or because he was in danger, but because he was trying to get his hat that fell off his head. And then the defendant approached with this gun. Now, the people in the area who were now seeing the defendant with this gun, they were trying to figure out how to get this gun away. At one point, you'll hear that the defendant, after he shot Colin Brew and Nick Peering, he stopped and he froze. And then he crouched down and he looked at Colin's injuries, the damage that he had caused, and he put the gun in the back of his pants, tucked back there. And people in the area were thinking this is their chance to try to get this gun away from the shooter. And a couple ran up to the defendant, tried to get for the gun. The defendant was too quick. He got his hand back on the gun, and he pulled it out a second time as people scattered. And then the defendant shot off several more rounds. Witnesses in this case will talk about hearing two sets of gunshots. The first set of gunshots coincides with when the defendant shot Colin Brew and Nick Peering. The second set of gunshots coincides with when the defendant brought this gun out a second time. Now, in the moments before the defendant was pushed to the ground. Nick Prado, one of the victims in this case, was near Colin, attending to him, and he had the thought that he should get a good look at this person, at this shooter, so he could identify him to the police. And so he made a conscious effort to do so. He stood up and he took a couple steps forward and he looked down at the defendant, who was now on the ground reaching for his gun, and he saw the defendant look back at him. And he saw the defendant reach the gun out from behind him, pull it out, take aim at Nick Prado, and fire. Nick Prado heard the gunshot, felt the hit to his neck. He immediately grabbed onto it. He ran away from the area, back toward the courtyard to try to find help. Blood was coming out of his neck. He was getting dizzy. He was in shock. He managed to get back, found some help. People helped put pressure on his wound until the paramedics arrived. Now, after the defendant shot Nick Prado, you'll hear that he didn't stop shooting. He also shot the other victim in this case, Kyle Zentek. Now, Kyle was in the area when Colin and Nick Peering were shot. He doesn't have a great memory, though, about this night because of the extreme trauma that he experienced. You see, Kyle, when he was in that area, he was trying to get to Colin's body to see if he could help his friend. He recalls that the defendant brought the gun out the second time, shot Nick Prado, and then the light of that gun rested on Kyle. And he remembers distinctly that it wasn't sweeping past him, that it was directed at him. And Kyle knew that this was bad. And he turned to run away, and as he turned to run away, the defendant shot him twice in the back. Kyle kept on running as far as he could. He made it partway down the sidewalk before collapsing in extreme pain. Kyle doesn't remember the paramedics arriving. He doesn't remember the rush to the hospital or the emergency surgery that he had that night. At this point, the defendant walked away from the carnage to a nearby tree. A witness from Mountain View Dorm had come out at that point, and he hadn't seen the shooting from earlier, but he could see people on the ground. He could see the defendant hiding the gun behind his back like this, and he was putting two and two together. And he asked the defendant to put the gun down, that he'd keep it safe. At this point, officers were on their way. Sirens could be heard in the air. And after the defendant shooted 4 unarmed kids, and without any options, he put the gun down, and he walked away from that scene. Police converged on the area. One of the first officers to arrive was Officer Park from NAUPD. He found the defendant walking toward him, hands up in the air, identified himself as the shooter. Officer Park put him in handcuffs. He put him in the back of his patrol car so he could attend to the wounded. You see, when the police arrived, they didn't have much information. They had information that there was an active shooter on campus, but they didn't know who was wounded or how many. And when they got there, it was a battle scene. Nick Prado was lying on a kitchen floor, clutching his neck. Kyle Zentek was writhing in pain on a sidewalk. Nick Peering was on his back, unable to move. Colin Brew was motionless on the rocks. The police tried doing CPR on Colin, but by the time the paramedics arrived, there was just nothing anybody could do. Colin died in the rocks, right where the defendant shot him. Now, Nick Peering, Nick Prado, Kyle Zentek were rushed to the hospital. Of the 3 of them, Kyle had the worst injuries. One of the bullets the defendant shot into his back pierced his bowel and also one of his kidneys. And he was sent to emergency surgery that night. Doctors actually had to remove one of his kidneys to save his life. And he spent several days in the hospital afterwards recovering. In fact, the first interview he ever did in this case was in a hospital room while he was hooked to machines. Nick Peering fared a little better. He was shot twice as well, but one bullet went through his arm, the other through his hip, missing vital organs. He did suffer a fracture to his pelvic area. but he was able to walk after a couple of days. Nick Prado was lucky. He was shot through his neck, through and through, centimeter or two away from his jugular, from his carotid artery, which if hit at the scene almost certainly would have killed him. Now, while the victims were being attended to at the hospital, the police were putting the pieces together. They were talking to people who were there, who saw what the defendant did. They were photographing the evidence, the blood at the scene. And one of the things they did, you'll hear about during this case, was they took a digital scan of the area, which allowed them to take precise measurements. And because of that, we know that the defendant traveled approximately 150 feet from the point he was punched in the face to get to his car, to get to his gun. And then he had to travel another 90 feet to get to the point where he shot the 4 victims in this case. A grand total of 240 plus feet to get his gun and come back to shoot these victims. Now, while the defendant was placed in the back of that patrol car and he was sitting there, the officers were attending to the victims in the case, there was one officer, a deputy with the sheriff's office, who was standing guard. And he had a digital recorder going in his pocket, and he had a conversation with the defendant to try to figure out if there were any additional shooters. You see, they didn't know exactly what had happened, so they were asking questions. And he asked the defendant if he was the only one. The defendant said yes. He tried to clarify, "You're the only one?" At that point, the defendant made this admission: "Nobody else did anything wrong but me." Colin Brew's body was eventually taken from the scene. He was taken to the medical examiner's office for an autopsy. And the medical examiner found the 2 bullets that killed him. One bullet lodged in his spine, the other still in his back after busting through his ribs. The medical examiner also removed approximately 2 quarts of blood from Colin's chest cavity, evidence of the internal bleeding he suffered after he was shot. What the medical examiner did not find, however, was anything on Colin's hands, suggesting that he was reaching for the defendant. No defensive wounds, no burnt or unburnt gunpowder, consistent with the witness accounts that Colin had his hands at his sides when the defendant shot him. Colin Brew was 20 years old when the defendant killed him. He was a junior at NAU, excelling at school. By any account, he had a bright future ahead of him. He was just making his decisions. He was 20 years old. His whole life was ahead of him. And the defendant, Stephen Jones, ended all of that in seconds because he wanted to retaliate, because he was punched one time in the face. Ladies and gentlemen, during this trial, you will hear from approximately 35 witnesses. It's going to take some time. Many of these witnesses were there at the scene, saw the defendant's actions. But this is not going to be like a movie where you get all the information at once for easy consumption. You're going to get this information from one witness at a time and from different perspectives. People who were being attacked by the defendant, people who were running away or watching from the sidelines. And because of that, you'll be getting the information in pieces. But as the trial progresses, these pieces will begin to fit together, and they will form a picture of murder and of an unjustified shooting. This case is not a whodunit. There's no mystery to who killed Colin Brew, who shot Nick Peering, Nick Prado, or Kyle Zenteg. The defendant did. The question for you during this trial will be, what was the defendant's intent when he shot these 4 unarmed victims? And that's a question you will only be able to answer based on the evidence, based on the testimony you get from this witness stand. As we've talked about and as the judge instructed you, it cannot be based on sympathy. It cannot be based on prejudice, one side or the other. It must be based on the evidence. Now, you've received some instructions already. You haven't received all of them. You'll get more at the end of the trial. But these are the instructions that you have to follow that will give you guidance in the law. And one of the instructions you got today was about premeditation, about what that means, how it's a moment of reflection before killing someone. And it tells you that moment of reflection can be very short. And that may be different than what some of us have heard about premeditation. And that's why it's so important to keep an open mind during this process, during trial. Wait till you hear all the evidence, and wait till you get all the jury instructions in this case before making up your mind. Now, after I sit down, the defense may give an opening statement. They don't have to, but they may. And if they do, they may talk about things I haven't talked about, things that may even seem important. But rest assured that at the end of this case, the state will have an opportunity to talk to you about all the evidence you've heard. Evidence that will include the testimony of the 3 surviving victims in this case: Nick Peering, Nick Prado, Kyle Zentek. You'll hear their firsthand accounts of how the defendant attacked them unprovoked. Evidence that will include the testimony of witnesses in the Mountain View dorm, independent witnesses who saw the defendant shoot on an unsuspecting group. And evidence of the time and the travel it took the defendant to get to his car, to his gun, and then to go another 90 feet to shoot the victims in this case. Now, what the defendant, or what that initial confrontation was juvenile. It was uncalled for, that confrontation in the street. There's no doubt. And sucker punching anybody in the face is just wrong. But none of those kids deserve to get shot. And Stephen Jones does not get to decide who lives and who dies.
Objection, Your Honor. Counsel's arguing. This is opening statements.
Sustained. Jury will discard.
At the end of this case, the state will ask you to hold him accountable for what he's done. For the murder of Colin Brew, and for the shooting of Nick Peering, Nick Prado, and Kyle Zentek, and find him guilty on all charges. Thank you.
Mr. Davidson.
Thank you so much. You're welcome.
One of the instructions that you've already been given by Judge Slayton is an instruction that what the attorneys say is not evidence. And while Mr. Barker tells a very good story, it's still not evidence. The only testimony, the only evidence that you're to consider in deciding what happened on October 9th of 2015 is from people who sit in that chair and are cross-examined by both sides. And you'll have a chance to assess their demeanor while testifying. You'll have a chance to assess any prior inconsistent statements they say. You'll have a chance to assess how their testimony lines up with physical evidence from this case. When you hear this case, you will find that this is not a case about an assassin emerging from the dark on a rampage. It's not even close. This is a case about an 18-year-old kid who was just a couple weeks into his college career, a freshman at NAU. And he found himself in a situation where he was surrounded, bullied, threatened, and attacked, and did what he had to do to protect himself. And he didn't have the luxury of hours or even minutes to make this decision. He had seconds. Mr. Jones was at a party with 4 of his friends: Hunter Thomas, Jacob Mike, Shay McConnell. The group of 4 were returning down Franklin towards the parking lot where Mr. Jones's Mustang was parked. There may have been alcohol served at the party. What Mr. Barker doesn't tell you is that Mr. Jones apparently didn't have any, because after he was arrested, they took his blood and tested it for drugs and alcohol. He didn't have a drop of alcohol or any drugs at all in his system. As they approach this apartment, the courtyard as it's sometimes called on Franklin, where these other individuals were having their party, it occurs to Jacob and to Shay and to Stephen that Hunter's whereabouts are unaccounted for. So they decide to stop and try to call him. As they're attempting to call Hunter and see where their friend is, because they're almost at Stephen's car at this point, a group of individuals comes out of the courtyard. It's not a square off. It's not a friendly discussion. It's not a, hey, what are you doing? It's a, go back to your freshman dorm, you faggot freshman. It's getting in your faces. It's get the fuck out of here. It's people who Stephen perceived to be, quite accurately based on subsequent toxicology, to be very drunk, stating, I'll kill you, you fucking pussy. Now, I don't relish having to repeat these words. Stephen certainly didn't relish having to hear those words by people who were surrounding him and his friends. But this is what he faced. This is what he faced after simply pausing on a sidewalk in front of a house to use his phone to call his friend. And then out of nowhere, through no provocation whatsoever by Stephen, what the prosecutor characterizes as a childish and juvenile act, Stephen is sucker punched out of the clear blue sky, hard enough that his glasses are knocked off his face. Stephen doesn't see well. He requires glasses. This isn't a very well-lit area to begin with. Stephen heads to his car, which is across the street on Franklin. He looks back and he sees at least two individuals from the group that surrounded him and his friends that are chasing him. He's still worried about his safety. It's a young man who's just been surrounded, threatened verbally, punched. It's dark, he can't see well, and now there's people chasing him to his car. His Mustang's parked in the parking lot. Stephen has a key fob, sort of a wireless remote to unlock the door, and then a separate traditional key that's turned in the ignition to start the car. They're separated. Stephen is able to recover the key fob as he approaches his car from the passenger side, and he unlocks the door. Pulls the door open, opens the glove box, and he recovers his pistol. As he recovers his pistol and he turns to announce that he has a gun, because to his knowledge, these people, at least through his limited vision, through no fault of his own, are chasing him, he sees that their attention is again drawn to him as a result of him making that announcement, and they come towards him again. Stephen is aware that his friends Shay and Jacob are still somewhere in this group with these people who are less than friendly. And he walks over and approaches this group. Yes, it was 90 feet. But what the prosecutor didn't tell you is that this cold-hearted assassin who was on a rampage this night did not approach his friends who were being surrounded and fire shots. He did not approach his friends who were being surrounded and even have the gun pointed, leveled off at them. He held the gun pointed at the ground in what's sometimes referred to as a low-ready position. He approaches his friends, and there's Mr. Brew. Mr. Jones is holding the gun, not pointed at anybody, he's pointed at the ground. Announces he has the gun. He's just trying to protect himself. He's not shooting anybody at this point. He says, get out of here, leave, stop, get the fuck out of here, words to that effect. And in response to that, what does Mr. Brew do? He turns and he lunges at Mr. Jones. And it was in that very moment that Mr. Jones leveled up his pistol and fired those shots at Mr. Brew. And we know that Mr. Brew was no more than 2 feet away from Mr. Jones at the time that happened. And that's based on the prosecution's own medical exam, because one of the 2 wounds that struck Mr. Brew had what's called stippling around it, indicating that it was anywhere from inches to a couple feet from the end of the muzzle of the gun. At that very moment, as Mr. Brew lunges towards Mr. Jones, Mr. Brew's roommate, Nick Peering, is running from up behind Mr. Brew. Mr. Peering later told the police that he was running towards Mr. Brew primarily because he wanted to calm him down, not calm
Mr. Jones down, but calm his roommate, Mr. Brew, down. And in essentially that same moment, when Mr. Brew lunges at Stephen and Stephen lifts up his pistol, Mr. Peering comes up behind Mr. Brew in the same direction towards Stephen and jumps up from this elevated position. Mr. Brew and Mr. Peering are up here. Mr. Jones is down here. From this elevated position, Mr. Peering jumps up over this bush that's separating him and Mr. Brew. And then in that moment, after firing those shots at Mr. Brew, Stephen sees that there's the second subject who's also jumping at him from an elevated position and fires shots at him as well. Now, there's other people around. There's no question that there's people from the party across the street who are still there and who are associated with this group who started this confrontation. And what does this homicidal assassin on a rampage do? He tucks his gun into the small of his back. He kneels down and he attempts to offer aid to Mr. Brew. As he's down there trying to render assistance to Mr. Brew, a group of people essentially pummel him and doggy pile him. And they're punching him and they're kicking him and they're trying to grab his gun, and again they're threatening him, "We're going to kill you, we're going to kill you." And it was in that moment when Stephen's underneath this doggy pile, again being threatened, this time people trying to wrestle his gun away from him. He's screaming, "Help, help, help," repeatedly. In fear of his life, he fires multiple shots up in the air with the intent only of dispersing this group of people who are trying to take his gun and cause him harm. In the course of doing that, the evidence will show that Mr. Prado and Mr. Zintek were shot at that point as well. Now, after a resident of the nearby dormitory who had heard a commotion, didn't see anything, but he came down at this point, a gentleman by the name of Chase Jones, he walks up and he approaches Mr. Jones and basically tells him, "Hey, it's safe, you're okay." What does our rogue assassin do? He puts the gun down. Puts the gun down, I would note, having not fired all of those 17 rounds that Mr. Barker made a point to tell you that his pistol was capable of holding at one time. He put it down and he waited and he cooperated and he voluntarily turned himself into the police in a very peaceful and cooperative manner. Now, the state wants you to believe that that is reflective of a cold-blooded killer who premeditated his crime. That's for you to decide. And you're going to make that decision based on the evidence that's presented in court, right? And no doubt there were lots of people there. And no doubt there were people, fellow students, who saw this unfold from different perspectives, both physically and perhaps psychologically. And we're going to hear from them. And there's going to be some disagreement about the finer points of what happened. And it's going to be part of your job to sift through that and decide what the state has proven and what they haven't. But there are things you'll find that are going to be undeniable and are not going to be the subject of dispute. In addition to Mr. Jones having no alcohol and no drugs in his system, you're going to hear that Mr. Brew had a blood alcohol concentration of 0.285%, approximately 3.5 times over the legal limit. The medical examiner also found THC, tablet of marijuana, and Xanax in his system. You're going to hear from a defense expert named Dr. French, who's a professor of pharmacology down at U of A, and he's going to talk to you about the potential interplay between alcohol and sedatives, such as the Xanax that Mr. Brew had apparently taken prior to that incident. Mr. Peering also had quite a bit to drink that evening. His BAC was 0.208, just over 2.5 times the legal limit. Mr. Prado, Mr. Zintek were also over the legal limit. Mr. Zintek, I believe, was a 0.092. Mr. Zintek was a 0.181, over twice the legal limit. and Mr. Prado was a .092. 4 individuals who had quite a bit to drink. There's not going to be a whole lot of dispute that this was a very dark area where this took place. There's not going to be any dispute that Stephen had his glasses knocked off his face when he was sucker punched, because his glasses were recovered by Franklin Street, north of the parking lot. There's not going to be any dispute that Mr. Brew was indeed lunging at Mr. Jones at that critical moment when Stephen had to make that split-second decision on what he was going to do to protect himself. And the reason that we don't have to wonder about that is from the prosecution's own expert witness, the medical examiner. The examination that was done by the medical examiner showed that Mr. Brew had an entrance wound by the 4th rib, which is essentially by the nipple area of his chest, and that bullet came to rest in the 11th thoracic vertebra, which is essentially his lower back. So you have a situation where the bullet goes in by his chest, it gets lodged in his back. It's pretty hard to explain that away without having Mr. Brew leaning at a very aggressive, particularly given the fact that he's in an elevated position towards Mr. Brew, towards Stephen at that very moment when shots are fired. There's not going to be any dispute that the presence of stippling on by Mr. Brew's wounds means that he was no more than 2 feet away from the end of Mr. Jones' gun, if not closer. There's not going to be any dispute that Stephen suffered injuries as a result of this incident, whether it was from being sucker punched up by the courtyard or being pummeled down by the parking lot. The officers who had contact with him right after he was taken into custody noticed that he had injuries to his neck, to his head, to his back, to his chest, to his arms, and to his knees. The officer also noted that Stephen had a swollen wrist. Again, all corroborating that Stephen was attacked and he was pummeled, and that it was under those circumstances that he, in that split second, made the decision to do what he had to do to protect himself. You're going to receive additional instructions from the jury, from the court, before you go back and you deliberate, and there's going to be several days of testimony between now and then. And one of the instructions, or several of the instructions that we anticipate you're going to receive, is an instruction called justification, self-defense, and other justifications that provide circumstances under which a person can use lethal physical force. And the burden of proof at no point in this trial will shift from that table to this table. It will be the burden of proof on the prosecution to not only establish that Stephen committed a crime, but also to exclude that his crime, alleged crime, was not justified as a matter of self-defense or through some other recognized legal justification. So you won't get the exact instructions on what constitutes self-defense and justification until later on, but I'd ask you to keep that in the back of your mind, at least as it relates to where the burden of proof for that is as this trial progresses. There's things that will be unclear. There's things that we'll have to see how the evidence plays out as to those finer points. There's things that we know for certain. I talked about them. The wound path, the toxicology results. There's things that we're equally confident that you'll know for sure when this trial is over, and that is that this was not a case of murder. It certainly was not a case of premeditation. This was a case of a young man doing what he had to do to defend himself. And for that reason, we will ask you to return verdicts of not guilty on all 7 counts. Thank you.
Thank you, Mr. Davidson. All right, members of our jury, we're going to go ahead and recess for the night. Please get a good night's sleep. We'll begin at 8:30 tomorrow morning with the beginning, the presentation of the evidence and testimony in this case. So until then, please remember the admonition. We stand at recess till tomorrow.
Welcome back to the Law News Network, everybody. I'm Aaron Keller, and we just listened to the opening statements in the Stephen Jones case out of Arizona. He's accused of shooting 4 people, killing one of them, after a verbal fight turned into a sucker punch, which then turned into the defendant going to his car, getting a gun, and then shooting 4 people, killing one of them just outside of a college campus in Arizona. We will continue to carry this case live here on the Law News Network, and we are also continuing to cover the Aaron Hernandez double murder trial out of Boston. We are expecting to hear the closing arguments in that case starting tomorrow morning. We broadcast every day, Monday through Friday, here on the Law News Network between 9 a.m. and 5 p.m. But this particular time, we're going to be broadcasting much later, as we are tonight, to carry this trial out of Arizona, which of course is being done in West Coast time. We are carrying that case every day that it is in session, but we are hearing that they will not have testimony or court on Mondays. So the Jones trial will run Tuesday through Friday. We will see you tomorrow morning on the Law News Network. So for everyone here at LawNewz.com, this is Aaron Keller. Have a good evening, everyone.